This is when she had culture. All right. And so she's going to the doctor one day. Now we know that she, was pregnant with culture. At the time, she was trying to keep it. I'm multitasking real quick. Give me a second. I'm doing something. I'm talking while I'm doing it though, because I'm in other places, if you know what I mean. But we can't tell here, okay? But you know. So hold on. So Cardi B was going to the doctor's office, right? Hold on. Just let me do this for a minute. If I don't concentrate, if I keep talking while I'm doing it, I'm gonna mess up. Okay, there we go. All right, so she's going to the doctor, and it's the security guard, right? So there's this security guard, right? So the security guard is on the phone at first, and she's going, "Oh my God, it's Cardi B! It's Cardi B! Look, it's Cardi B!" And then Cardi B is here. She's going, "Cardi B is here." Right? And then she, Cardi B notices her, and then she notices that she brings her phone from here down to here. Right? So she has the phone down here near her chest. So Cardi B goes, "Well, what are you doing?" And then she goes, "Oh, I'm, hold on, I got to plugify my phone in before it goes deadify. So Cardi B goes, she says, "Are you filming me?" And then she goes, "My bad." Now this is what Cardi B said. So Cardi B said, she says, "That's my bad." Right? And to me, that was a key fact indicator in her testimony in the trial also, because that's an admittance that you did something wrong. If you say, "Oh, my bad," that means you did something wrong. What's up, the real Kiana? What's up now? Hey, let me see the whole name so I can say it. What's up, Kia? The real Kia. Hey. So, Cardi said, what you doing? And then, "Are you filming me?" She said, "My bad." And then it escalated into an argument, which carried on in the area where she was going to the doctor, right? And they got into this verbal argument, right? Now, we're going to flip to her side. And then with her side, her name is Ammani Ellis. She says that Cardi B scratched her with her fingernails. Now, first when she wrote her boss in the incident report, because when you have an accident, right, they take an incident report. So you fill out the incident report for your job, right? Your job asks you, well, what happened? What happened when Cardi B came to the complex? Why, what happened? Why did you get into an argument? So she explained that whole thing. But in her explanation, she says that Cardi B scratched her on her nose at first. And they brought that up in court. They said, you said that Cardi B scratched your nose at first, right? And then in court, it turned into she got a scratch on her cheek, right? But yes, she has no footage from a right. She has no footage from her phone. I don't know whether did she say she threw the phone out? Did she say, I don't know what happened to the phone? What happened to the phone? So the phone is gone, the pictures are gone, receipts are gone. She has this scaly picture from the doctor's office. It's real scaly, meaning that I looked at it when they put it up. I didn't see anything. And we'll go through after the closing arguments. We might not get to it today, but tomorrow we'll go through the whole trial again, because it's going to take them a day to deliberate. So I feel that's a good time for me to go through the whole trial, right? So, because everybody didn't get to see and hear it. So we'll do the closing arguments today. We'll do the backstory and all of that. Waiting for them to come on. It's going to start at 12:45, everybody. So everybody share it with your friends. Okay? Hold on, I gotta tell my mods I'm live. I wanted to get on here. I wanted to get in. So hold on. I forgot to message my mods. All right. So tomorrow, we won't get to it today because the closing arguments, I don't know how long it's gonna last. You know what I'm saying? The closing arguments might last for a while. So we'll probably get to going over the case and hashing and going through. I have the whole trial. I have the whole audio, the whole trial of everybody's testimony, and we'll go through that tomorrow while they're deliberating. She needs to go sit down. She's reaching for the stars, right? Thank you, Gina, for that. Yeah, she is reaching for the stars. You know what I'm saying? Who feels, put a yes or no in the comments. Because I don't know, I was thinking about this. Who feels like this is the era of the money grab? Everybody's sitting around waiting for that light bulb moment, right? These celebrities better watch out. You celebrities out there, you better watch out, right? And if you are rich or becoming rich, you better move a certain way. You better watch how you talk with people. You better watch how you interact with people. Because Cardi B is kind of spicy. Everybody's saying, yep, Cardi B is kind of spicy. So she's going to come back on people. But I believe Cardi B when she says that she didn't touch her. And Cardi B says that she didn't touch her because she's pregnant. She said, I'm pregnant. She said, I didn't touch her. I didn't put a hand on that girl. She did say that they were chest to chest at one moment. She did say that. Right? But Cardi B said, I'm messaging my people right real quick, y'all. But Cardi B says that, I cannot get this other number in here. I don't know why. But Cardi B says she didn't hit her because she was pregos with Culture. So we know was pregos with Culture now. We didn't know she was pregos with Culture then, but we know she's pregos with Culture now. You know what I'm saying? But Cardi B, I believe she was going back and forth with her. She was spicy, calling all kinds of B's, and that's why you work security and all of that. That's like, something that she would say because she's real spicy, animated. But I don't believe Cardi B hit her, allegedly. Just my opinion from watching the whole testimony. And I don't believe Cardi B cut her with her fingernail. Now, the girl also had, right? She also had, I could never find this number. Why can I never find this number? Wait, hold on. She also had a car accident, right? She also had a car accident. I don't know why I could never find this second number in here. I could find it on my phone. It's strange. I could find it on my phone, but I can't find it in here. You know what I'm saying? So, and then if I go on my phone, hold on. So, let's see. Hold on, y'all. So, I don't believe that she cut her with her nail. I believe she was spicy. I believe she was going back and forth. Did you try Google? No, it's okay. I'll figure it out after I get off. I can't figure it out now because I'm in the middle of my broadcast. But I want to message a certain mod, but on my computer I could never see the other number she got. But on my phone I could see it, but then I gotta pause y'all and do it. And then people just start, they leave. For some reason, when you pause, people just leave. We live in a very impatient society. They have no patience. Oh, she's paused. Let me go, stick my thumb up my behind. You know what I'm saying? So, let's get back to it. So, now what I want to get into now, we have about a good, almost an hour, right? Michelle laughing. Yes, everybody wants instant. Yeah, they want instant. It's like I'm not your puppet. They want instant. So I go and message her, and then boom. You know, let me see. We got 140 people in here. Watch this. Watch this. Hey, I'm on live only if you're available and around. See, I found it right away on my phone. But it doesn't appear on my computer. I don't know why. I'll figure it out later. Anyway, let's get back to the situation at hand. Well, we actually got 2 more people, see? Oh, we lost a couple of people. Spoke to some. Right? So, let's get into the testimony. Now, we didn't go over this testimony. We're going to go backtrack for the people that didn't see any testimony, missed testimonies. All day tomorrow, we'll be going through the whole thing and until they reach a verdict. So they'll have the closing arguments today, right? And then the jury will go back and deliberate, right? And while they're deliberating, we'll go back through the whole trial and go through all these testimonies and pull everybody up to speed to what's going on, because everybody doesn't know what's going on. You know what I'm saying? Everybody didn't get a chance to hear the case. Okay? So, let's pull up this. Let's pull this up real quick. Hold on for a minute. Hold on. So I had it all ready to go. All right, hold on, y'all. I had this all ready to go.
She was cursing at me, though.
What were the words that she used?
Okay, so let's pull up this testimony of it's another doctor. I believe she's a I'm gonna let her tell it. It's a psychiatric. She's to do with not physical. Okay, hold on. Let's see. So I gotta bring this up. I had it all ready to go, y'all. And then now all of a sudden it's just disappeared. You know what I'm saying? Because I had to reboot my computer. Okay, so let's see. It's part of this. It's part of the... Okay, I believe it's part of this. Alright, so... Okay, so this is another doctor in the case. We're going to get into this. Alright? It's a very interesting part of the testimony.
When this was presented,
hold on, let's see. Let's see if they got labels up here.
Everybody was advised that it was on February 24th.
Okay, oh, here it is. Cardi B defendant, Tierra, witness, outside, President James Rosenberg,
I can put it on Elmo.
Thank you.
It was published on February 19th.
Dang, I had it, y'all. I had it and I lost it. Okay, so this is Tierra's case. So that's the receptionist. That's Cardi B. That's the receptionist. All right. I had everything lined up, y'all. And this, I had to close my computer. Okay, so let's get into it. So let's get into this doctor's account while we look for that.
Later is also equally beneficial.
So this is Dr. Rosen. This is very interesting, okay? So this is a psychiatrist. Why I find a lady that we haven't heard yet. Okay? I don't know why I can't. I had it all set up, y'all. So let's listen to the psychiatrist. This was very interesting, right? Because he actually counteracted what the girl was saying about Cardi B. Right? He actually counteracted it. So let's get into his testimony. He's a psychiatrist. His name is James E. Rosenberg, and he's an MD psychiatrist. All right? So let's get into it. Everybody share a fine. Saying word for what? Thank you, Michelle. Thank you so much for the blessification. Everybody blessified. Thank you so much. So Ms. Knockout won't be brokified.
Licensed medical doctor in California. I specialize in psychiatry.
Can you
please outline your professional education for us?
Now remember that he specializes in psychiatry. Remember that. Okay, let's listen.
Yes, I studied philosophy and molecular biology at UC Berkeley. I then did a year of surgery research at Cedars-Sinai Medical Center, including coronary laser angioplasty research. I attended medical school for 4 years at UCLA. I then did an internship in primarily specialties of surgery and cancer medicine, including neurosurgery and cardiothoracic surgery. I then did a 3-year residency at the UCLA Neuropsychiatric Institute in psychiatry, and I did a fellowship in forensic psychiatry at
So he's
Case
telling
Western
all
Reserve
his-
University in Cleveland
his,
with
his
Dr.
stats
Philip
and stuff.
Resnick.
Okay, and what licenses and board certifications do you hold?
So my license is to practice medicine in the state of California.
Going
I
to
have a
okay.
lifetime
I'll
board
be here.
certification in psychiatry. In 1996, I got my second board certification in forensic psychiatry, a subspecialty of psychiatry involving the legal system. That's every 10 years.
Thank
I renewed
you.
it for another
Hey,
10
Mr.
years
Meany.
until 2016.
Thank
and
you,
then due to
Mr.
a very
Meany and
bad
Mr.
experience I
Mrs.
had in
Meany.
a criminal case, my wife and I decided I wouldn't renew it again, and I would stop doing criminal work.
Okay, can you please briefly summarize your professional experience as a psychiatrist?
Thank you so much.
Yes,
Thank you, man.
After I completed my training and came back to my
Thank you
fellowship,
so much, man.
I became assistant director of psychiatry at the West Los Angeles VA Medical Center and ran the locked psychiatric intensive care unit at UCLA Teaching Service and was there for a few years. I was a member of the UCLA Medical School faculty for 16 years. After I left the VA, because my forensic consultation practice started to get busy, I always continued to see patients at least one day a week unrelated to any legal matter. Most recently, it was 22 years at a nonprofit community mental health clinic in Van Nuys, providing psychiatric evaluation treatment of homeless and low-income individuals. My
He's just
forensic
telling
psychiatry practice,
his credibilities
the first,
and his credits. He's going to get
half
into
of
it.
my career was primarily criminal cases, approximately 200 murders,
Everybody come on in, we'll
mass
listen to
murders,
Cardi B
serial
testimony.
criminals, and other types of major crimes. The second half has been primarily civil litigation matters of brain injuries, catastrophic physical injuries with PTSD claims, and employment-related matters. I've consulted over the years to the United States Attorney in Washington, D.C. on organized crime in the Eastern District of New York, the Medical Board, the Attorney General, and also for 8 years I was a consultant to the show Law and Order Special Victims Unit.
Oh, wow. He's a consultant. Did you hear what he said, y'all? He said that he was a consultant for Law and Order Special Unit. Wow. For the forensic part. Wow.
Honor, I
Hey,
would like to show
Lola.
Exhibit
Hey.
220 to the witness.
Thank you for the follow. Everybody come on in. Everybody tap a 5. Everybody share a 5. We're waiting for the closing arguments to start. In the meantime, we're going through certain testimonies in the Cardi B case. And this is a doctor. He's a psychiatrist. Okay,
Dr.
testimony.
Rosenberg, it's Exhibit 220 in the...
I don't realize what size he's on yet. I don't know. We'll see when he starts talking.
Okay, I'm at 220.
Are you familiar with this document?
Yes, this looks like the first page of my resume, curriculum vitae.
And can you please flip through it and let me know if that's a true, correct copy of your CV?
Yes, this is the most current version, last updated February 2023.
Thank you. Your Honor, defendant wants to admit...
So they
Exhibit
just showing
220
him the
minutes.
document from the case.
Thanks so much. Over.
Have you been retained as an expert on behalf of the defendant Cardi B in this case?
That's my understanding.
And what is it that you were asked to do?
I was asked to
Good
conduct a
afternoon,
psychiatric evaluation.
He's very
Ms.
accomplished.
Ellis's emotional injury
Also
claims
worked in a
related
forensic
to,
facility. Yes,
the
Christopher.
incident on February 24th, 2018.
Everybody bless her
Have you
five
served
this
as a
knockout so she
retained
won't be
expert
broke
in
a fire and
previous
bring you
cases?
some hot tea today.
Yes,
Because we can go straight into the closing arguments
criminal and
live
civil matters,
and in real
probably
time.
Over my
Okay?
career, maybe 1,500 times.
You're the first ones to get it. Thank you so much, everybody, coming in.
Experts are paid for their time.
Tapify, sharify.
What is your rate
Get your orange right.
that you charge for the time that you spend?
Now
working
listen
on
to this, y'all.
So I charge, my base rate is $550 an hour, which is for reviewing records, my face-to-face examination of Ms.
Let's all close our eyes for a minute and imagine making $500 an hour. Close your eyes, y'all, and just imagine it for a second. $500 an hour.
Ellis, scoring the psychological testing and writing a report.
Good morning, shorty.
My rate for testimony in deposition, which was taken in this case, or trial like today, is $800
I
an
get my
hour.
coffee.
And there's a four-hour
Hey, thank you,
block.
shorty. Everybody get your two qualifications.
Does your fee depend in any way on whether your opinion is favorable to Cardi B?
No,
Thank you,
that's never
Sheila.
been the case. And for example, I've never worked on the lien, which does involve that type of interest from my non-attorney standpoint.
Do you recall approximately how long you've been engaged on this matter?
I believe it's been
They
since
asked him basically, is he working for Cardi B? And he said, no, he's just here, you know, with his own biased opinion, right? Hold on, y'all, got to clean the lens off. His, you know, he has a very high credentials. He has a reputation to uphold, this guy. So I believe he's giving his honest opinion, and we're going to hear it. Thank you, Sheila. Thank you.
early 2023.
Okay, and how
so
much,
much.
have you charged in this matter over those 2.5 roughly years?
Well, for reviewing the records, which I've had to re-review, and additional records, examination, the psych testing, my report, preparing for deposition with plaintiff's counsel, I think I've thus far charged something a little over
Diddy's
$30,000.
sentencing is October 3rd. October 3rd.
Okay. And I believe you testified that you conducted a psychiatric evaluation of the plaintiff as part of your duties in this case. Is that correct?
Yes, so the psychiatric evaluation is, to me, a broader term that consists of the triad of reviewing records, conducting a face-to-face examination, and scoring and utilizing the psychological testing that was administered during that examination. So it's a matter of integrating and correlating and weighing the information from those three sources.
And can you please, in just a little more detail, explain what happened during that evaluation
I got a hater in my life. Oh yeah, I see it. I see it.
in this case?
Certainly.
I see it.
So I believe it was in July, maybe around July 21st, 2023. So it
Thank
took
you,
about,
thank you, CJ.
I would say roughly 6 hours.
It's always
The
one.
entire examination was audio recorded.
I'm gonna get
And
him.
the first half of the examination was the administration of the psychological testing, where using gold standard psychological tests, I provided them to Ms. Ellis. I was there with her the entire time. And made sure she understood the instructions, and then she filled out the answering sheets, circles or bubble and answer sheets, as she went along. The second half of the day was the interview.
I gotta figure out.
And
Tell me how to block. I don't know how they block.
This was
How to block.
generally
So it keeps. That's not me, y'all. That's the thing going in and out. That's not me. That's it going in and out.
sorry, it was either the MMPI 3 or the MMPI 2, the current ultimate gold standard tests. You have to pass.
See, that's them going in and out. Hold on.
That test, for example, to fly a passenger jet, to be in
So that's
Secret
their stream
Service.
going in and
Yeah.
out, yo. It's probably
Past
going to
that,
clear
or
up.
the other test I gave. For
Oh, yeah,
example,
that stream
to-
is fucking up. Hold on.
Okay, yes, I can
Okay, let's go
context.
Thank you. As part of your
Yeah, I got to figure out.
duties in this case, is that correct?
Yeah, but see, I'm in.
Yes, so the psychiatric
Wait.
evaluation is
Hold on for 1 minute, y'all. Hold on for 1 minute. Hold on. See, I'm broadcasting from prison. So in prison, everything is coming in the same chat line. So it doesn't have an option for me to block them. So now I got to search online to do it. I got to go in and do it directly. You know what I'm saying? I'm going to get them, CJ. I'm deleting the comments now. Okay, sorry
Term
about
that
that. I had
consists
to
of
tell
my-
somebody something.
the triad.
Okay,
of
hold on. Let's
the,
go back.
Incident on February 24th, 2018.
Have you served as a retained expert in previous cases?
Yes, both criminal and civil matters, probably over my career, maybe 1,500 times.
Experts are paid for their time. What is your rate?
Yeah, I'm getting it now. I
you
gotta
charge
go
for the
over
time that you
here and
spent
do it. I
working
gotta
on this
find it.
case?
So I charge, my base rate is $550 an hour, which is for reviewing records, my face-to-face examination of Ms. Ellis, scoring the psychological testing, and writing a report. My rate for testimony in
Listen to his
deposition,
rates.
which was taken in this case, or a trial like today, is $800 an hour, and there's a 4-hour blocks.
Does your fee depend in any way on whether your opinion is favorable to Cardi B?
No, that's never been the case. And for example, I've never worked on the lien, which does involve that type of interest from my non-attorney standpoint.
Do you recall approximately how long you've been engaged on this matter?
I believe it's been since early 2023.
Okay, and how much have you charged in this matter over those 2.5?
This is Cardi B
years?
case. Cardi B.
Well, for
Cardi B
reviewing
versus
records,
Ammani
which I've had
Ellis.
review and additional records, examination, the psych testing, my report, preparing for deposition with plaintiff's counsel. I think I've thus far charged something a little over $30,000.
Okay. And I believe you testified that you conducted a psychiatric evaluation of the plaintiff as part of your duties in this case. Is that correct?
Yes, so the psychiatric evaluation is, to me, a broader term that consists of the triad of reviewing records, conducting a face-to-face examination, and scoring and utilizing the psychological testing that was administered during that examination. So it's a matter of integrating and correlating and weighing the information from those three sources.
Thank you
And
so
can
much,
please,
Agro.
just a little
Thank
more detail,
you.
explain what happened during the
appreciate it.
evaluation in this case.
Certainly.
Exactly.
So I believe it was in July, maybe around.
That you're exactly right. $3,200 for 4 hours work. Imagine that, y'all. Imagine getting $3,200 for 4 hours of work. This guy's doing it. What?
July 21st, 2023. So it took about, I would say, roughly 6 hours.
Okay.
The entire examination was audio recorded. And the first half of the examination...
Look, he making that money, but he got that experience, he got that knowledge. You know what I'm saying? You ain't gonna be making $200 for one box of short work if you ain't got that skill set. You know what I'm saying? Yeah.
was the administration of the psychological testing.
Thank you so much,
where using
Agro.
gold
Thank you,
standard
Agro.
psychological tests, I
Thank you,
provided them
Agro,
to
for you, Q.
Ms. Ellis. I was there.
So this is when it
With her the
starts
entire
cutting in
time.
and out. Hold on, yo. So
I
that's
think
the
that the
stream, not
MMPI-3
me.
or the MMPI-2 current ultimate gold standard tests, you have to pass.
Okay, we're going to skip a little bit of this because the stream cuts in and out. Okay, so now they give him the documents to look over for the visit for the case. And I say that the document's about this big, y'all. The book is this thick. For a, what is it, a 2 centimeter cut? How many centimeters was the cut, y'all? It was 2 centimeters, right? Was it 2 centimeters or millimeters, 2 millimeters? Whatever millimeters, centimeters, it was a minuscule of a cut. But let's continue. So he's looking through a book of documents this big. Let's listen. I'm going to get him, CJ. I'm going to get him.
Okay, I'm at 229.
I'm just doing this a certain way over here. So I can't get him because
Yes.
they don't have an
so
option
this
for
is
it.
the report of the MMPI-2 psychological test that I administered to Ms. Ellis on July 21st, 2023, in which I provided along with other documents to opposing counsel before my deposition.
And does this document refresh your recollection as to which version of the MMPI-2 test you conducted in Ms. Ellis' case?
Yes, I gave the MMPI-2. That and the MMPI-3 are the most recent and, again, the gold standard tests worldwide in this kind of context.
Thank you. And that report that you have in front of you, did you create that document yourself?
Well, I created it in the sense that I inputted
I know what I'm
her
gonna do.
answers into the test publisher software on my laptop. I then double-checked the answer through a process that's provided by the software. And then I had the software generate this report, again using statistical algorithm.
I got
that
it,
is intrinsic
CJ.
to the software.
Straight
I
to
don't
the source.
personally score any of the scales. I don't personally write out any of the text interpretation that's in it. My job is then, how do I use that information once it's available in an overall assessment?
And is it fair to say that you used this report as an analytical tool in reaching your conclusions with respect to Ms. Ellis?
Yes, again, considering all the information available to me from the records, the exam, the testing, I utilize inductive medical reasoning, a best fit logical reasoning, the same reasoning I would use if I was in an emergency room, if I was a surgeon or I was a radiologist.
Do you use this software and the reports that are generated from it regularly in your psychological evaluations?
Yes, I've used these tests several hundreds of times. I have the highest user rating qualification from both test publishers.
Okay, and do you recall when this particular report was generated?
My best recollection is I generated it, shortly after the examination had been completed, but I just apologize, I don't recall a specific date.
Thank you. Defendant moves to admit Exhibit 229 into evidence.
Objection, hearsay.
Your Honor, may I publish page 2 of Exhibit 229?
Sorry.
The trial is going to start closing arguments in a half an hour, y'all. So we're just doing preliminary stuff before the trial starts. Let's listen.
All right, and Dr. Rosenberg, you can see at the top there, I suppose you could look at the binder as well.
If you turn your screen on, the top left button on the top left side, it should be on there.
Thank you, Your Honor. That's much better. Thank you, Your Honor. Okay, yes, sir. I can see it now. I wasn't able to see that.
Thank you. If you look at the top of the page, it says validity scales. Can you please explain what that means?
Yes, so these are the most important scales of their type for this and the MMPI-3 of any test in the world, any psychological test. The validity scales look at how somebody is approaching the test. The first two scales, Brin and Trin, variable and true response indicator, look at whether somebody understood the test questions and responded to them in a consistent fashion. So those first have to be valid before you can go on to interpret the rest of the test. The remainder of the validity scales, the vast majority of them, look at their F scales because they look at infrequent responses. These scales become more and more elevated if an individual endorses or answers questions endorsing symptoms.
I'm trying to find out what
that
happened
are
to him.
infrequent, meaning
Well,
that
we're
even
going to
somebody
talk
who
about
actually
that.
had that
By the
mental
time
disorder
this is over,
would
Pamela,
not
you'll
actually
know.
endorse them.
You'll
And
know.
these scales are scored against a large statistical population, cross-section population of the United States. And then the last couple scales, the L scale, looks at a different type of potential manipulation, portraying yourself in an overly positive or virtuous light. And then the last one is just a correction to that.
Thank you. And what do Ms. Ellis's test results in this case show you? And I'm sorry, specifically with respect to the validity scales.
Yeah, so looking at these, it's more fun to do it from memory, but looking at these scales, they demonstrate that when Ms. Ellis took this test, that she generated scale elevations in the range that only reasonably could be interpreted as either severe symptom exaggeration or symptom fabrication. From a psychiatric standpoint, obviously I'm not giving a factual opinion. So if we look at F, the third one over with a T-score of 83, so these are compared against a normal bell curve of statistical scores where a T-score of 50 is in the middle. And every time you go out 10, you're going out another standard deviation. So at a T-score of 83,
Over a
the
tiny
F
scratch.
scale that looks at things
That
like
we can't even
anxiety,
see.
depression, PTSD, she generated a score more than 3 standard deviations above the norm. And statistically, only 48 people out of 100,000 would actually generate that score, even if they really had the condition. If we then look at the other scales thereafter, the FS scale, S is for somatic, meaning physical symptoms. The FBS, which is the fake bad scale or symptom validity scale, and the RBS
You
scale.
left a lot of comments,
Those look at
CJ.
physical health symptoms.
It's gonna take me
and
a
they look
minute
at
to
cognitive
remove all
symptoms
these,
like
but I
attention,
reportified them.
concentration, primarily if you're evaluating a brain injury claim. And so on those scales, with the understanding that, as I'll discuss, Ms. Ellis has not sought out any type of...
She ought to be
I reviewed
ashamed
the
of
Kaiser
herself.
records
Yeah.
in my audio recorded interview. Any type of physical health problem.
The one thing that I sense in this case that I don't sense in the other in Diddy's case is it seems like this judge is fair when they talk, right? The judge ain't out to get Cardi B. He probably don't listen to the music. He probably ain't in that realm. A lot of people just don't like Cardi B. A lot of people do not like Cardi B because she became famous. And people just don't want... In the beginning of Cardi B's career, I was listening to her on Instagram when she was cracking jokes, talking crazy. It's her personality that people like, right? It's a personality that got her indoors. And plus, she was a stripper. Stripperifications get around all the celebrities. They all come to the stripper club, right? So she got real popular. The Shaft said, "Oh, you got popular now. Let's find something to do. You want love and hip hop? Okay, let's rap." And it was the logical thing because she sang in school, like she did the talent school. This is stuff that people don't see. But people did not like it. And Cardi B seems to keep pissing them off because she keeps winning. This girl been relevant for 7 years. No album out. No album. 7 years stay relevant. Any other artist, look at them. They put an album out, let them disappear for 7 years. You wouldn't even know they exist anymore. Cardi B stayed relevant. People do not like Cardi B, right? But it's like funny. The thing that you don't like and people don't like is the thing that keeps going. That's the thing. Cardi B is going to be the thing that people don't like that keeps going, and it's going to keep pissing them off. This girl is not going to win this case. And she definitely not getting $24 million. But let's listen.
However,
I don't care what people feel about
injury.
Cardi B. That girl lied.
These elevations are
Allegedly.
extraordinarily high.
Thank you, Rico.
The FBS or fake bad scale
She's
elevation
lied
is a
about a
T-score of
couple of
102. at 5 standard deviations above the norm, only 2 individuals out of 1 billion would actually have that score
Yeah,
if he or
Love
she
and
had
Hip Hop got a famous
the actual disorder. So these are extremely high. They're far beyond the range of somebody who could just be distressed and is trying to emphasize how distressed she is, or so-called cry for help. These are in the range of elevation that no individual, even with the conditions, would reasonably have at that statistical elevation. Putting aside
We
that
got
she doesn't
20
even
minutes
claim
to the closing argument
those types
start,
of symptoms in the first place.
Everybody sherified, everybody
And
like
what types of symptoms would that be?
We're in some other places.
So for the
Multitasking.
FS to have an elevation on F sub S, which is somatic or physical, especially a significant elevation, you would have to have a serious physical health condition. Let's say you have cancer, or you recently had a heart attack, or you're in heart failure, or you have uncontrolled diabetes, things like that. FBS is particularly sensitive to symptom fabrication or exaggeration in individuals who've had traumatic brain injuries. But again,
I
even
didn't
if you
listen to her
have
music, but I like the
a
fact
severe
that she is
disabling
yeah,
traumatic
she's
brain
very
injury
blunt.
and you're in a rehabilitation facility.
Oh, you can't
your
hear it,
elevation
Giselle? Giselle said,
be
"What is?
maybe
Are you
peaceful.
saying what is he saying? Because you can't hear it? It's not loud enough." Or are you saying what is he saying as is? What is the context of what he's talking about? He's talking about his findings, reviewing the documents of this case from a psychiatric point of view. So that's what he's talking about. Everybody keep tapifying. Everybody keep sharifying. Okay, let's listen.
Or of 70,
Hey,
75.
Risa?
Again, at 102,
Yeah, Giselle.
where it's 2 people in a billion, no individual who even had a brain injury would reasonably endorse that score. Or again, they get elevated the more and more you endorse symptoms that no person who actually has the condition would actually report those symptoms. And then RBS is cognitive. So again, it looks at things like attention, memory, and concentration. And again, hers is elevated in the range of 4 standard deviations. So, it would be well over 100 million to 1 that she would actually have those symptoms.
Thank you. Can you please turn to page 10 of the report?
Of this psych testing report?
Yes.
He's saying that the girl suing Cardi B is lying. Exactly.
Towards the bottom, you see is written Diagnostic.
He is going through this report and counteracting everything that girl Ammani is saying from a doctor of his standpoint, working for law and order, working at the VA hospital. He's not going to put his credibility on the line and lie and say, oh, what this girl is saying is true. He's going to tell the true feelings of his expert opinion about the case. And he's basically saying what you just said, that she's lying. The person that experienced this type of traumatic experiences, she's not experiencing this, that thing. She's not a person that looks like she had this experience. Let's listen. Let's dial it back a little bit and let's listen.
Infrequent, meaning that even somebody who actually had that mental disorder would not actually endorse them. And these scales are scored against a large statistical population, cross-section population of the United
I think
States.
Cardi B needs to counter to her.
And then the last couple scales, the L scale looks at a different
Who
type of
thinks Cardi
potential
B needs to-
manipulation,
Cardi B
portraying
needs to,
yourself in an overly positive or virtuous light. And then the last one is just a correction to that.
Thank you. And what do Miss Ellis's test results in this case show you? I'm sorry, specifically with respect to the validity scales.
I do 100%.
Looking at these,
wasting
more fun to
people's
do
money
it
and
from memory,
time.
but looking
She
at
wants
these
some of that money.
scales, they demonstrate that when Ms. Ellis took this test, that
just like Cardi B said in the case in her testimony, she just wants some money. And the lawyer said, what did you say? He said, I said she just wants some money. Who wants some money? Her. Why do you think that? She's suing me for $24 million. That's why I think that. That's what Cardi B said. And I believe her. The girl
she
just wants some money.
generated scale elevations in the range that only reasonably could be interpreted as either severe symptom exaggeration or symptom fabrication. From a psychiatric standpoint, obviously, I'm not giving a factual opinion. So if we look at
Cardi B kind of has to waste her time, Tulip, because they summoned you. You have to be in court. If Cardi B didn't waste her time with this case and didn't go to court, right, she would get $24 million in default. And Cardi B is not going to let that happen. No. No, a waste of money
with a T
that
score
the girl
of
is
83.
broke. Okay, wasting it.
So
Right.
these are compared against a normal bell curve of statistical scores where a T-score of 50 is in the middle. And every time you go out 10, you're going out another standard deviation. So at a T-score of 83, the F scale that looks at things like anxiety, depression, PTSD, she generated a score more than 3 standard deviations above the norm. And statistically, only 48 people out of 100,000 would actually generate that score, even if they really had the condition. If we then look at the other scales thereafter, the FS scale, S is for somatic, meaning physical symptoms. The FBS, which is the fake bad scale or symptom validity scale, and the RBS scale, those look at physical health symptoms and they look at cognitive symptoms like attention, concentration, primarily if you're evaluating a brain injury claim. And so on those scales, with the understanding that, as
I know this girl didn't claim she had a brain injury. I know she just didn't.
Discuss, Ms. Ellis has not sought out any type of, from my review of the Kaiser records in my audio recorded interview, any type of physical health problem whatsoever, and certainly hasn't had a brain injury. These elevations are extraordinarily high.
This reminds me of the Brat.
FBS, or fake bad scale elevation.
Yeah, somebody said this reminds them of the Brat situation. It does. And you know, James, the Brat is still just paid. I think she just paid off her debt to that girl. But that girl put her in jail. See, it was a little different than this case because it was a criminal and then the girl sued her civilly. You know what I'm saying? So claiming that the Brat took to her over her head with a bottle. But CJ, in that case, the Brat's case, I think the girl actually got hurt because the girl actually had doctor's doctor's records of which she actually did get cut by the bottle that Brat threw. So that's a little bit different than this.
The T-score of 102 at 5 standard
she
deviations
lost the temper
above the
to Brat.
norm.
She talked about it a little
only
bit.
Only 2 individuals out of 1 billion would actually have that score if he or she had the actual disorder. So
2 or something out of something billion if they actually had the disorder. So she lying and making up about stuff that she got that she couldn't get in 200 billion probations. What does it go?
You know, these are extremely high. They're far beyond the range of somebody who could just be distressed and is trying to emphasize how distressed she is, or so-called cry for help. These are in the range of elevation that no individual, even with the conditions, would reasonably have at that statistical elevation, putting aside that she doesn't even claim those types of symptoms in the first place.
Thank you. What types of symptoms would that be?
So for the FS to have an elevation on F sub S, which is somatic or physical, especially a significant elevation, you would have to have a serious physical health condition. Let's say you have cancer, or you recently had a heart attack, or you're in heart failure, or you have uncontrolled diabetes,
everybody
things like that.
Everybody blessify Miss Knockout. You're getting a lot of tea in here.
To
a lot of tea.
Symptom fabrication or exaggeration in individuals who've had traumatic brain injuries. But again, even if you had a severe...
Well, I think that might be an effect, Tulip. Tulip says Ammani shouldn't be allowed to work in security again. Thank you so much for the little doggy rubbing, right? And I agree with you. And she did get fired from it. She doesn't work at that security job. And I'm willing to see, when you get fired from a job, right, in order to get another job, you got to get a referral. She got to get a referral from that job to work another security job. It's imperative. Because, you know, they really check you when you're doing security. You're security. And that job ain't going to give her no good reference. I like your hair like that. Thank you. I'm all natural. This is my hair. This is my hair. I'm all natural, y'all. No wigs. You know, so trying to grow my hair out. I want a little curly afro. Okay, let's listen. We got less than 15 minutes, y'all.
Disabling traumatic brain injury and you're in a rehabilitation facility, your elevation would be maybe a T-score of 70, 75. Again, at 102, where it's 2 people in a billion, no individual who even had a brain injury would reasonably endorse that score. Where again, they get elevated the more and more you endorse symptoms that no person who actually has the condition would actually report those symptoms. And then RBS is cognitive. So again, it looks at things like attention, memory, and concentration. And again, hers is elevated in the range of 4 standard deviations. So, it would be well over 100 million to 1 that she would actually have those symptoms.
Thank you. Can you please turn to page 10 of the report?
In other words, she learned everything in Miss Knockout's life is all allegedly. That's what he's basically saying. This girl ain't get what? Let's listen.
Of this psych testing report?
Thank you. Get your orange hearts, y'all. Thank you, Mickey the man.
Towards the bottom, you see is written diagnostic considerations.
Mickey the man.
Yes.
Can you please explain what that section is saying here?
Yeah, so again, the report doesn't talk about Ms. Ellis specifically. It talks about, at a statistical level, individuals who have these scales and scores tend to look like this. And the diagnoses that are suggested are rank ordered in the priority of how likely they are. And so the first diagnosis listed is malingering of somatic and or cognitive symptoms, primarily generated by the elevation of the F sub S, the fake bad scale, and the RBS. And so, and malingering refers to the intentional gross exaggeration or otherwise fabrication or manipulation of symptoms for secondary gain in the field of psychiatry, and is actually
for
in accordance
secondary
with the
gain.
American
Did you hear what he
Psychiatric
said?
Association's published guidelines.
For secondary
Again,
gain.
this section of the report, like everything else, this was generated as a result of the test publisher software. Is that correct?
Yes, the test publisher software, the statistical scoring, which involves hundreds of thousands of individuals, and then detailed mathematical statistical algorithms that are used to score this test and prepare this report.
You testified earlier that there were other psychological tests that you administered. Are the results of those tests similar with respect to symptom exaggeration?
Thank you so much, Philly, for getting your orange heart.
Well, I would say yes and no. The other test, the personality assessment inventory, does not have as sensitive of validity scales to detect exaggeration or other manipulation, though it does show some evidence of that.
Thank you so
But
much,
when we
Selena.
look at the clinical scales
Thank you.
on the personality assessment inventory, Ms. Ellis generated such huge elevations for scales like anxiety, physical symptoms, PTSD, depression, again, several deviations above the norm that make no reasonable sense unless somebody was actually, for example, so ill that she required inpatient psychiatric care on medications, was critically ill or terminally ill with physical health conditions. The other inconsistency is that on the MMPI-2RF, she scored, accepting her symptoms at face value, she scored very high on symptoms for paranoid thinking at the level of somebody with a paranoid psychotic disorder like schizophrenia. And that was not seen on the PAI. So that would be an inconsistency between them.
Of her lying butt trying to get, he's evaluating for the case, right? He said that she does have a paranoia and that's a person that's probably, she was in that mode of thinking of things. I got to think of the next thing I could do. I got to get this money. Like, she in that mode. So those symptoms is showing. Like, he just got on the stand, in my opinion, and he just ripped her to shreds. Like, by just giving his opinion. You know what I'm saying? By just giving his opinion. Ripped to the shreds. Let's continue to listen, y'all. Let's continue to listen.
Larger area of changes of the skin, which I would characterize as scarring. So I did those areas.
Wait, hold on. This is the wrong one. Hold on. Why does this thing keep disappearing? Okay.
But it also would be another example of symptom endorsement that makes no reasonable sense except for intentional gross fabrication.
Listen to what he said.
Or outright fabrication of symptoms in this case at that level of paranoia.
Did you hear what he said outright in court? Oh my gosh, Ammani, the psychiatric doctor that worked for Law and Order, the VA hospital, credentials beyond belief, said that you are fabricating. Wow. That part is going to tremendously hurt her case. I'm going to tell you something, guys. Let me run it back. Let's run it back. That right there is going to tremendously hurt her case by this guy of this high professionalism of psychic. Because when you have these cases, right, and you're suing people, both sides agree to, and they agree on the psychologist, right? Thank you, Desiree. Thank you. Oh, I love y'all too. Yeah, throw it out now, right? Taylor said, throw it out now, right? They both sides agree to have you psychologically evaluated. That's part of a lot of cases. Even if you slip and fall, car accident, the lawyers can opt to send you, both agree to send you to a psychologist. And they sent him to the psychologist. He has all these credentials. And he's saying that basically she fabricating stuff. All right? Okay? We got like 10 minutes. Now, it's probably not going to start right away. They're probably going to be shuffling papers. But we're going to be there listening. If they're shuffling papers, we'll listen to this. Right? Until we go into that. All right? In the meantime, everybody typify, everybody sharify, and everybody blessify Miss Knockout so she won't be brokified because you're getting a heck of a lot of a tea today. Okay? What is going to happen to her? I don't know, Anna. I don't know what's going to happen to her. If I knew that, I would run down there and get the Powerball that they didn't win Saturday. I wish I could tell what's going to happen to people before it happens, Anna. Because I will run right down there and pay the Powerball. I don't know what's going to happen. We're gonna find out. We're gonna find out when they deliberate and the jury comes back and they say what they say. But today we're gonna hear the closing arguments, and I don't like that. Ammani's lawyers are a-holes. He was aggressive with her. He was argumentative with her. The judge had to tell him several times to tone his voice down. Right? And he says, I'm not yelling. No, the judge says it's not about yelling. It's about tone. Your tone is argumentative. Why is his tone argumentative? Because he want that $24 million. That's why his tone is argumentative. He want that $24 million. How long was your nails? How long was your nails? When she told you to get out and leave the complex, how come you didn't leave the complex right now? Aggressive, argumentative, defensive. And it gave, I want that money. Because see, the lawyer gets 33 1/3%. A lawyer let's go to Mama G, y'all. All right, for on this side, I don't think y'all never met Mama G. So you're going to meet Mama G today. Okay? Let's go to Mama G. Let's find out from Mama G, right? How much is 33 1/3% of a $24 million lawsuit? That's what's on the line, and that's why he got that. He wants it. He wants it. Everything is about the bag. Everything is about the bag. Everything is about the bag until, like, even if she got that $24 million, the universe ain't going to let her enjoy it. How much you willing to bet? Let's just say that first of all, she's not going to get the $24 million anyway. Even if she was dead right, she's not going to get no $24 million. She didn't have major surgery, okay? She didn't have a major surgery. They did not, that little micro needling is like basically what they did was micro needling. And a micro needling lady came in here and said, as we were listening to it, she says, I do that. That's what he did. Micro needling. He didn't do no plastic surgery. No, $24 million, CJ. $24 million. Not 7.2. Right? So she ain't going to get nearly like that and that type of money anyway. Hi from the UK. See, I'm on early. I'm getting early and earlier, Tracy. I'm getting early and early. Hancock is here. What's up, Hancock? Welcome in on my newbies. All right? Newbie boobies, make sure you follow Miss Knockout. All my newbie booby people, make sure you follow Welcome to Miss Knockout. Now, there's a couple of things that can happen. Okay, it's getting ready to start in 2 minutes, y'all. Okay, so let me watch this. Let me keep an eye on this to make sure it don't start, right? But we don't want to be there for the fluffy fluff. We want to be there for the when they talking and getting in the paint. All right, so I'm Miss Knockout going to keep an eye on and let them shuffle papers and all that, and we're going to come in on it when we get to the meat and potatoes. We love you, Ma. Thank you, D. Gonzo. 8888. Thank you. I appreciate it. Everybody tapify. Everybody sharify. I love everybody and everything you do to help the community, the knockout community, whether you tapifying, sharifying, blessifying, whatever you do. Miss Knockout, appreciate you all. Everybody coming in. Okay? We're getting ready to listen to the closing arguments for Cardi B's trial against Ammani Ellis. Okay? Mama, we're going to, after we listen to closing arguments, we might not get it today, but we're going to come on tomorrow, which is Wednesday, right? And we're going to go through the whole trial from top to bottom tomorrow, all right? We don't finish it. We'll either come back in the evening, we'll come back in the next day, and we'll go over stuff until they reach a verdict. Now, it's going to take them about a day or so to reach the verdict. It's going to take them about a day or so to reach the verdict. All right? Everybody make sure you follow me. Let's continue to listen to them. They haven't gone live yet. They're probably going live in a few. But let's continue to listen to them. All right?
Diagnoses that are suggested are rank ordered in the prior.
Well, hold on. This is the wrong one. Hold on, y'all. Okay, we ain't going to do no battle. We'll probably do some battles at the end of the broadcast if y'all stick around. All right? Okay, hold on, y'all. Hold on. All right, so the assault trial didn't start yet. All right. So everybody that's coming in, we're listening to, hold on. We're listening to a psychiatrist.
Priority of how likely they are. And so the first diagnosis listed is malingering of somatic and or cognitive symptoms, primarily generated by the elevation of the F sub S, the fake bad scale, and the RBS. And so
he's saying that the conditions that they was trying to push was cognitive stuff. That meaning that it's stuff that you lose your memory, like you disorientated, like dementia type symptoms and stuff like that. And he's saying clearly, she's sharp as a tack, darling.
And malingering refers to the intentional gross exaggeration or otherwise
Thank you, Michelle.
fabrication or manipulation of symptoms for secondary gain in the field of psychiatry, and is actually in accordance with the American Psychiatric Association's published guidelines.
And again, this section of the report, like everything else, this was generated as a result of the test publisher software.
They said 12:45, but they didn't
Yes, the
start
test
yet.
publisher software, the statistical scoring, which involves hundreds of thousands of individuals, and then detailed mathematical statistical algorithms that are used to score this test and prepare the.
Oh, we was going to ask. Okay, hold up. I was going to ask in the middle of okay, we jumped from here. I was doing it, then we jumped. I was going to ask Mama G, right? Let's see. Let's see if we could pull Mama G up. Now look, I'm putting the label on because I have to, right? Because the clock, when you're talking to AI or you got anything AI, you got to put the label on, else they'll remove you from the homepage. Okay, so don't mind that label down there. Okay, Mama G, you there? Okay, Mama G is turning and I got a lot of screens open, I know. All right. So I want to ask Mama G, right? Let's just ask her in the text. Okay? How much is 33%? Let's just round it up to 33%. How much is 33% of $24 million? That's if that lawyer, happen to get, because I don't think they'll never, they put it up real high and then you get something lower. That's how lawyer suits work. They put it up real high and then you get something lower. But we're just curious. How much is 33% of 24 million? Right? This is why the lawyer is so anxious. But he know he ain't gonna get no 24 million. You know what I'm saying? Now, if they want to just throw her something, I think that she would get 25,000 to 500,000. 7.9 million. Somebody else says 7-point-something million. That's what you think she's going to get? 7.9 million? Is that what you think she's going to get, Dana? Is that what you think she's going to get? I don't know. All right, let's listen. Let's go back and listen. So they ain't live yet, y'all. When they go live, we're going to get right into it. Let's listen.
I testified earlier that there were other...
Oh, 7 point. Oh, y'all are telling me what the 33% of it. Oh, okay. So the lawyer gets 7-point-something million. Look at that. Look at that. For 5 days, 3 days in court, 7-point-something million. Come on now. Imagine that. Let's listen. They're not live yet.
Are the results of those tests similar with respect to symptom exaggeration or fabrication?
Well, I'd say yes and no. The other test, the personality assessment inventory, does not have a sensitive of validity scales to detect exaggeration or other manipulation, though it does show some evidence of that. But when we look at the clinical scales on the personality assessment inventory,
thank you so much, Philly. Everybody
Ms. Ellis generated such huge elevations for scales like anxiety, physical symptoms, PTSD,
7.2 million plus.
Again, several deviations of the norm.
Okay, James. Yeah, that's what Joe was saying.
Make no reasonable sense, right? Unless somebody was actually, for example, so ill that she required inpatient psychiatric care on medications, was critically ill or terminally ill with physical health conditions. The other inconsistency is that on the MMPI-2RF, she scored, accepting her symptoms at face value, she scored very high on symptoms for paranoid thinking at the level of somebody with a paranoid psychotic disorder like schizophrenia. And that was not seen on the PAI. So that would be an inconsistency between them. But it also would be another example of...
Now, if she tries to get hired, right, somewhere, and an employee isn't privy to this testimony, which a lot of people are, right? Who's going to hire a person that a clinical psychiatrist says has the characteristics of a schizophrenia person? Who's going to hire her? She's doing herself more. Let's listen.
Symptom endorsement that makes no reasonable sense except for intentional gross fabrication or outright fabrication of symptoms in this case. at that level of
Outright
paranoid
fabrication.
thinking, again, would be like a
Listen to what he said.
requiring acute inpatient care on medication.
Outright fabrication, he said. Wow.
But by the same token, taking it at face value, it is, from my standpoint, of relevance to the trier of fact in evaluating somebody with that degree of paranoia and suspiciousness, how that individual reacts to or responds in neutral situations, social situations, potential arguments.
You mentioned a high paranoid thinking score. I believe that's correct?
I'm sorry, so what did you say?
Did you mention a high paranoid thinking score? Is that how you phrased it?
Yes, on the 3 key scales of the MMPI-2 for paranoid thinking. Again, typically seen in something like
8
schizophrenia.
million when you, basically 8
She
million
has
when you round it off.
significant elevations on those scales, all 3. Again,
Okay, let's
in
check
the
and see
range
if
which
they
the
live, y'all.
we see here in the text.
We waiting at the
report,
door, y'all.
how the
We waiting at
report
the door.
interprets it. At the level of somebody with
Everybody
a paranoid
share it. Come
psychotic
on,
with
y'all.
delusions,
Let's
not
share
just
it. Let's
somebody who
get
feels
everybody in
a
the
little
room.
stressed or like somebody's looking over her shoulder.
And
Oh, it's live.
as a
It's
professional
live, y'all.
and a psychiatrist,
Here we go.
how would you interpret that?
Everybody share fire. Everybody wouldn't put in comments. Cardi B. Put in hashtagifications. Hashtagifications. Cardi B. Court case. Hashtagifications in the comment. Okay? Let's take this AI tag off. Hold on. Let me take the tag off, y'all. Sorry about that. Forgot to take the tag off. Okay, let's go into the closing arguments, y'all. Let's go into the closing argumentifications. All right, here we go.
Your Honor, it looks like these combine 3903 with 3903A, which is the next page in my binder that was given to you.
I wish they would have it that way.
Thank you, Michelle. Okay, so this is live.
Like,
This is the closing arguments live. Let's
I think it's
listen.
confusing.
Let's listen. This
But
is
since I've
happening
already
now.
given it, I'll just
Hey,
swap
Liberty. Thank you.
3903 and the 3903A as
This is live, y'all. Real time.
did already.
So you're going to keep the one that's been read already, is that what we're saying?
I did give these jury instructions. I gave them as they're printed out here. It's just without I think the proposed instructions had language that I struck out. So this is the thing.
Let me share it to my stories.
The one that I submitted this morning.
Hold
is
on, y'all.
directly
Share it
out
to
of
the
KC.
stories.
But you combine 3903 and 3903A. And that's not how I gave it. So if it had been given to me that way originally, I would have read it that way, but I didn't, so I don't want to change what I've already read. All right, 3905A. Did I already give? I think I already gave a version of that as well, right? Oh, maybe I didn't.
I'm not sure, Your Honor, you asked that we...
Oh, I have to
that we
share it
just
to my
include the
story.
case
I share it to my
instruction rather
story.
than a special instruction. So this is just the case instruction.
Okay, so I will give that.
Can y'all hear it?
Your Honor, I also submitted.
Can we all hear it?
3905,
Is that straight from the cases?
straight from the case.
Okay.
Are they
They're the same.
they're the same?
Correct. All right,
Okay, good.
3934. That was not in the original package.
That wasn't the original package.
It was.
It was modified only because now that the damages are more limited than what Mr. Rosenberg was proposing earlier, we've just changed the last sentence.
So they're shuffling
Oh, okay.
papers.
And I did not read that on Wednesday.
But they're still
Is that
talking
correct?
about stuff, so
I
let's
don't believe
listen.
it.
Correct.
Okay, so I'll give 3934. Special instruction number 8.
Special instruction number 8, there are just 2 differences from the casing instruction.
A version of that as well, right?
Is
Oh, maybe I didn't.
I'm not sure. Is that punitive damages cannot be awarded if there was accidental harm.
Hold on, y'all.
The second
I gotta
is
adjust
to include the next. That's paragraph 3. Paragraph 4 is to include provocation. as part of the jury's consideration of punitive damages. And we've identified a lot of supporting authorities in the notice that we filed with it. And I believe even Whitkin states that it's proper to instruct the jury on provocation when they're considering punitive damages.
Yes, Your Honor. My understanding was the trial would be bifurcated, and we would only get to this point after the jury made its decision as to the first non-punitive damages stage.
Well, this is a modification of the casing that is given during the first phase. So do you want to be heard on the modification, specifically accidental or heat of passion?
Hey, Jenna. Thank you, everybody, for listening. It's going live. It's live.
See a need for this one because there is a specific casing on punitive damages that can be read.
I understand that. He is suggesting that it be appropriate to amend the casing to add accidental harm and passion. Do you want to hear that?
Yes, Your Honor. So
Thank you so much.
my
Get your
point is that none of the cases can be changed.
like Jennifer.
This is an example of one that's really so far off.
Liz is here.
Completely
Everybody
different.
that's just coming in, we're listening live to the closing arguments for Cardi B. So they're shuffling papers and they're talking now. Let's listen.
What the casing states. So that's my position.
All right, submitted.
Yes.
All right, I think special instruction number 8 is appropriate, so I'll do that. Special instruction number 9 is not going to apply until we get to punitives. All right, let's go through plaintiff's proposed instructions.
Your Honor, there's one more I need to add. 3932, life expectancy. I have it here.
Is it printed out?
Yes.
And is the math right?
May not be. I'm willing to reduce it if that's the case, but I believe it's close to the number. Oftentimes, we'll have a stipulation with counsel, so if they want to reduce it to 40 years, I'm fine with that. I just picked a close enough number.
So what evidence do you have that she will continue to have future? I guess she testified that it still bothers her, is that?
Yes.
Okay. Any objection to 3932?
Yes, Your Honor. I'm not sure that she testified that it still bothers her, but in any event, first of all, this was never shown to me. We're not sure that the math is correct. And
Aileen is back.
this is just not an appropriate...
How you feeling? Hope you're having the best day. I'm
This is not an
feeling
appropriate
good.
instruction in a case like this where it's over an alleged scratch and there's a overwhelming amount of evidence that it wasn't caused by the...
Want to respond to it?
Go ahead.
So I'm pretty confident that if it was changed to 40 years, it would fall well below the threshold of the National Vital Statistics report. So I'm willing to do that. If there's a different number that they propose, I'm fine, but there should be some kind of case in 3932 of life expectancy so that the jury can understand that case.
We're listening, people. They're getting ready to start the closing. The actual closing arguments are going to start soon. The court just started. They're shuffling papers and they're going over preliminary stuff because they also have to answer the judge asked the jury if they have any questions about the case. And I'm sure, darling, they had a couple of questions for that assification, right? And they got to, answer those questions, and they got to give the jury instructions, just like they get in the Diddy trial. They give the jury instructions on how to deliberate on the case. Now, of course, this is not a criminal case like Diddy's case. This is a punitive damage case. So they got to give the instructions on how to rate, what she gets for what. Does she get damages for this? Does she get the damages for the cut? Does she get damages for the mental distress? Or does she get punished for lying? Okay? But let's listen. Open arguments. So both of the judges are standing. They're looking at the judge. Cardi B's people is on this side. Ammani and her people is on this side. They're both standing up and they're doing preliminary things so that each side is going to have a chance to give that last minute push. Closing arguments are a last minute push to convince the jury what you want to convince them about the case. You know what I'm saying? And the lawyers for the plaintiff, which is Ammani, with the fake face cut, allegedly, right? They got to convince, oh, she got this cut. She deserves this money. And on Cardi B's side, they got to convince them she's not. Cardi B didn't touch her. She's lying. Both sides closing arguments. They got to drive that nail in a hole. Closing arguments can make or break you. Make or break you. Let's listen. This is live, y'all. The first one's hearing it. Y'all, the first one's hearing it. I hope she's awarded $5. So, Miss Lucia says, I hope she's awarded $5 and throw her behind out of the doggone court.
I'll go 3932 over plaintiff's or defendant's objection.
Rev is in the building. Hey, Rev.
All right. Plaintiff proposed 3901. I think I already gave 3901.
I wanted to give you a heads up, but I want to, I know it's working season, so everybody's workifying, Everybody's workifying, including me. That's why I have to leave for a day, or don't come on at a certain time when I want to. So everybody coming in, we are listening to the Cardi B case. We are listening to closing arguments live and direct, honey. Let's go.
That's not correct.
Shuffling papers.
No, I give 3900. I did. Oh.
Thank you, Luna Bell. Hey. Everybody tap a
You're
five.
right. Yeah. So 3901 is only if liability has been established, not contested.
I apologize, that's an error.
Okay, so that's withdrawn?
Withdrawn.
Okay. 3902 already gave. 3903. I did not give, but I think that was proposed by the defense.
That's correct, Your Honor.
And the defense version was straight from the casing?
Yes.
Well,
it's in the binder.
Hey,
the one that I
everybody.
did, Your Honor, is from the casing, which seems to have a lot more words than theirs.
What's up? Thank you for the heartbeat, Luna.
Yeah, I already did give 3903.
So we're gonna go with their version now?
It's straight from the casing. 3905, I think I already gave.
May I be heard on that, Your Honor?
Go ahead.
So the one that I've submitted today has all of the different types of physical pain, mental suffering, and emotional distress. Their version doesn't really cover everything at all. It just has a small amount. It's missing an entire paragraph, at least a portion of it. So I would request that plaintiff's version be read.
It's just starting, y'all. We're listening.
I just looked. I did not give
She'll get
$3905.
$20 court voucher to top up her
plaintiff's
gas
straight from the
tank to
casing.
go home.
And defendant had a
You're not right, Loretta.
3905A.
You ain't right,
So maybe
Loretta.
that's why. I would like 3905.
What's going on with you, Puffy, these days? Yeah. Puffy's coming back
Your
up
Honor,
a turn
I
with
believe
third.
the difference is that 3905
Today we're talking
and
about Cardi B.
3905A, we just submitted them as separate instructions.
Cardi B closing argument.
Plaintiff's counsel has combined them.
Your Honor, I don't think I've combined them, but
Oh, I see. The defense proposed version does not define.
Yeah, we talk about Puffy's updates and stuff like that.
Doesn't cover.
Yeah, it's not the full instruction.
But Cardi
so
B
I'll
is
give
what's
Plaintiff
going on now. This is the hot topic.
Thank you.
Heather.
All right, 1600.
Welcome, everybody. Welcome back.
I think I gave 1600, didn't I?
I believe you did.
I thought the court wanted us to work on the 1600s, but I may be mistaken.
Your Honor, it was the 1602 instruction, which was the special instruction for
There is a jury. They don't show the jury, though.
I did give 1600 already.
Then I withdraw the objection.
It's a jury.
1600s.
Okay.
They shuffling a lot of papers for that 2 centimeter cut. They like
1602, did we give a version of that?
they shuffling them papers. So the jury not
1602 is
trial by
the
jury.
special
Y'all.
instruction 4
Hold
that
on,
we
let me grab
discussed
some. We're
a few
listening.
minutes ago.
And that, okay.
And-
So I'll give the modified version.
Thank you.
1603, did we give that?
1603 was included in ours as well. I believe the court asked that we include it, so
Okay.
that's in our record.
And 1604,
I believe was given.
was already given. All right, tell me we have an agreed upon verdict form.
Unfortunately, we do not, Your Honor.
Can you highlight the differences?
Yes, Your Honor. So I've never seen it the way that they proposed it, with the preponderance of the evidence language. It's also something that was just created as
It's
a
just started.
form that doesn't really reflect any type of special verdict that's really I've seen in any case before. I'm not sure what that is. So the one that I've done, Your Honor, I've done 2 different ones. The distinctions of 2 that I've submitted is page 7 is added with respect to punitive damages. And the other version does not have the punitive damages. Question number 19. That is the only distinction between the 2 versions that I've filed with the court.
Hold on, y'all. Got something
I
on
did give a courtesy copy to counsel. It was filed today at 12:19 a.m. with 2 different verdict forms. I did give it without, I did submit it to the court this morning without the caption of the attorneys, just so it would be somewhat of a neutral form. And I request that one of these be used because the one that they've provided doesn't really follow the usual method. I don't think it even has a signature line. Let's see. No, I withdraw that. It doesn't really cover it the way that's usually done from what I've seen. Thank you.
All right, so I noticed the plaintiff's version has
How are
damages for
you
each
doing
cause of
today? I'm
action,
doing
which
good.
is,
Well, listen to Cardi B's closing
duplicative
arguments.
multiple times over.
Starting fresh.
It
Fresh off
also
the
doesn't
press.
include self-defense, and it also doesn't include,
Fresh off the press, y'all.
what was the other affirmative defense?
Contributory negligence.
Oh, comparative.
Yeah.
Contribute went away on time.
Yeah. Thanks.
All right.
I think
I
Cardi
can
B is
modify it.
there too. Cardi B is there. I believe.
Your Honor, if I may.
Yes.
What we submitted was to simplify the form as much as possible. I believe it even has fewer questions than the plaintiff's form. And that was after our discussion that the previous form was complicated. Which
I hope so.
We believe this is clear cut.
Right, Heather?
It includes all the issues.
So she can do
It
her
should not be
laugh on the
difficult
way out.
for the jury to understand or to answer.
May I respond here?
I'm doing good, Lawson.
So the worst part of
How
it
you
is,
doing, Lawson? I'm doing
again,
good. I can't complain.
states by preponderance of the evidence. That's not usually in a special verdict form. They put that throughout the questions, kind of limiting.
Cardi had
kind
the
of creating
forensic
a
consultator of the Law
way
and
for
Order
the jury to
show
think ahead
on
of
her
time. It
case.
just doesn't make sense to have
Can't
that
get
there.
no better than that.
I can modify
What's up,
mine. I have a printer. I can make changes in a couple of minutes and print out the version the court wants me to print. And the special verdict that I
Everybody come on in.
submitted, I've seen all kinds of attorneys use
Oh,
it.
yeah.
I've never seen this
Yes, you
version.
do. Yeah.
And they would have to change it anyway because of the preponderance of the evidence, and it doesn't really tell the jury how to move along.
Let's
So,
put the
for example,
background on it.
under assault,
So
you have a
people know what we're
question,
talking
yes or
about.
no, and then it says if you answer to question 1 is yes, then answer question 2. If the answer is no, then proceed to question 6. Theirs doesn't have any of that. It's very confusing and has that preponderance of the evidence language. So definitely I would ask that that language be taken out, preponderance of the evidence. And if we could follow more along the lines of a special verdict form, that would possibly make it a better form, but still a little confusing.
Your Honor, as far as the instructions, it's just clearly not true. The verdict form specifically states what the jury is supposed to do after they answer every question. There are other problems with plaintiff's form that would be beyond just little modifications. As you mentioned, the damages issue is very likely to lead to confusion and possibly duplicated damages awards. So if the court is inclined to ask that one of these be modified, we believe it should be this one. And we would, if the court has an issue with the evidence language, we can strike that language. Otherwise, it would be the same.
Can you strike it and print it within
Yes.
the next 5 minutes?
In the next 5 minutes, he wants it. He wants it quick.
Certainly in the next 10 minutes.
10 minutes. Yeah, you gotta go. He wants that quick.
Go ahead.
Why you
So
need it
again,
so
Your Honor,
quick?
the way that they've had it is not the way that the casing instructions read.
Hey, Miss Coco.
Casing
Thank you, Miss
instructions
Coco.
do not read, do not have these boxes.
Use a
It's
tissue to clean your
confusing
eyes,
way.
please.
It doesn't
Oh,
allow
not
the
the
jury to
Q-tip?
really answer
Or a rag,
the
right?
questions. They have to just say yes or no for everything. It doesn't break it down.
You mean don't use the
So, for
don't
example,
use the Q-tip?
They're not able to
I
answer
got you.
the 4 parts of the question. For example, assault, it has 4 parts. And their form does not have the ability, the jury cannot answer the 4 different parts. They have to either go with
I don't-
everything
no, I
or
don't-
nothing. And that's
I don't
not,
have no infection. An eyelash got in my eye. I don't have, there's no big thing going on, y'all. An eyelash got in my eye. I got it out with my finger. I went and got a Q-tip and got the Q-tip to get it out. You know what I'm saying? Then I used the rag. There's no infection. I don't have pink eye. And I don't have gangrene of the eye. Okay? Everything's fine. All right.
not how a special verdict form or any verdict form is done. So I have a printer with me today.
Yeah, I know you
I
do.
can make changes.
I know you do.
I can email it to the court.
I
If
know
the court
you
wants
can.
to do something with it. Their form doesn't cover any of these questions for any of them. Either it's all or nothing.
But you should stop
And that's
picking
not
with
how a
it.
special
The
verdict
more you
form
pick
reads.
with it, the worse
So
it
I
gets.
ask that the court. Well,
I'm just inclined to do a general verdict at this point in time.
I'm willing to accept that. If
Oh,
that's what the court wishes to do,
you
but
said
theirs
a,
is really off
a
base.
general? Yeah, I know.
It
I
does
know,
not
Cindy.
cover
I know.
all the 4 parts.
Thank you, y'all.
Your Honor, there's multiple causes of action. Affirmative defenses that apply to some causes of action but not others. We believe it's important, at least for our appeal rights, among other things, that we have a special verdict form in this case. I'd be happy to work on it.
Well, I mean, actually, I think the defendant's proposed verdict form is the equivalent of a general verdict.
Well,
So they're working on the verdict form
Go ahead.
to get to the
so
jurors.
again, I'm looking at my form here, and first of all, the question is, are we doing the punitive damages question? At least if I can narrow it down to, is the court want number 19 or not?
Well, I'm not inclined to do the plaintiff's version at this point in time.
No, I understand, but I just wanted to know if you wanted to have punitive damages, if that question, because the question is the same.
Your Honor, under the motion to bifurcate, the jury decides
Trying to
entitlement
adjust
to
my
punitive
lighting.
damages.
Exactly. So here's my question on punitive damages in the defense's proposed version. You've got punitive damages attached to negligence. Was that your intention?
Along with the instruction that it cannot be caused, that punitive damages are not awardable if the conduct was by mistake.
I'm sorry, you said you can get
If
punitive damages for negligence?
no, not if it's by mistake.
Her lawyer
Not
is the
the
spirit
Not,
of
no.
confusion.
We don't believe you can.
Okay, so, but you do have a punitive damages question linked to question number 9, which is damages for negligence and comparative.
We can strike out
For
the end of that
negligence?
of 12.
What's the negligence? That you got into an
Here's what
argument?
I want to do. I think the defense version of the verdict form is, for all intents and purposes, a general verdict on each cause of action. I think it's straightforward. I don't think it's confusing. And so the only remaining issue that I have with it is that you've got damages for each section, whereas there's a jury verdict that says that they only decide damages once. So how do we deal with that?
So we did it. We did the form this way just to avoid having to ask questions like, "Did you answer question this? Did you answer question that?" However, if you look at question 7, for example, it says if you already answered question 4, which is the same, skip this question. So the intent is to have only one of those be answered.
Yeah,
And
Shanique,
if you
it's
fill the
coming.
form out,
I
that's
got
fine.
new music coming, y'all.
May I respond to that?
Go ahead.
Each cause of action can have its own separate damages. And that's why in their form it is the way that they have it, and that's why I did the same thing. So I would request that the jury be allowed to break it down on damages and decide what type of damages are for assault and battery. Those are kind of coupled together. They shouldn't be, but they are.
Assault
And then
and
intentional
battery.
infliction of emotional distress.
Assault and battery is a criminal charge. Okay, if you felt like Cardi B assaulted you,
And that
why didn't you call the cops?
arguably kind of makes sense to me. Let's say that they find that the assault was limited to the scratch and nothing more.
This isn't even funny.
That the scratch itself did not cause past or future, maybe isn't going to cause future emotional distress, but they find that the intentional infliction of emotional distress was more.
How many people had a fight in high school and the girl you had a fight with scratched you? Are you living a life of emotional distress from that? I'm just asking for a friend.
Longer lasting.
Right? They got me lost. Right? Emotional distress from a scratch?
For
No,
example,
right?
have you heard?
Go ahead.
The
For
real
example,
Ammani
they may
said
find
no.
that there
Love
was an
said
assault
no.
and battery
David said no.
and no intentional
Risa
infliction of
said
emotional
no.
distress. By removing the damages section, they would never be able to award any damages. So
Now everybody's gonna
That's
be
why I
running around
request,
looking for a celebrity to
at least
scratch them. Scratch me, Chris Brown, scratch
be
me.
left there so that they could give
She's
damages
chasing
to
them
the
dollars.
parts
She
that
surely
they
is.
wish to give, and counsel on both sides can argue.
Here's the bad thing about this. This girl, even if she wins, lose, or draw, right? Anybody that works with her is not going to trust her. I would never work with this girl on nothing. All right? What she's doing, I would never work on. If anybody who knows about this case going to be like, no, I'm good, Ma.
Don't give it twice.
Go on down the street and work with them.
Break it down.
I don't want no lying. As soon as I breathe wrong, now you suing me.
Difficult to separate.
Now you suing me. Talking about I scratched you now.
I understand your position,
No.
but there needs to be some
You
way
on the
of-
do not
of
work
ensuring
list.
that there's not duplicative damages for it.
We'll all be in distress.
Your Honor, they have multiple attorneys on their end. They've created this form. If the court is going to go along with their form, then they should have
So
to
they're
live with the
going
form
over
they
the
created.
jurors' forms,
The
y'all.
form that we've created does not have that risk of duplicative damages. I'm sorry. The other thing is that I think we've already established with the jury instructions that if there are not
I'll whoop.
damages that are avoidable,
You'll whoop that
under some
assification,
constitutional
Mariah. You
I
are
don't
correct.
think that-
I was not
I'm
wondering
sure the
if
court
you
is
see my
still
comments.
in
No,
many
what
cases
did you
where-
say? What'd you say, Chiquita? Because I'm listening and I'm trying to catch the comments. What did you say? I'm sorry about that. I'm listening and I'm going back and forth, so I can't catch every single comment. Hey, D. We'll see. Let me see if I could go back and see what you said. Miss Knockout, I had to come out and back in. Oh, yeah. Yeah, you said you had to come back out and come back in, right?
It is broken down.
one?
There's
Chiquita?
the damages
that
award
comment?
specifically for one cause of action, like in this case, assault and battery, and another one for intentional infliction
Sorry
of
about
emotional
it. Sorry
stress.
about that.
In
Sorry,
closing
Heather.
argument, counsel obviously can argue how this form should be filled out, and as confusing
Just
as
say,
it is
no,
to
don't
me,
stop
I'll
it.
have to just live with
Let
it.
it run.
To take away the damages section in assault and battery would mean that it's too confusing. It should
Hold
be
on, I'm trying to adjust
separate
this
so that the jury can decide whether there should be any damages for assault and battery and any damages for any other cause of action.
Your Honor, we could, in theory, have one question for the damages and just not duplicate them. And that the only difference there would be we would have questions like, did you answer yes to question 3? Did you answer yes? Like what we do
And
with the
adjust
punitive
my
damages.
lighting, y'all.
That would be one way to do it.
That's good, right? She don't have any or before, after. No, she don't got no pictures. No phone. The phone, she threw the whole phone away. Because she knows she
How
was
about we
texting her
modify
friends.
question
I'm gonna
7?
get that money from
What
her.
are Ms. Ellis's damages? If
Right?
you answer question 4,
Yeah.
only include additional damages for this cause of action.
Yeah, it was looking red like the background.
Can we include
Hey,
if any?
Kenneth,
Your
thank you
Honor?
for the share.
If any.
I'm confused. So again, it is very confusing because assault and battery is a separate cause of action and has its own damages component. By leaving the form as is, the jury can then decide if they're going to give any damages for assault and battery.
They can, it's under question 4.
Right, in 4.
Money grab.
And they can do it again for 7. They can do it again for 9. They might not do it in any of them. So that way they're able to break it down and decide what, if any, damages they're going to be awarded. Each cause of action has its own damages award.
Final closing arguments, yes.
But you can't double count.
I'm
I'm
gonna let
not-
it rock
I'm sorry?
because people gotta
You can't
play
double
this back.
count,
So I gotta keep
Double
that.
count, what does that mean?
Meaning include the same emotional distress that
Some comments are
if
being
they
filtered.
find that she has a certain amount of emotional distress, are you asking them to allocate it between the different causes of action or just
No, I'm just straight asking assault and battery. This is what it is. If you find an assault and battery, it should really be separate. Now, let's say we take it as together. We say, was there an assault and battery? And then what are the
Assault
damages
and
for
battery?
assault and battery?
What?
It's really harmful to have it assault and battery combined because the swing that was taken was the assault and the cut to the face was the battery. So we're then limited to one damages. And number 4, we're limited to one set of damages for both assault and battery. So then in my closing, I have to explain that. Same thing, intentional infliction of emotional distress. Separate cause of action, it has its own damages.
Thank you.
Negligence has its own damages.
Your Honor, I believe that, first of all, the addition that you proposed would address that. Not
He
including
did.
something or just including more damages
And the
questions would
receptionist
make
came
everything
out.
more complicated. Another proposal, Your Honor, however, is we could do separate verdict forms.
No, this
One
is
for and
closing
have
argument.
damages only after liability.
Rochelle. Thank you for the follow.
It would make things less complicated.
Thank you, Missy.
Go ahead.
So yeah, separate verdict form complicates it even further. This is a form that defense has prepared. It was well thought out, and it doesn't even break down the 4 different parts of the question. If we're going to live with this, I ask that at least we have those damages for each section.
Thank you.
I'm not going to ask for the same thing 3 times. It's going to be broke. If I'm going to do it, I will break it down. This is worth this, the other is worth the other. It's not the same. So I ask that the form we submit it as is. And just, if the court is going to go along with their form, then at least I would ask that. Thank you.
All right. I'm going to ask that you modify question number 7 to, if the answer to question 4
What happened after all? That's a good darn question.
only include additional damages under this cause of action, if any.
All right, that makes sense. Thank you. And what happens with the other one, Your Honor, number 9? Same thing?
Same thing. Can we do that?
Yes, Your Honor, thank you.
All right.
And Your Honor, will we be giving number 13?
Yes.
Your Honor, just to confirm, question 12, we're going to omit the last 3 words or question 9.
Correct.
Thank you.
All right. There's a request for judicial notice regarding the date of the NBA game.
Yes, there is. I did file that yesterday, and I served it a copy on defense counsel.
And I'm sorry, what was the testimony of the date that the photograph was taken?
Ms. Almanzar stated that that the photo was taken on the date of the NBA All-Star game, which was the date of the accident, the date of the incident of February 24, 2018, about 6:30 p.m. She testified that that's when the photograph was taken, and her nails looked like that on that date. There's no question that the All-Star game was on February 18th of 2018, so it's just a clarification so that the jury is clear of when the game is. This is common knowledge. There's no question about it. I've given different exhibits confirming that the All-Star game was on February 18th of 2018, and that's why I found this.
All right. And for the defense?
Yes, Your Honor. What Mr. Rosen is saying is absolutely false. I'd like to read what my client testified to. Cardi, I'm going to put this in front of you. Cardi, can you please look at this photograph and tell me, do you recognize this? Answer, yes. Question, what's this photograph? Answer, that is me out here in LA at the All-Star Weekend NBA game. Question, does this picture refresh your recollection about what your hair color was that week? Answer, yes. What color was it? Answer, I'll say
Read
like...
more slowly, please.
Sure. Answer, I'll say like an ashy, dirty blonde. Question, can you see your nails in that photo? Answer, yes. Question, were you wearing acrylic nails or some other type? Answer, acrylic. Question, I think you testified yesterday that acrylic nails can last you up to 2 weeks. Is that right? Answer, yes. Question, are those the nails you had the entire time you were in LA? Answer, yes. And I can continue reading, Your Honor, but nowhere
Sorry
does
about
my
that. I had to
client
fix my lighting.
say that this was taken on February 24, 2018.
Thank you,
She
Shalane.
doesn't reference a date.
Hey, Sandra.
And Mr. Rosen represented this to you twice last Wednesday, that the court was advised and everybody was advised that it was on February 24th of 2018.
Layla, this is the most up-to-date recap you're going to get. We're listening to the live closing arguments for the Cardi B trial. It's no more update you could get than that. I mean, after the closing arguments, we will go over certain points of the trial while they're deliberating. But we're getting something firsthand now.
He later said she testified that she got the picture taken on the same day. She testified under oath that at 6 p.m., he just said 6:30, on February 24th, 2018, that this picture was taken. That's absolutely false, Your Honor. I'd be happy to provide a copy of it.
They act like they're going to pay
Transcript to
something.
the court.
She never touched them. She might get something, though. You see,
And one other thing, Your Honor, may I-
Go ahead.
my understanding under California law
She
is
looks
that we
cute
can't
in a
take
polka
judicial
dot
notice of the
dress.
truth of
Yeah.
the contents of a website.
We didn't get
And
that
there's
for
case
you.
law on point I can refer the court to.
Well, I'm not necessarily worried about that. I'm just worried
Oh,
about
you need
whether...
3 more
I don't
followers?
think that there was any representations
Everybody follow
of the
M.
date it was taken.
Follow M,
She did
yo.
just reference it generally, but the substance of the
Follow
testimony
five.
was
Follow
that
5. Follow 5.
she had those nails for the entire time that she was here. So whether it was taken on one day or a different day, I don't think that's material.
This is the judge talking.
Go ahead.
That's the judge talking.
The purpose of this
I
is
like
really
the-
not to make
the judge
anybody
is
right
here.
or wrong. The purpose of judicial notice is just to clarify when the All-Star game took place. And
We doing
the
follow for
second half
follow
of
now?
it is when the photograph was taken. There's overwhelming evidence attached from different news outlets. There's
Everybody
Again,
follow
is
five
it
each other.
material?
Follow five.
The
Everybody
date
follow
she said
five
she
each
had
other.
those nails for the entire week.
Why not
it's
throw one?
material, Your Honor, because the defendant testified that that's what she was wearing later in the day, the exact same day. She had those nails. You have testimony
Oh, she
all
does
over the
look
place
cute.
about the fact
So Cardi B has her hair in an updo. Okay, because we are the updo girls, darling. No, Cardi B got a cute little polka dot dress, just like they came in here and said. She got her hair in a nice little messy bun up top. She looks very professional, okay? She looks very professional. Remember, this is going back from 2018. Cardi B matured a little bit, believe it
this
or not.
photograph was
Since then,
taken
she got kids
on
now.
the same date of the All-Star game,
Changed,
the
she
same
got
day of the
kids.
incident.
Let's listen.
What was the error there is that the All-Star game was on February 18th of 2018, and the court said that we didn't have credible evidence at that time about it, so that's why the judicial notice was prepared so that the court can see for itself. The All-Star game was on February 18th of 2018.
Come on, y'all. Let's tapify. We got 252 people in the room. Miss Knockout is giving you the tea firsthand. Closing arguments in the Cardi B trial. Blessify Miss Knockout so she won't be brokenfied. And I can keep coming here bringing you the hot topics that you love. All right?
Okay. I'm going to deny the request for judicial notice. All right. Are we otherwise ready?
There's one more thing.
Hold on. Let me answer this. Hold on.
You asked, the court asked that I prepare a statement regarding the death of John Sherritt.
Okay. You have that?
Yes, I do. I did give it to the court. It would say plaintiff testified that she treated with John Sherritt MD.
I have to answer my agent. Gotta answer that.
It is undisputed
We work
that
for our
Dr.
money
Sherritt
over
died on
here.
March 5th, 2021.
So Cardi B looks very nice. She has on a polka dot dress. There's rumors that y'all hear that Cardi B might be preggos with the 4th baby. That's another talk about for the other day. But we need to mind like Cardi. So if Cardi B's having a baby, that's what humans do, have babies. People act like it's such as, oh my God, Cardi B's pregnant. This is what humans do, have babies. This is why she's in this predicament. Because we can't mind our business. That's why she's in this predicament right now. Worry about every little thing, everything that Cardi B goes. Oh my God, it's Cardi B. All right, so Cardi B sitting there. She's looking real anxious. She got a real serious face. You want me? Let me turn the camera around. Let me turn the camera around. Stand down over here because we can't do it over here. But over here, okay, let's turn the camera around. All right, let's turn the camera around. And let's look at Cardi B. So this is Cardi B, y'all. This is Cardi B. Okay? That's Cardi B. She got a nice little updo. She got a little polka dot dress. She got Blondie next to her. Okay? And that's what's going on. So, hold on. Let's switch this back. Hold on. All right. So that's how Cardi B looks, y'all. All right. So she looks cute. She looks professional. She looks cute. She looks demure. Okay, let's keep it going. I just wanted to show y'all that.
After a lot of back and forth, what we agreed to, what I agreed to, was that the court could instruct the jury that it is undisputed that Dr. Scher died, period. This March 5th, 2021 date, it's not in evidence. Plaintiff didn't testify to that. She said she understood he died sometime in 2021. She also testified, and we launched the transcripts. I can cite to where in the transcript she says it.
Cardi B is looking like I got to give her some more doggone money.
148 lines 12 through 149 lines 15. Really she says that she went to see a Dr. Scher, and he told her not to have any treatment. So this assertion that plaintiff testified that she treated with John Scher is not supported by the evidence. It is the March 5, 2021 date is not supported by the evidence. The only portion of this that is actually what I agreed to was it is undisputed that Dr. Scher died, period.
So one of the doctors in the case was unalive for whatever reason. They didn't go into that.
But this is what I would propose reading. Plaintiff testified that she treated with John Scher, and D does not dispute that Dr. Scher has passed away.
Your Honor, she did not testify she treated with Dr. Scher. She sought medical treatment. This is page 148, line 12 through 14. Around that time, did you also seek medical treatment from Dr. John Scher? I did.
Look at the hearts.
And then at line 22, and when you saw him, did he advise you that you needed to wait at least 1 year? He did. So, that goes on page 149.
So I will read. Plaintiff sought treatment with John Scher. It does not dispute that he's passed away.
Well, plaintiff testified she sought.
Very good.
Thank you, Your Honor.
What will it read, Your Honor?
Plaintiff testified that she sought treatment with John Scher, and D, it does not dispute that he has passed away.
Thank you, Your Honor.
All right. Now are you ready?
Well, there's a couple things. In my closing argument, I need the verdict form, so I can't start without.
We're working on that.
That in hand. The other thing I wanted to say, Your Honor, is Your Honor did allow me to argue and clarify the NBA All-Star game when it was, the photograph. I want to be very clear that I intend to argue that in my closing.
That's not evidence. I think what you said was they didn't provide the date. And you're fine, you can argue that they didn't properly authenticate the photograph in terms of the date.
Your Honor, the court said that I could argue this in my closing.
You could argue it. You could argue that they didn't establish what the date was.
Follow me.
The All-Star game was on February 18, 2018, the week before.
Thank you, Al. Thank you for this.
The week before the incident. I don't see the harm in that. They can object to that. They can say their version. But that's part of my closing, Your Honor. And this photograph, by the way, this photograph was sprung at the last minute. It was never produced in discovery.
Go ahead.
Just briefly, a couple of questions. First, if you remember, counsel violated a motion to eliminate order. And now he's talking about arguing things that are not evidence, which is completely improper. I don't want to object every 5 minutes to the closing argument. I would ask that at least let me say, if the court doesn't want to tell him, that he has to follow the rules. He can't argue out things that aren't in evidence.
Thank you for
He
the
can't
follow-up
violate
after
the
NTL
motions in
transportation.
I think it's readily apparent that you can't argue facts that aren't in evidence. I think plaintiff's counsel admit he would be violating by intentionally arguing.
Good afternoon, Jess.
If you want to present that and you want to object, then that's how we'll proceed.
Thank you, Your Honor. And
Need
then,
the same, are you done?
then two procedural questions. Does the second monitor work and can it be facing the jury so they can clearly see it?
I don't think so. We're in the middle of a transition and I
Yeah,
don't
she
know.
falling asleep.
Okay. And
We can see it's not.
Your Honor's preference.
And the photos that they did show, she does look a little high.
We have demonstratives and we have
Well,
things we're
she's
going to show.
pregnant.
intend to
That's
show.
her life.
Do we need permission to
That's her life if
to
she's
publish
pregnant.
admitted exhibits?
No.
And do we need permission to publish demonstratives? They have been provided to plaintiff's counsel.
No. And it's argument.
Yeah, okay. I just want to make sure. Thank you, Your Honor.
All right. Anything else from plaintiff's counsel?
Yes, Your Honor. I feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside of the evidence.
I think you just said you were going to.
No, I didn't say I was going to. The court told me that I can argue the issue of the photograph, that it wasn't taken on the day.
Correct. Your position on Wednesday was that they didn't establish the right date, and you can make that argument.
That's exactly what I wanted to do.
Look at that. Look how they
Thank you
changed
very
it.
much, Your Honor.
Look how the light
I must have the verdict form before it starts.
That's cool, right?
They're being printed right now.
Okay. All right. That's good.
All right, everybody, keep blessifying Miss Knockout so she won't be brokified. We're bringing you some hot tea in real time. Okay, y'all, this is the first. It's playing, and the first y'all are hearing it. Okay, so what do you think so far? Okay, so far they brought up an inconsistency. Okay, and on some testifications. All right, each side is going back and forth on how they want the jury form to look. Okay, they were talking about that a lot in the beginning. They have a little bit of a break going on. Okay, let's see. Let's skip this.
Based on the fact that you're all here, I'm assuming no one hit the lotto over the weekend.
Oh man, that lotto, $9
Folks,
billion.
we thank you for your patience. We
What's
did have
the
a
power-
few
what's the
procedural
next
issues that we
Powerball,
needed to
y'all?
address prior to bringing you in. We are now ready to proceed with the last batch of jury instructions. I'll try to give context to these to the extent that it's necessary. I will put them into the package where they belong, but I do need to give these to you. And we're going to relieve the court reporter of her obligations to report these by stipulation of the parties. Okay, here we go. Words alone, however threatening, do not amount to an assault. Aggressive and threatening actions do not constitute an assault unless they were intended to cause immediate, harmful, or offensive contact. If you decide that Ms. Almanzar assaulted or battered Ms. Ellis, you should fine for Ms. Almanzar if you decide that Ms. Almanzar was acting in self-defense. To succeed, Ms. Almanzar must prove both of the following by a preponderance of evidence: that Ms. Almanzar reasonably believed that Ms. Ellis was going to harm her, and that Ms. Almanzar used only the amount of force that was reasonably necessary to protect herself. Ms. Almanzar claims that Ms. Ellis's own negligence caused or contributed to Ms. Ellis's claimed harm. To succeed on this claim, Ms. Almanzar must prove both of the following: that Ms. Ellis was negligent, and that Ms. Ellis's negligence was a substantial factor in causing Ms. Ellis's harm. If Ms. Almanzar proves the above, Ms. Ellis's damages are reduced by your determination of the percentage of Ms. Ellis's responsibility. I will calculate the actual reduction. Ms. Ellis may only establish her claim for negligence if she proves that Ms. Almanzar engaged in negligent conduct that caused Ms. Ellis to suffer physical injuries. If Ms. Ellis can prove that Ms. Almanzar caused her to suffer only emotional injuries, and this is under the negligence cause of action, Ms. Ellis cannot establish her claim for negligence. Emotional distress includes suffering, anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, or shame. Ms. Ellis claims that Ms. Almanzar assaulted her, that Ms. Almanzar acted with the intent to cause harmful or offensive contact, that Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner.
Yeah, she's gonna lose.
Ms. Ellis did not consent to the conduct, that Ms. Ellis was harmed, and that Ms. Almanzar's conduct was a substantial factor in causing Ms. Ellis's harm. A touching is offensive if it offends a reasonable sense of personal dignity. Words alone do not amount to an assault. Outrageous conduct is so extreme that it goes beyond all possible bounds of decency. Conduct is outrageous if a reasonable person would regard the conduct as intolerable in a civilized society. Outrageous conduct does not include insults, threats, indignities, annoyances, hurt feelings, petty oppressions, bad manners, or other trivialities that a reasonable person is expected to endure. Outrageous conduct also does not extend to profanity, obscenity, or abusive language without circumstances of aggravation. In deciding whether defendant's conduct was outrageous, you may consider, among other factors, the following: whether or a relationship that gave her real or apparent power to affect plaintiff's interests, whether defendant knew that plaintiff was particularly vulnerable to emotional distress, and whether Ms. Almanzar knew that her conduct would likely result in harm due to the position of authority. Examples of positions of authority or relationships of power include an employer to his employee, an insurer to its insured, a landlord to his or her tenant, a hospital to its patients, an attorney to his or her client, or a religious institution to its members. Ms. Almanzar acted with reckless disregard in causing Ms. Ellis's emotional distress if Ms. Almanzar knew that emotional distress would probably result from her conduct, or Ms. Almanzar gave little or no thought to the probable effects of her conduct. If you decide that Ammani Ellis suffered damages that will continue for the rest of her life, you must determine how long she will probably live. According to the National Vital Statistics Report, a 32-year-old female is expected to live another 50 years. This is the average life expectancy. Some people live longer, others die sooner. 80? The published information is evidence of how long a person is likely to live, but is not conclusive. In deciding a person's life expectancy, you should also consider, among other factors, that person's health, habits, activities, lifestyle, and occupation. Ms. Ellis seeks damages from Ms. Almanzar under more than one legal theory. However, each item of damages may be awarded only once, regardless of the number of legal theories alleged. You will be asked to decide whether Ms. Almanzar is liable to Ms. Ellis under the following legal theories: battery, assault, intentional infliction of emotional distress, and negligence. Ms. Ellis's claimed damages are recoverable only once under all of the above legal theories. And the verdict form breaks that down for you. The following are specific items of non-economic damages claimed by Ammani Ellis: physical pain, mental suffering, and emotional distress. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. To recover for future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, emotional distress, Ammani Ellis must prove that they are reasonably certain to suffer that harm. For future
Cardi B,
physical pain,
she pregos.
Okay, no, we're fine.
When you pregos, you tired.
For future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, and emotional distress, determine the amount in current dollars paid at the time of the judgment that will compensate Ammani Ellis for that future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, and humiliation, and emotional distress. If you decide that Ms. Almanzar's conduct caused Ms. Ellis's harm, you must decide whether that conduct justifies an award of punitive damages against Ms. Almanzar. The amount of punitive damages, if any, will be decided later. You may award punitive damages against the defendant only if plaintiff proves by clear and convincing evidence that Ms. Almanzar engaged in that conduct with malice, oppression, or fraud. If you define that defendant accidentally harmed plaintiff, punitive damages are whether or not to award punitive damages against the defendant, you may consider whether the defendant's acts were the consequence of a sudden heat of passion that was provoked by plaintiff. Malice means that defendant acted with intent to cause injury, or that a defendant's conduct was despicable and was done with a willful and knowing disregard of the rights or safety of another. A defendant acts with knowing disregard when a defendant is aware of the probable dangerous consequences of her conduct and deliberately fails to avoid those consequences.
That's not the lawyer, that's the
defendant's
judge.
Conduct was despicable.
Nikki, that's not the lawyers. That's the judge giving the criteria of the case of deciding the punitive damages.
And subjected the plaintiff to cruel and unjust hardship in knowing
That's how it works with accident cases. You could get all the surgeries and stuff you want. If you lose an accident case, this is a liability case. If you lose it, no, you don't have to pay those doctors.
Of the plaintiff's rights. Despicable conduct is conduct that is so vile, base, or contemptible that it would be looked down on and despised by reasonable people. Fraud means that the defendant intentionally misrepresented or concealed a material fact and did so intending to harm the plaintiff.
What Misty said?
During the trial, plaintiff testified that she sought treatment from John Scher, MD. It is not in dispute that Dr. Scher has passed away.
Listen, they're speculating Cardi B is allegedly pregnant, right? She's looking chunky. She's looking wide. She's moving like she's pregos, but we just don't know. So she hasn't official. Every pregnancy she had, she just said it at the right time. She didn't say it right out. You know what I'm saying? So Cardi B is tired, you know, but she's very family orientated. That's why she's having all these babies. It's very family
oriented. All right, ladies and gentlemen, that concludes the additional jury instruction, and we're back on the record with the court reporter. That concludes the additional jury instructions that we are adding to those instructions that I previously read. At the attorneys to give you their closing arguments. Please keep in mind my instructions regarding the facts in this case. You are the ones who are to determine the facts. And to the extent that the attorneys argue facts that you do not believe were proven during the trial, please rely on your own finding of what the facts are. And similarly, to the extent that the attorneys argue law that is contrary to the law that I've just given you, please rely on the law that I gave you. And with that, is Plaintiff prepared to give your closing argument?
Come on, y'all. Blessify Miss Knockout. 315 people in the room. You're getting a lot of hot topics here today. So blessify Miss Knockout so she can keep bringing you these hot topics. What you got a question about, Latina Doll? What you got a question about? All right, we're listening to Cardi B's arguments. It looked like they took a little break. All right, so let's move ahead. Let's move ahead. Okay, let's get it.
And just for any members of the gallery, if you are not a member of the press and you don't have a sheriff's badge as well, you're not allowed to use any electronic devices or phones. Thank you for that.
So now I learned something new. So he said if you don't have a badge, you know, they give you like I guess that's the press pass equivalent to that down there, right? You can't record. But if you do have a badge, see, I wish I would have made it to that case. Because I would have definitely got me a badge to that case. And I would have been able to record. Right? You could record, see, Diddy's case. If you was able to record Diddy's case, woo! Wow! But you can't, that's federal.
So at this point, both sides will be giving our closing argument. Just so you can jot down things, take notes if you feel comfortable. So you all heard all of the evidence in this case. And the distinction between a civil case and a criminal...
So now, they got all the preliminary stuff out of the way. Now he's talking to the jury. Let's listen.
Case are different. And what that means is in a civil case, our proof, what has to be in the box, is greater than 50%. Touch more than 50%, maybe a featherweight more than 50%. 51%. It's not 100%. The standard is a little bit more than 50%.
In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified. Those three witnesses explained their recollection about the scar. There was testimony that the scar or the cut came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything, our expert witness, Dr. Mulliken, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And his testimony was that, in his opinion, as an expert, that when the way that this scar, the way that this cut happened was from fingernails. And that there were 3 different scrapes, 3 different scratches. And that the middle one...
Because that's the doctor that's working with you, sir.
Was the deepest one. And that's really the one that he worked on. Now, the issue in this case...
He had no proof either. And he's well respected. Look at that, Chile.
Before I go to that, is the photograph that you saw.
You can't trust nobody.
Which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos. The cut that was on the face.
Okay, so Panther said, Pam Hart says, y'all want Cardi B to get off? It's not about Cardi B getting off. It's about, well, Cardi B, I don't care if you like her. A lot of people just don't like certain celebrities. So I don't care what it is, whether they could be dead in the right and people be like, yo, no, take her money, right? This is not about Cardi B getting off. This is not a criminal case, okay? This is whether Cardi B owes this girl money for a nail scratch that she can't prove and we never seen. This is what this is about. So do you think Cardi B should get off? On that note, do you think Cardi B should get off? Yes or no? Cardi B's going to a case, to her doctor's appointment, minding her business with culture in her belly. And the security guards on the phone going, oh my God, Cardi B is here. Cardi B is here. Oh my God, it's Cardi B. It's Cardi B. Right? Thank you, Most. And Cardi B's like, are you filming me? And she goes, oh my bad, holding the phone like this. Cardi B is here. Then she went like this. Then she said, oh my bad. And it went up from there. So it's not about Cardi B getting off. It's about whether this girl deserves $24 million after throwing her phone in the garbage, showing us an invisible cut, saying that she has all this stuff that this doctor I just played said that she's fabricating. Invasion of HIPAA, in which she got fired before, allegedly. But they said that she didn't get fired for the HIPAA for Cardi. But I believe that's her people saying that. So then whose HIPAA did you get fired for, Ammani? Because remember, people plant stuff in the media. So we can't go by nothing. We only go by our intellect and what we research now in these days. Because we can't believe nothing we see, hear, nothing. Right? $0 for a security guard. Girl should go for Talia. Yeah, Cardi B might counteract this after this. Let's get back to it, y'all. I had to stop and address that. Because it's not about Cardi B getting off. It's about, does Cardi B owe this girl $24 million or any dollar? Does she owe her a penny? We're about to see. Let's listen, y'all.
Does not show up as well.
Everybody
so you may have to really look at it.
Let's get to 100K,
deeper
y'all.
Than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand it. The defendant came here, used all of this foul language. This is a court of law.
You cannot speak this way in a court. I have never seen this before. And for her to use all of...
Wait a minute. So you asked Cardi B what exactly she said to the girl. She asked you, can you say it? So they using that against her. I don't like this lawyer. This lawyer is foul. This lawyer is foul. You coerced her into cursing, and not only did you coerce her into cursifying, you said, say it to the client. Do y'all remember that he said to say it to the client's face? Thank you, Precious. Do y'all remember that? He asked her specifically to exactly say what she said that day. That's right. So they baited her into cursing, and they're using it against her. Check that out. These lawyers is like foul. These lawyers is foul. They trying to get that $7 million. Sir, I hope you don't get a dime. Let's continue to listen. Let me run it back. Let's run it back. Listen, y'all. Listen, y'all. This is juicy. Thank you for the blessification. Everybody blessify Miss Knockout. Let's get this. You keep the tea going. Keep the community going. Blessify Miss Knockout so she won't be brokified. She could come back and bring you these hot topics and this entertainment. Let's continue.
You may have to really look at it.
This is Ammani's lawyer.
Than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in a court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words, it's a disrespect to us. It's a disrespect to the judge. It's disrespect to this courthouse. You cannot come to court and...
Now, Cardi B is going like this. Cardi B is in court right now. She's like, she can't believe that they're using that against cursing. They coerced Cardi B into cursing. They said, say exactly what she said to the defendant, to the plaintiff in the incident. And she said exactly what she said. She even, if I'm not mistaken, asked them, could she curse? Didn't she? Did she ask them, could she curse, y'all? Who remembers that? Because we're going to play it again after this. We're going to play it again. Okay, let us hear it. I got to commentate, Lucci, I got to commentate because it's my channel. If TikTok hears me playing stuff and I'm not speaking every once in a while, they'll mark me as fake engagement. So I got to talk sometime. I can't just run and get restrictions all day.
Say these kind of words. It's just disrespectful. And just because Miss Ellis, just because Miss Almanzar, also known as Cardi B, is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people.
She did say, excuse my language.
If you recall, just to give you a little bit of background about Miss Ellis. When she was 19 years old, she moved out of her house. She went to college.
She did.
She's a college graduate. She has a bachelor's degree. She went on to become a security guard for 4 years, from 2014 to 2018. She did whatever she needed to do to become a licensed security guard. And she did that job. And when this incident happened in 2018, that was cut off. She lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman.
Ammani's lawyers.
He complimented me. Maybe he's doing that because
Ammani's lawyers speaking now.
To say, to twist everything. But the point is, he got $40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury.
So that was the guy, the doctor that I was just playing. He's saying that he got paid $40,000, right, to come here and say that she was fabricating. That's the one I just played. But how much your doctors got paid? That other doctor said he makes $500 an hour. The one who did the little micro needing on that invisible.
That's not the facts. The facts are Ammani Ellis was working as security guard. There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss Ammani Ellis suffered.
Hold up, y'all. Sorry about that.
Now, in this case, there was overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that this person was a security guard. And there has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you got to do this, you got to do that, please leave the building, different commands were given to her, which none were followed. They were all ignored.
Why should she leave the building when she's going to her doctor's appointment and the girl started following and groupifying and wigging out because of her? Why should she leave? Weak, right? Weak.
Instead, the defendant thought that, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her head at the time, and she's testified to those.
It wasn't no thoughts. It was actually happening, sir. It wasn't thoughts.
However, that's not the case. Miss Ellis testified that she's never had a fight before. She's never done anything to harm anybody. She's never had any fight with anybody. And her mother and her grandmother also testified. She's a model citizen. She's a hardworking person, and she simply...
grabbing money.
Her whole goal of doing this,
she's a money grabber.
To be here and sit here and go through this, is so she could move on with her life. Sometimes people have to be heard. So by you all being here and hearing everything that's gone on, you have given her a sense of closure where she can move on and go on to the next step and the next phase. She's only 32 years old, and she has plans. She has plans to do other things in her life. So we're very thankful that you gave us that opportunity. Each and every one of you, we're very thankful. The other thing I wanted to mention is the phone. It would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And the error message that you would get if you tried it is recording video is not available while on a call. So it couldn't be. The two of them couldn't be done at the same time.
Let's get to 200K, y'all. 200K.
Miss Ellis told Cardi B multiple times, I am not recording you. I am not telling anybody that
Ammani Ellis is a security guard that's suing Cardi B. We are listening to the closing arguments of Cardi B's trial. Everybody that's not pulled up to speed after this is over and going into tomorrow, we'll be going over the whole trial while they're deliberating. But this is the closing arguments, okay? Don't worry, I'll catch you up.
Now
here comes Alexander in the live talking about he's going to give somebody that he don't know from a can of paint $5,000. You're almost as bad as Ammani. Don't fall for that, y'all. Thank you, go girl. Thank you. All right, let's continue on. I just don't want nobody to be lost. All right, hold on. Hold on, y'all. I don't want nobody to be lost. So let's get back. Hold on, y'all. Here we go.
Here, I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almanzar, Cardi B, got angry and started yelling and cursing and
thank you, Jessica. Thank you.
Spitting on Miss Ellis and calling her different words, using the N-word. The district.
Cardi B said she didn't spit on her. The receptionist said she never seen her spit on her. And the doctor said she never spit on her. But ironically, they said, oh, they came out in those 2 seconds before they came out. She hurried up and spit on her. And when she came out, she didn't. Come on now. Come on.
Respect her, calling her the B word, calling her fat, anything to try to trigger her and make her upset and embarrass her. Sometimes words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher a sentence that basically it's undisputed Dr. Scher died.
Trisha!
And Miss Ellis basically testified that initially, a couple months after the incident,
it was me, Trisha. It was me.
She saw Dr. McKenzie, a psychologist.
I was glitching out there.
Through her workers' compensation.
I'll call you after this.
She was given that. She got 7 visits with that doctor.
No pictures, no photos.
During that time, she also saw Dr.
Everybody that's just coming in, joining us, we are listening to the Cardi B closing arguments trial live and direct in real time.
Dr. Scher, who was another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some sense of fairness. Why there's no records from Dr. Scher.
Objection, Your Honor.
Thank you, Jessica. Let's tapify y'all. And everybody,
then we learned throughout the case that
we got 500 people here. Y'all getting tea. Not too many people are covering this like this. Everybody blessify Miss Knockout so she can keep coming here, bringing you the hottest topics, hottest entertainment. Let's go. Cardi B closing arguments. Everybody that's new.
When Cardi B came to the building,
thank you, you go girl.
She caused a disturbance. She caused a disturbance.
That's
she was
right,
yelling and
Carla.
screaming at the top of her lungs, going crazy, yelling and screaming to the point where 2 other witnesses, Miss Malcolm, which was the secretary of the doctor, and Dr. David Finke, was so loud that
they showed the pictures, Chantel. I ain't seen not one scar, Chantel. I ain't gonna lie. Can anybody in here tell me different? Because I don't know. Maybe my eyes are off. But they showed those pictures. I don't see shit.
Those 2 people came out after about 40 to 50 seconds. Now, the issue with that is those 2 witnesses didn't see the 4 things that happened before that, which happened in the 40 to 50 seconds before. So, yes, they're witnesses, but they're not witnesses to that first part, that first segment, which would include taking a swing at Miss Ellis, spitting on Miss Ellis, calling her the N-word, and ultimately cutting her face. None of that was seen by those 2 witnesses. So yeah, they're witnesses, but they're witnesses to the aftermath. They're witnesses to what happened afterwards. They're not eyewitnesses. They don't know what really happened. And when they arrived, Miss Ellis was so upset. Can you imagine all those 4 things happening, being disrespected, embarrassed, who knows what else happened? All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure. I mean, naturally, she was angry, she was emotional. So when these 2 witnesses come out of their offices, they can only see an angry person.
No camera footage.
They didn't see what led up to that. And they had assumed that it's her fault, maybe, or that she did something wrong. But again, those 2 witnesses didn't really see much. They saw something after the fact. And then you have Miss Malcolm, who decided on her own, this was her choice, to squeeze herself in between the 2 people. Well, that's a risk that she took. And if she somehow got a cut to her face or a scratch or something.
Somehow.
Well, we don't know who did that. We really don't know. She didn't even know. Miss Malcolm testified that she did not know who scratched her face. She has no idea. What does that mean? Could be from either one. Could be from the commotion that's going on. These things
So now he's talking about the receptionist. So the receptionist's name is Tierra. I gotta commentate, y'all, because this is my channel. All right, I can't just let the thing play and then TikTok starts, restricting me for faking, Anyway, now he's talking about Tierra. Right now, Tierra actually got a scratch on her face because she went in. She works for the doctor's office. She's the receptionist, right? Thank you, Jessica. And she actually got a face cut. But what he's saying is the Tierra face cut. She don't know if she got it from Cardi B or from Ammani, trying to make Cardi B look bad again, like she scratched a receptionist's face. But the receptionist said that Ammani reached out to her to get down with the case. So she wanted the receptionist who actually got cut in the face to get down with the lawsuit, and the receptionist declined. Why? In her own words, she said it's because she felt like Ammani was in the wrong. Oops. Another thing that's tarnishing her case. Let's keep it going.
It happened so fast, we have no real idea as to what really happened. Unfortunately, there was no video camera there. There was no other witnesses that actually saw it.
Right,
so it really comes down to one thing. Do you believe Miss Ellis?
She ain't got money like that to get no good lawyer like that.
Why not? You should.
Look, she didn't do her. I feel like Ammani didn't do her research right. She should have searched for a better lawyer too.
Hard-working security guard. She was doing her job with no prior anything.
Thank you for the follow, Toggle. She wanted her to join the payout, but she didn't.
At some point during the trial, the defendant
Thank you for the follow.
showed you Exhibit 232. If you all remember this photograph, Exhibit 232. This is a photograph. Now, the issue with this photograph is there's really no way to know the date that this photograph was taken. There's no way to know. We don't know when it was taken.
Objection.
There is no proof
Thank you, Rhonda, for the follow.
of when this
Thank you,
photograph
Walker,
was
for the
taken. It
follow.
could have been taken at any time, before or after the incident. It could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident.
Objection, Your Honor.
That was her testimony. But where's the proof?
So this is still Ammani's lawyer. They have a certain photo that was taken that day. It probably has her with no scratches on her face. So he's saying, we don't know when this photo was taken.
Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken at the All-Star, NBA All-Star game. There's no proof of that anywhere. That's just false. There is proof.
So she had a picture where she went out. See, that's why you can't be going out and stuff when you got a case. But they caught a picture of her and stuff at somewhere at an NBA All-Star game, and she had no scratches. So he's saying, oh, it's no proof of when this was, or when it's It's no proof. Okay, sir.
Proof of when this photograph was taken.
Yes, she
It just wasn't given to us. It wasn't.
She does have bodyguards, and that's a good thing to bring up, Miss Crestow. She does have bodyguards, but when she testified, she said she didn't want this guy to come up with her to walk her up to the GYN's door. She said there's certain things you got to keep private as a woman. So the bodyguard was waiting downstairs for her. Okay? That's Ammani's lawyer talking. The bodyguard was waiting downstairs for her. All right? She didn't want the guy to go up and say, she wanted to keep that private. You can't let the bodyguard, you're going to let the bodyguard go with you in the toilet too? So that's why the bodyguard wasn't with him right there. Okay, let's
provide it to us. So we can't rely on this photograph because there's no date on this photograph.
Cardi B's like this now. BS. No, Cardi B's not in jail. It's not criminal. It's civil, Mountain. This is a civil case. This is about that money, 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 money. Okay, so now they're shuffling papers and taking a little break. Hopefully he's finished because he's tired and he makes no sense. Okay, so was that closing argument, was it believable? Yes. Not believable? No. Was it believable? Yes or not believable?
Miss Ellis did is she
going.
made an incident report.
No.
2 days after the incident, Miss Ellis wrote an email to her boss and followed what she was supposed to do to explain all of the details of what happened to her. No. She did follow company policy and did what they asked her to do. She called her supervisor, made an incident report, and did everything possible to document all.
Tanya, imagine if I had a channel and I just played the somebody else's material that we're listening to, and I never talked. Do you know TikTok restricts you for just being silent as no engagement and fake engagement? Do you know that? So I gotta talk sometime. I don't want to keep stopping and explaining this. You know what I'm saying? I gotta have some kind of commentary on it because it's my channel. I can't just play it straight through, you know what I'm saying, and then watch the restrictions come. All right? But I'll play it as much as I can.
All of the different things that happened to her on that day of February 24th, 2018. The other important issue is Cardi B testified that she came to the building, at least downstairs at the building. She had a security guard with her, Mr. Newton.
Michelle? Thank you.
Mr. Newton, that's her security guard.
Thank you for the orange hearts.
He didn't testify in this case. Why not?
Thank you, Wendy.
Where is he? Disappeared? Miss Ellis testified that when she saw this security guard downstairs in the lobby, she met with him there. Mr. Newton apologized for what happened. Mr. Newton should have testified in this case and could have testified in this case. But
no, he's saying that her lawyer is saying that, Ammani's lawyer is saying that they have this picture of her out at an event, but nobody knows when the time and event was taken. They don't know if it was after the incident, before it. You can't tell when it's taken. So I'm guessing, and we will go back over this, like I said, that Ammani went out somewhere and they produced a picture of her and she probably had no scars. You know what I'm saying?
he didn't. And there is a jury instruction, KC Jury Instruction 203, which deals with a party having power to produce better evidence. The jury instruction states, you may consider the ability of each party to provide evidence.
I'll
if the party
stop it when I
provided
talk,
weaker
so
evidence when it could have provided stronger evidence, you may distrust the weaker evidence. That's what the law is. So, where is Mr. Newton? I don't know.
Thank you, Astro.
He was on the witness list. He should have came here and testified.
Thank you for the follow, Morgan. Thank you, Bridget, for the roses.
Another important fact is, if a witness
okay, that's them cutting out.
is not credible on one point, you can disregard their entire testimony.
Thank you, Cora.
When you go back into the jury room, you will have all of these different jury instructions.
Party lawyers coming up
and
next.
Each jury instruction will be there for you, where you can read and understand what the law is and how it applies to this case.
Thank you for the following.
And as I told you before, testimony is evidence.
Right, Carla.
Before, testimony is evidence, and you can rely on testimony alone to come up with your verdict. KC 107 states, do not make any decision
Thank you for the follow, Shade.
simply because there were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness is enough to prove a fact. So in this case, you've heard from different witnesses. Just because one side may have more witnesses or less, that's not how it works. One witness is sufficient to prove a fact.
Thank you, AQ. That's how it is. It's a dirty world out there. Yes, it is, Yo-Yo. It's a dirty world.
You initially heard that Ms. Ellis saw Dr. Nicole McKenzie. Dr. McKenzie testified. She's a psychologist. She treated the patient in her office, between her and other providers in her office, a total of 7 visits for a period of 8 months. Ms. Ellis did seek psychological care and received it.
This judge is so over.
She also, as I said, went to Dr. Scher. Dr. Scher advised her that he could not do the plastic surgery for a couple reasons. One is you have to wait at least a year. You have to wait at least 1 year, 1 to 2 years, to determine if the scar will become a keloid. I'm sorry, if the cut will become a keloid, if it will become a scar. Sometimes it may go away on its own. In this case,
that's not true, because when I had my when I had breast cancer treatment and they gave me a lift, my breast keloided a few months after that. So that is not true in all cases. Everybody got different.
It did not go away. After that time period, if we all remember that in April of 2020, the pandemic occurred. We had this pandemic outbreak where everything was closed. You can't just go and have elective surgery. So the case was delayed. Medical treatment was delayed. That's why Miss Ellis waited. Another factor is affordability. She had to find a doctor. We had to help her find a doctor that was willing to work on a lean basis. Dr. Mulliken testified that he would agree that he treated her on a lean basis. What that means is she still owes the money. However, in a court case, what happens is the doctor will agree to treat the patient and delay payment. They delay getting paid. That's what Dr. Mulliken did.
She had an outpatient disease.
Dr. Mulliken testified that he fully examined Miss Ellis.
She says a scratch, but
he then
I don't
decided,
see anything
with his expertise as a board-certified plastic surgeon, that it would be beneficial for Miss Ellis to have plastic surgery and have this done in a surgery center. 2 different surgeries were done over a period of 3 to 4 months, so that Miss Ellis could. There were 2 issues. She had hypersensitivity, a little bit of hypersensitivity, and also, as a woman, she doesn't want to have a scar to her face. And all the time, every day, waking up in the morning, looking in the mirror, remembering the event, it reminded her. It does remind.
As a woman, as a person, you don't want to have a mark on your face. What are you talking about? Thank you, Janima. Thank you, Janima.
Now, the defendant had the ability to hire their own plastic surgeon and have their own expert witness.
I'm sorry.
And in this case, the defendant decided not to hire one. So what does that mean? What that means is you really got to take what Dr. Mulliken says with a lot of importance, a lot of truth. There is no other doctor from the defense side.
Don't tell us what to take it
as, sir. And have them testify here.
Who are you?
And tell us, yeah, Dr. Mulliken's work is no good, or she could have done something different, but we don't have that here. You have one doctor on the plaintiff's side basically explaining all of his expert opinions. And he's a board-certified plastic surgeon for 30 years.
Cardi could sue Ammani, but she don't have anything worth suing for. Well, she can actually countersue her for defamation of character. She can prove of certain things that she liedified in court. If I was Cardi B, they probably didn't have time, I don't know, But I would have pulled those phone records and those iCloud records and stuff like that. But I don't know.
Affiliated with UCLA.
Right. A lot of things Cardi could sue for. Thank you, Trina.
In his career currently does teach medical students at UCLA to help them in their careers of becoming plastic surgeons themselves.
Perjury. Right, Goddess? Perjury. Hey, Trina.
Now, when you go back...
She's spicy. She gets spicy.
When you go back into
one doctor who says she was mental
jury room, you will see Dr. Mulliken's records and bills that are part of this case. They've been admitted into evidence, and you will see his medical report, and you will see his medical bills. Those are admitted into evidence. You'll have that in the jury room.
Well, Ammani doesn't have anything worth. I agree with you, Naoshi, but that don't mean that they can't make an example out of you. See, the point is to sue. Some people sue people and put judgments on people that don't got no money to make an example out of her. Don't mess with me. And that's a big example to learn, honey.
So you can see it for yourself.
Cardi B likes making examples out of people. So I don't know. She would do it just to do it, Brown.
And if you remember, even Dr. Rosenberg had testified that he has seen Dr. Mulliken in other cases. He's been an expert in other cases, working alongside Dr. Mulliken. And this is a very well-respected doctor. He went to Yale Medical School. Even Dr. Rosenberg testified that he had impressive credentials. He acknowledged that fact. And the other thing that I wanted to discuss would be the fingernails. Cardi B testified that most of the time she would have long fingernails of 3 inches. That's her style.
She's wearing like a black or navy blue polka dot dress.
In this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing. And he basically said he remembers the rhinestones, that they were protruding.
We need to go back
they were raised.
Hey, sexy queen. Hey, my queen. I didn't mean it. Oh, it's all good, y'all. It's all good. Just take yourself out the box.
When Cardi B testified...
We'll bring up people for questions.
She
afterwards
acknowledged that she refused to listen to Miss Ellis, who was the security guard on duty at the time. There was also testimony by Cardi B that the two of them were chest to chest touching. This was a touching that Miss Ellis didn't want. Miss Ellis didn't want to be connected to Cardi B physically, but Cardi B made that happen, and that's an unlawful touching.
Thank you, JP.
That alone, aside from the rest, that alone, Cardi B admitted to that fact. She said, that is what I did. I was chest to chest with Miss Ellis. Cardi B even testified that she was yelling and screaming so much that she acknowledged that it was possible that her spit went on to Miss Ellis. That was in the testimony.
She didn't exactly say that, sir. She didn't exactly say that. You coerced her into saying that. He said,
when Miss Ellis,
could it be possible when you're talking, spit could fly on the other person? Of course. Is she going to say, yes, it's possible? See how you turning stuff around?
Told Cardi B to leave the building. She should have left the building. Miss Ellis was hired by the owner of the building to keep the building secure and safe for tenants and other patients and visitors. Cardi B refused to listen to the security guard who was working there.
Cardi B is dozing off. She trying to
at
stay
some
away.
point, Cardi B caused such a disturbance that what she was doing was a trespassing. You cannot.
Cardi B was dozing off for about a good 5 minutes, and she had to wake herself up and readjust herself. You know, there's rumors out that she's pregos, and when you're pregos, you're tired a lot of the time.
On the property, when the owner or an extension of the owner tells you have to leave, you have to leave.
She got into a back and forth with this girl, and the girl is suing her for $24 million, mama.
Miss Ellis's mother, Leanne Schmidt, testified.
Thank you,
She testified that Miss Ellis obtained the scar to her left cheek as a result of this incident.
Objection, Your Honor.
Miss Ellis's mother testified that she recalled seeing the scar after this incident.
I will not.
Miss Ellis's mother testified that she.
But you can't help it if you're pregnant, DeGonzo. Sometimes you can't help falling asleep. You know what I'm saying? As a woman, pregnant women can out there tell you that, you know, you get really tired when you pregos. Not saying that I know she's pregos, but also her lifestyle. She's in the studio. She's Cardi B. She has other obligations besides court. You know?
Saw.
Talking all the time.
Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar after this incident, and that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars in this type of movement. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when when Miss Ellis went to Kaiser Permanente for vaginal discharge. In 2020,
Ammani Ellis's lawyer's closing statements. That's what
Dr. Rosenberg testified that there was an inconsistency when Miss Ellis went to Kaiser and didn't tell them about her emotional injuries. Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon, they tell them about their neck pain, their back pain, their left foot pain, left ankle pain.
What's the point, sir?
This idea that every time you go to a doctor, no matter what specialty, you have to cover all these things is not real. It's not real life. Some of the doctors will even say, don't tell me, I don't want to know. I'm not writing it down. Yes, sir. We've all gone to doctors, and we all know when we go to a specialist, we'll focus on why we're there. Miss Ellis went to Kaiser Permanente Hospital for vaginal discharge.
So Neoshi said that's BS. I worked in the medical field. They address mental illness at all appointments.
Charged in 2022, and different things throughout her time there. She didn't go there for emotional injuries. She didn't go to the psychiatric care there. She didn't get any psychological care
I know, right?
there. None of that.
He's boring me. He's
psychiatric care there. She didn't get any psychological care there. None of that. So for Dr. Rosenberg to sit there and tell us there's inconsistencies because in Kaiser she didn't tell him about the emotional injuries, it just doesn't make sense. I want to talk a little bit more about Miss Malcolm. So I just want to remind you that when Miss Malcolm came out, 40 to 50 seconds had already transpired.
I'm good.
She came to the aftermath. I know I've already said that, but I really want to hammer this home, that she is not a witness to what happened before. It's like a car accident. There's two cars, they have an accident. If a third car comes down the road a minute later and hits them, it's completely different. It has nothing to do with it. So that was inserted into this case in a sense, to muddy the waters, to kind of cloud what really happened. What really happened here in this case is Miss Ellis was working as a security guard. She had to be there. She was working there as a security guard. And Cardi B came along.
So Linda, that won't be he's right. Linda, that would be he's wrong, because he's saying when you go to other doctors, they don't ask you about mental illness. So according to that, then he will be wrong. Because he's saying the opposite of what you're saying, Linda. He's saying that when you go to different doctors, they don't ask you about mental illness and this and that. So he's saying the opposite. Thank you, Charlie.
And thought she's above the law. She could do and say whatever she wants and attack Miss Ellis emotionally, physically, and do whatever she wants in a building which is inappropriate. We all know that when we go to a building, you got to be respectful, especially to security guards that are working there. These are not just doormen or doorwomen opening the door for you. You have to follow along with what they say. Next, we heard from Dr. Finke. I want to talk about inconsistencies. There was an inconsistency between Malcolm and Finke. Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finke comes out and says that Malcolm told him that Ellis had scratched her face. That's not true. That was never said. So this, if you remember, this is a 7.5-year-old incident, and that's a few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently by different people. So Miss Malcolm could have perceived it one way, and Dr. Finke could have perceived it one way. But again, same problem with him is when he came, everything already been done. The whole incident already happened. The injury was already complete. And really, this comes down to believing Miss Ellis. He gave you no reason not to. She's been truthful through me and through herself and through her witnesses to give you whatever is there, to provide for you all that she could with the things that she has available to her, so that you could give her the peace of mind, the closure, and yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating her with money damages, you're then evening the playing field. You're giving her what she lost back. So she's not trying to gain something that she's not entitled to. Unfortunately, she was abused, she was harmed, she was assaulted and battered by Cardi B, and Cardi B needs to pay for that and needs to be accountable. We need to hold her accountable. We should not just let her walk away and say, oh, everything you did was okay, and yeah, do it again.
Paul. Thank you.
Now, in addition to seeing the two plastic surgeons and Dr. McKinsey, Miss Ellis also received another 12 visits. She testified that she saw psychologist Dr. Avila and other people in his office.
Violation of the court's order.
Move on.
What's a violation of the court's order? Reaching real hard, official. You reaching.
The other thing that Cardi B failed to do, or could have done, is she could have filed a cross complaint.
Objection, Your Honor.
I think she's going to do it afterwards. And which is smart.
All right. And then
the reason why I think if Cardi B does a cross counter sue, it would be smart to do it afterwards, because they're going to consider all the testimony in this trial. They're going to consider all the flubs, all the miscommunicational fabrication of things. They're going to consider all of that. If she countersued her while it was going on, then it would probably be going on simultaneously. No, she want to get some of this in the trial. That's what she doing. Watch and see.
I want to go over a little bit about the medical bills. So you don't have to get it exact. Doesn't have to be.
The girl says she scratched her. She wants $24 million. That's
The exact number. But there was testimony in this case that Miss Ellis had $17,500 in medical bills from Dr. Mulliken, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things.
Workers' comp. For a job you got fired by?
There was also testimony from Dr. Mulliken that he believed Miss Ellis could benefit from one more surgical procedure. Another one. To make
Again, in the range, which
the cost of that
you see here in the text.
$15,000.
Objection here.
Another surgical
The $15,000.
Another surgical procedure for a scratch that nobody can see. Is that wild work or what? You know what I'm saying? Let's keep going. Wow.
That would be paid for that.
Workers' comp denied her.
Would,
Said no PSTD.
in Dr. Mulliken's expert opinion, it would make the scar better, meaning it would reduce.
Neoshi. Stop it, Neoshi. Kalila
Basically, what I'm saying is there's still some scar on her face. And if you want to look at it, you're more than welcome. You can have her walk around. You can look at it for yourself. There is still some scar on her face.
So I'm on Cardi B's side. No, I'm not on Cardi B's side. I'm listening to the same thing you saying, right? I'm listening to the same thing you're saying and giving an opinion. So I'm supposed to sit here and not have commentary, and every time they say something that's outlandish, be quiet? That doesn't mean I'm on Cardi B. This is a civil suit, first of all. It's not a criminal suit, right? So there's no sides. Actually, it's about, did Cardi B scratch her, and does she deserve $24 million? That's what she's about. So don't come in here attackifying me because the Diddy trial is over, and you can't attack me because I'm not out there no more. So now you scrambling to twist and turn something in here. You know what I'm saying? I'm reporting the news and I'm commentating, and I said what the F I said. Now, if you want to say I'm on somebody's side, then that's your thoughts. I'm simply giving my views on the news. Okay? Let's continue.
Still there. It still bothers her. So that's why I'm asking that not only you give her the $17,500 in her past medical bills for the scar, that you give her another $15,000.
I like playing with them.
For the future scar revision treatment. She didn't deserve this. She didn't deserve to be scratched and cut and spit on and all these things. All of the things that happened to Miss Ellis are they're wrong. And we want to make this wrong right.
Thank you, Martha.
And how can we do that? Through each one of you. You have the power to make this wrong right and close the books for Miss Ellis so she can move on with her life as much as she possibly
can. We don't want to close the books. He said not close the books.
And yes, the only way to do that right now for today's purposes is to reimburse her for the losses that she sustained. Those are the medical bills, the past, and the future. The other thing that is an important way of compensating Miss Ellis is for her pain and suffering.
Yes,
in every case where there's medical bills and there's medical damages, a component of that is pain and suffering. There is really no way, there's no exact math to that. So for instance, if you said, I want to give her the $17,500, I want to give her the $15,000, and I want to give her another $250,000 for pain and suffering. You are allowed to do that. It is a number that you can come up with. During the 7.5 years that she's been suffering, you may say, I would like to give her $100 a day. For 1 year, that's $36,000. And for 7 years, that comes up to $270,000. We're not looking for millions of dollars like the defendant said. That's not what we're looking for. We're really looking for a simple amount of money that can make her whole, give her something that's fair so she can get some form of compensation, some form of closure, and move on with her life. That is all we're asking you to do.
All right, he's shuffling papers. We're going to continue. This is Cardi B's case. This is closing arguments, and this is Ammani Ellis's lawyer. And another thing you said, that I'm attacking black people. Let's see what your name is again. I screenshotted it. How am I? This is not a racial thing. This is not a racial thing. How am I attacking black people when I'm just repeating stuff that's in the trial? You know what I'm saying? And pointing out inconsistencies. How is that an attack on black people? Don't come in here and try to make me look bad because I got 700 people in the room and I'm able to hold my numbers. I mean, don't get mad at me and try to come in here and be turning people against me because we ain't paying it no mind. I just want to clarify it though. You know what I'm saying? But let's go on. So this is still Ammani's lawyer. All right. Closing arguments. Let's continue to listen. He's shuffling papers though. He's looking for stuff. He's looking. Hey, Christina. Yeah, don't say I'm attacking my people because I'm the farthest thing from them. You ain't gonna
when you go
that
into the jury room, you'll be given a verdict form. And the verdict form will basically state, it covers all of the different areas of this case.
Thank you, Jamie.
First section A is the assault and battery. They are in a sense separate. Because the assault is the swing,
waking up a
and the
little
battery
bit.
is the scratch and the cut to her face. However, it's very clear. Did plaintiff Ammani Ellis prove all of the following elements of battery? And then it goes down, it breaks it down. Defendant Belcalis Marlenis Almanzar touched Miss Ellis with the intent to harm or offend Miss Ellis. Miss Ellis did not consent to being touched. Miss Ellis was harmed or offended by Miss Almanzar's conduct. A reasonable person in Miss Ellis's situation would have been offended by the touching. I would say that yes, all four of those have been done here. So when you get to that question, there is going to be on the right side. It's not broken down into 4 parts. It's all as a whole.
Well, listen,
so
y'all.
If you want to give money damages to Miss Ellis, you would check yes. Okay, and then you go to the next question. Did Miss Ellis prove all of the following elements of assault? And again, it breaks down for you the 5 different parts. Miss Ellis acted with the intent to cause harmful or offensive contact with Miss Ellis. Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Miss Ellis did not consent to Miss Almanzar's conduct. Miss Ellis was harmed, and Miss Almanzar's conduct was a substantial factor in causing Miss Ellis's harm. Again, if you want to give her money damages, you would check yes. That would be page 2. Both of those.
Thank you, Ms. Tam.
Then you have question number 3. Did Miss Almanzar prove all of the following elements of self-defense? So the defense is trying to argue that all the things that Miss Almanzar did were in self-defense. There is no testimony of self-defense here. In fact, Miss Almanzar herself, her position was, I didn't touch anybody.
She said a few things that she said she was. And let me ask me, is my memory correct? Didn't she say a few times in the testimony that she was just defending herself? Am I bugging? Didn't Cardi B say that she was just defending herself? Once again, we're going on facts here. We talking about facts. We're not talking about on nobody's side and attacking black people. We talking about facts. I remember Cardi B saying a couple of times that she was just defending herself. She attacked me. She started it. She was following me. Okay? Somebody's following you. Are you the aggressor? Who are you if somebody's following you? Who are you? How could you be the aggressor if you're the one that's being followed?
And nobody touched me. So self-defense,
thank you. Hey,
no. You would say no. Then you can go, then question number 4 speaks about the damages that she suffered. Past medical expenses. That's where you would put in an amount of money through the testimony that you heard and through all of the exhibits. You would put an amount of money that you believe Ms. Ellis incurred in this incident. So you will have
on the jury form, they have like the questionnaire or whatever to fill out, and they have to put because she's not going to get 24 million, y'all. They do that. They inflate the price on the lawsuit so that they put it real high. So whatever they get, they get. Okay.
In the jury room, exhibit number 4. You'll have exhibit number 4. It's been marked at the bottom right corner. You will have exhibit 4-1 through exhibit 4-6, and then it will skip over, and you will go to the bills, which will be 4-13, 4-14, and 4-15. If you combine all of these bills, you will get $16,500. So past medical expenses would be $16,500. That would be what you would write there if you want to give her the cost of all the plastic surgery she had to go through up until now. The future economic loss is the future plastic surgery. Dr. Mulliken stated that Ms. Ellis would benefit from a future plastic surgery of $15,000. So you'd write $15,000 in that box. Pain and suffering. Again, there's past pain and suffering and future pain and suffering. The court read a time frame for you of how many more years Miss Ellis will live. And the jury instruction life expectancy, 3932, basically states that Miss Ellis will live for another 50 years. This is an estimate. It's not 100% certain, but it's the best estimate that we have based on all kind of statistics. She has 50 more years to live. So if you feel that she is going to suffer from this point forward, then you can award her money damages for the future. And if you feel that she sustained pain and suffering in the past, then you can award her money for the 7.5-year time period.
She's gonna suffer from a paper cut, y'all. A paper cut. Thank you, Keith. Thank you. Thank you. Keep it real.
And again, you'll all have the jury instructions in the back when you go into the jury room, and the jury instruction on pain and suffering covers a whole bunch of different things. Very important. Very important.
Hey.
So I would take a look at that one because it covers all of the different things.
I watched the other
embarrassment, pain and suffering, disfigurement, all of those. So if you look at 3905,
thank you for the follow.
It talks about physical pain, mental suffering, and or emotional distress. And it basically says that there's no fixed standard for deciding the amount of these damages. This is a number that you will come up with. It won't be based on chance or a flip of a coin, but it will be a number that you come up with. If you decide you want to give her $500,000, you can do that. If you want to give her more, you can do that.
No, that's not her mugshot. That's her in court, Aaron.
So for past non-economic loss,
no,
you should put a number there.
There's still Ammani's lawyer. Still Ammani's lawyer. Look like he's getting to the end now, though.
Because if you don't, the award will be thrown out. You got to have at least $1 there.
Get a job, right?
You got to award some kind of pain and suffering. It's required. Now the amount would be up to you. A lot of times, some people say, well, 3 times medical bills, 10 times medical bills. This is an assault and battery. It's just not a simple car accident where it's just, some bump.
Assault and battery. Let me stop, because they say I'm attacking black folks. Let me stop.
Some bruises. This is a serious injury. Very serious. And Miss Ellis has been suffering for the last 7.5 years. What kind of weight do we put to that? What kind of number do we attach to that? I don't know what number you're going to attach to that. But for purposes of now, for example, you could write 250.
So he's instructing the jury on how to determine how much they're going to give her. Right now, I'm just calling it what it is. It's not about being nobody's side. It's like, I'm just analyzing it with y'all and calling out what it is. I'm not going to just sit there and let somebody pee on my head and say it's raining and not say nothing. I can't do that. I'm a very straightforward person. The Diddy trial was different. That was a thing where it's like, but this is different. You ain't gonna pee on my head and say it's raining and I'm gonna sit there like Boo-Boo the Fool and just not say nothing. Right? Even if she did get her face cut, right? Let's say she did get her face cut. She still wouldn't get $24 million, y'all.
$50,000 for the past pain and suffering.
Ellis, everybody that's coming in late. Thank you, everybody that's coming in late. Thank you for being here, Marcy and everybody. This is Cardi B's case against Ammani Ellis, who was a security guard that when they're following her, they got into an altercation, and she claims that Cardi B scratched her, and now she wants $24 million. This is the closing argument. So after this, we'll go through the case with a fine-tooth comb, okay? If we don't get to this today, we'll start early tomorrow. We got time, all right? So let's go.
Violent attack. She was violated. She has a scar to her face now. She's gone through all kinds of medical treatment that she didn't have to go to.
All kinds of medical treatment.
So much life was lost from her, time-wise. You can't get it back. All this time that she's lost and feeling embarrassed and all of that. What is the value of life? It's significant. We all went through the pandemic.
She should feel embarrassed.
We all went through the pandemic, and we realized that after the pandemic, the value of life is much greater because we realized that life is really about future non-economic loss. Again, that's going to be for the 50 years going forward. You could
50 years. 50 years. Economic loss. 50 years.
Pick what number you feel. Maybe you feel she's recovered. Maybe you feel she deserves another 10 years. Maybe the whole 50 years. I don't know what it is.
Everybody like
you as individual judges will work together as a team to come up with a number for the future non-economic loss. Then it goes into intentional infliction of emotional distress. Did Miss Ellis prove all the following elements of intentional infliction of emotional distress? Number 1, Miss Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. Miss Almanzar intended to cause Miss Ellis emotional distress. Miss Ellis suffered severe emotional distress, and Miss Almanzar's extreme and outrageous conduct was a substantial factor in causing Miss Ellis to suffer severe emotional distress. If you believe that Miss Ellis sustains emotional distress, then you would, on number 5, you would say yes. Then number 6, again, it says, did Ms. Almanzar prove all of the following elements of the privileged conduct defense? So again, it's similar to a self-defense of this, and it goes through a whole laundry list of different ways and finding excuses why the conduct was okay. So you would put no there if you believe that the conduct caused intentional infliction of emotional distress.
Extreme.
Then number 7
extreme emotional
has its own damages component. However, we've agreed and conceded to the fact that we don't want you to award damages for the same thing twice. It's not what our goal is. The goal is, if you feel there should be separate damages aside from the assault and battery for the emotional distress, then this is where you can give that amount of money. Separate and apart damage area for you to award more damages. Same breakdown. You can give past medical expenses, obviously past and future medical expenses. In this, if you're awarded in the first box, then you would say 0 and 0, because we're not double dipping here. That's not our goal. However, pain and suffering. If you want to give separate pain and suffering for the emotional distress, separate pain and suffering
that's a good
for the emotional distress from the past and the future, this is where you could do it. You could say, okay, well, we're going to give $50,000 additional for the past, $50,000 additional for the future, and then we're going to move on to the last part, which is negligence and contributory negligence. And again, this is all from the form that you're all going to see when you go into the jury room. And I'll close with this. Did Miss Ellis prove all the following elements of negligence? Miss Almanzar was negligent. Miss Almanzar's negligence caused Miss Ellis to suffer physical harm rather than only emotional distress, and Miss Almanzar's negligence was a substantial factor in causing Miss Ellis's harm. So what that means is, for example, was Miss Almanzar, was Cardi B negligent in thinking that the was disseminating her privacy to others, photographing her, videotaping her? If you believe that Miss Almanzar, Cardi B, was mistaken, then that would be negligence. She was negligent. She negligently thought that all these things were happening. And then again, it asks for the damages. Same thing.
I love you too.
0 and 0 for the past and future medical expenses if you have given it in the first phase. So there's different areas. Maybe you'll say, well, I don't really believe there was this, but I believe there was that. So anywhere on the form, we would ask that you award Miss Ellis her medical bills of $16,500 for the past and $15,000 for the future, and in different boxes and different areas of this form to award her the pain and suffering that you feel is fair for all the things she went through, the assault, the battery, the emotional distress, all that she should be compensated for. And then there's a box, did Miss Almanzar prove all of the following elements of contributory negligence? Miss Ellis was negligent. Miss Ellis' negligence was a substantial factor in causing her own harm. Well, Cardi B testified that Miss Ellis didn't touch her, didn't do anything. There was no physical contact. That was the testimony.
She didn't say Ammani didn't touch her. What she said was, we didn't touch each other. That's what she said. We didn't. Am I right or wrong? She didn't say she didn't touch. She didn't say specifically, oh, I didn't. She probably said that in the midst of things, but her point was, we didn't touch each other.
Of Cardi B. So how can she say that there was contributory negligence? What did the security do wrong? So the answer would be no. And then
make it too much, right? Then
it goes to number 11. What percentage of responsibility for Miss Ellis's harm do you assign to Miss Almanzar? Say 100%. And Miss Ellis,
He's twisting stuff around.
And the final page deals with punitive damages. Did you answer question 4 or 7? And you look back, and if you did, which is the damages, then you put yes. And then it says, did Miss Ellis prove by clear and convincing proof that Miss Almanzar engaged in conduct with malice, oppression, or fraud? And then you would look at the case as a whole and kind of come up with your opinion. Did all of these things combined, did all of this thing that Miss Ellis went through? And remember, it's or, so it's either malice, oppression, or fraud. So if you agree that there was, then you would say yes here.
So he's giving
So
the jury
at this point, I'm going to turn it over to my
Here we go.
counterpart. They will obviously contradict everything I will say, I've told you, and then I will have a chance to come back and rebuttal and just clean up anything that was said. At this point, I'm basically Miss Ellis's mouthpiece, and work with her as best I could to convey all of the things that she wants you to know. I worked with her personally to tell you all what she went through, and I did the best that I could with what I had. And we really, no matter what happens, whatever is supposed to happen will happen, because that's what's supposed to happen. And we want to thank you each individually for being here. Each of you as individual judges, we're thanking you very much. Thank you so much for hearing the story as to what Miss Ammani Ellis went through, and I'm asking you to award Miss Ellis an amount of money that you think is fair that will make her whole for the losses that she suffered in this case. Thank you very much.
Wait a sec, I thought it was dismissed already. You talking in 30 years.
You okay? Okay. All right. Defense ready to proceed?
We are, but I would think a break would be appropriate at this
Does anyone want a break? We got started late. Okay. Why don't we take a short break? Why don't we resume back at 11:25? In the meantime, let's not discuss the case with anyone and pick another jury.
Now, every comment after comment in here is saying the same thing. But I'm bashing people and talking about black folks. But every comment going down the line is saying the same thing. We are all watching the same show.
So form any opinions or do any research.
All
we'll see
watching
you
the same
at
show, y'all.
10:25. I'm sorry, 11:25.
All right, so they went on a break. All right, they went on a break. And here they are back. This is why I'm glad I lagged it a little bit.
Were based on facts that weren't introduced during the trial. And so that's why I was sustaining those objections to the extent that plaintiff's counsel mentioned any facts that weren't presented in the...
Wait, hold on. This is the judge that's going to be talking. Let's start from the beginning. All right, so this is the judge talking. Let's get into it, y'all. Let's get into it. Okay, it's coming.
The defense closing argument...
Okay, hold on, y'all. I'm trying to catch it from the very beginning. Hey, April, what's up? What's up, April? Everybody come on in. We're listening to Cardi B's closing arguments. Everybody come on in, grab a seat, get you a drinkification, because there's a lot of tea going on, baby. All right? Tapify, shareify, likeify, and blessify Miss Knockout so she won't be brokified, so she could come here and keep bringing you the tea.
All right, welcome back, everyone. We're back in the record in the Ellis matter. Counsel and the parties are present, as are the members of our jury and our alternate. And before we get started with the defense closing argument, you heard a number of objections during plaintiff's closing. Some were procedural or evidentiary in nature, but some of them were based on facts that weren't introduced during the trial. And so that's why I was sustaining those objections to the extent that plaintiff's counsel mentioned any facts that weren't presented in evidence during the trial. Please disregard any and all of those facts that he represented that weren't actually accepted into evidence during the trial. Okay? All right, with that, defense can give their...
So he was talking about stuff that wasn't accepted as evidence in the trial. Because he was going on. He was trying to go in.
Thank you.
Hey, thank you, Donna. Thank you, Jan. Okay, here goes Cardi B's lawyer. Let's get ready now.
Good morning, everyone. I'd like to start by thanking all of you for taking the time to participate as jurors. This is how our system works, and it wouldn't work without jurors. And I'd like to thank you on behalf of both Cardi, my colleagues, and myself. I'd like to just mention quickly that counsel argued that Cardi swore and used profanities in the courtroom and that was disrespectful. Actually, all she was doing was repeating under oath what was said. In fact, Ms. Ellis, plaintiff, used profanities to describe what she heard. Counsel used profanities, and I have to admit I used profanities, but just to tell you what was supposedly said. Cardi has never gratuitously sworn at any point in this courtroom, and the suggestion that you should be prejudiced against her because of that is just unfounded and offensive. Last Monday, it seems like it's a lot longer ago, but last Monday in the opening statements, I told you what I expected the evidence would be, and I told you that you can treat my statements and counsel's statements as promises of what they were going to show, and that I would ask you at some point, well, today, to decide who kept their promises and who didn't. I also told you that I would have a second chance to talk to you directly after all the evidence is in. The evidence is in. Witnesses have testified that exhibits have been admitted. And if you remember, the judge told you the first day that the way trials work is that bits and pieces of evidence come in. This is my opportunity to tell you how we think those bits and pieces come together and how they establish that Cardi, you should decide in Cardi's favor. First, there's a couple of things I ask that you keep in mind throughout the rest of the trial. If you remember, Judge Fusselman told you last Monday morning that the reason we have juries is because they have diverse backgrounds and they have common sense. He reiterated how important common sense was when he said, we just need you to exercise common sense and evaluate, is this witness being consistent? Is this witness saying things, something that doesn't seem true? And does this piece of evidence fit in with all the other pieces that have been presented in this case? I respectfully suggest to you that using your common sense, there's only one possible outcome in this case.
This is closing arguments, y'all. This is closing arguments, and I did start a little behind because I wanted to skip that break. We don't have time to be sitting through no break. So yes, closing arguments.
And that is a decision in favor of Cardi. Now, you'll be instructed that plaintiff bears the burden of proof of establishing her claim. She must convince you that the evidence shows that by 50% or more, her claims are valid. Now, there's another way of putting it is, and you'll see this in the jury instructions that you get from the judge, if a plaintiff fails to prove that her version of what happened is more likely than not what did in fact happen, you must decide the case in Cardi's favor. The concept of a preponderance of the evidence can be demonstrated by this slide. That's 50-50. That's where the plaintiff has put on as much evidence of as the defendant of a fact, and you'll see that that's where people talk about the 51%. But it is crucial to keep in mind that plaintiff doesn't start at 50%. She starts at 0. She has to raise that needle from 0 to 50% and more. She has to go beyond 50%, or you have to find for Cardi. Third, there is no dispute that there was yelling and some curse words in the hallway at the medical building around 1:30 p.m. on February 24th, 2018. But the judge will provide you with the jury instructions. In fact, he already has. That arguing, yelling, even using profanity, is not something you can sue over. That's just part of normal life, and that is what we're supposed to bear. In fact, that would be crazy that someone could sue if they cause someone else to use profanity.
Thank you, beautiful, for the share.
The question really is whether Cardi ever struck Plaintiff, and who caused this confrontation, who caused the incident. And the answer is that the evidence in this case overwhelmingly proves that Cardi did not strike Plaintiff, and Cardi did not cause this encounter. As a result, Plaintiff has failed to establish, by the evidence you heard last week, that by a preponderance of the evidence, more likely than not, that Cardi was the cause. The way, I'm going to try and do this in a very organized fashion, and the way I'm going to do it is going to be demonstrated by this chart. And so we have on the left-hand side plaintiff's evidence, and then on the right-hand side defendant's evidence. Now, plaintiff started with her own testimony. Last Monday, she testified under oath. Importantly, though, in plaintiff's evidence, she never called as a witness either Tiara Malcolm or Dr. Finke, both of whom were present.
Objection, Your Honor.
Both of whom were present at this very time of the incident. Now, plaintiff's evidence, plaintiff's testimony, and we should keep in mind that just because plaintiff says something doesn't make it true. Okay? She has her version, but the fact that she alone says it does not actually make it true. And later this morning, maybe stretch into afternoon, I'll tell you, or I'll identify the many inconsistencies in plaintiff's story over the course of this litigation, actually going back to February 26, 2018, when she did her incident report. In the meantime, plaintiff claims that she was assaulted and scratched or cut on February 24, 2018. But plaintiff did not see a doctor. She didn't go to an emergency room. She didn't call the police or make a police report. And she actually testified she did not know if the scratch that had supposedly ruined her life was even bleeding. She also testified last week that she didn't even put a Band-Aid on the scratch. What did she do? She claims that Cardi mauled her, basically, cut her face, and this woman went home, and what did she do? She took a nap. That was her own testimony. She took a nap. The fact that on February 24, 2018, plaintiff just went home and took a nap is corroborated by plaintiff's own T-bill cell phone records for that day. As you'll see, and this was an admitted exhibit, you'll be able to see it, it's exhibit 200.
HIPAA violation.
She gets calls, and she makes calls from 11:20 a.m. all the way to 3:35 p.m., and then nothing until 9:08. That's when she took her nap. That's what she did. She didn't call a doctor. She didn't go to the hospital. She didn't put a Band-Aid on her face. She took a nap. Now, importantly, when plaintiff testified as her own first
Cardi look like she's over this. She want this to be over.
Witness in her case, she admitted that in 2021 she hit her head in a car accident. She's put on no proof that that wasn't the source of the scar, which is a pretty obvious reason that she would have a scar if she had one. And importantly, 2021, a car accident in 2021, is after plaintiff told Dr. McKenna in April 2018 that Cardi almost touched her with a fingernail. Not touched her with a fingernail, and I'll talk more about that later, but almost touched her. So after the plaintiff tells Dr. McKenna, her workers' comp physician or psychologist, that Cardi almost touched her, plaintiff was then in a car accident, hit her head, and that's when she went to Dr. Mulligan. She went to plastic surgery 4 years later after being in a car accident.
Objection on this case.
Whoa, there it is. You went those many years later after you had a car accident. So how we know any injuries is from the car accident or from this? You have no phone, no proof, no receipts, no pictures, no nothing. Let's continue to listen.
Plaintiff also testified, by the way, that she was in another accident in 2023 and filed another lawsuit over that one.
Everybody like a fire. Everybody share a fire. This should be a 1,000,000 like day. We should have 1,000,000 likes in here. We got almost 1,000 people. Let's blessify Miss Knockout so she won't be brokified. We getting overload of tea in here. Overload.
Plaintiff has argued, and he said again today that plaintiff's counsel has argued and said again today that plaintiff has some special status as a security guard. But she testified she became a security guard by having her fingerprints taken and sent to California. That's it. That doesn't make her a policeman.
That was real shady. He said that she just take her fingerprints. They just hired her, took her fingerprints, sent them somewhere, and that don't make her a police officer.
Also importantly, when testifying last Monday, plaintiff admitted that she knew on February 24, 2018, that Cardi was in the medical building because Cardi was going to a medical appointment. Plaintiff's own testimony establishes that at 1:30 p.m. on that Saturday, plaintiff could have been at that security guard booth that counsel showed you a photograph of. She could have been on her rounds, going through the whole building. She could have been in parking, checking, because that's what security guards do. But plaintiff, who has testified she was a fan, just happened to be outside Dr. Finke's office when Cardi B was showing up to see an obstetrician. From those facts alone, you can infer that she was actually laying in wait. She wanted to photograph and videotape Cardi. She would then be able to post it on YouTube, maybe start a new career, be a follower, I don't know. But from the facts you've seen in this and heard in this case, she very well could have done that on purpose. But even if we assume that plaintiff just happened to run into Cardi B in a 5-story building that afternoon, plaintiff testified that she knew Cardi thought that plaintiff was using plaintiff's phone to tell someone that Cardi was there and to videotape her. What would a reasonable person do at that point? By her own testimony.
This is Cardi B's lawyer now. This is Cardi B's lawyer talking.
The plaintiff had the chance to be professional and avoid all of this by putting her phone away. That's all she had to do. But the evidence is she kept that phone in her hand all the way through as she advanced on Cardi B and forced her into a corner in the hallway where Tiara Malcolm found her. Plaintiff also testified that after she was fired as a security guard, she got a new job that paid more money. That's why you don't hear any claim for lost wages or anything like that. She was better off.
Not claiming lost wages.
That summarizes what plaintiff testified to, and I'll talk later about the inconsistencies in it. But let's talk about her second and third witnesses, plaintiff's mother and grandmother. Both very charming. But her mother and her grandmother weren't in the hallway that afternoon. Her mother and her grandmother were not witnesses. And they testified that because plaintiff is the mother's daughter or the grandmother's grandchild, that they believe her. They don't need evidence. They just hear what she says. And that's understandable, of course. We all have relatives, and we hope our parents believe us, and our grandparents. But remember what Judge Fisselman said at the very beginning, common sense. Okay? We all know that parents are not with their children every minute of the day. We all know that children don't always tell their parents everything, and they especially do not tell their parents that they're embarrassed or guilty about what got them fired. That's what plaintiff left out when she talked to her mother and her grandmother. Is anyone surprised that plaintiff did not tell her mother and grandmother that plaintiff cursed and yelled at a pregnant Cardi half her size that plaintiff cornered Cardi in a medical building hallway, and that plaintiff knew she was probably going to get fired? Is that the kind of thing you'd say? Guess what, Mom? Guess what I did today? So it's completely understandable, using common sense, that the mother and grandmother would not know actually what happened. In fact, plaintiff didn't tell them.
That's a good question. Where are the cameras? There's cameras all over the place. Everything you do got cameras on you. Where are the cameras? Where's her cell phone? Where's her messages? She threw the cell phone away. She discarded. Nobody knows where that cell phone is at. Where's her cloud? Where's anything at? But let me be quiet because I'm on Cardi B's side and I'm bashing black folks. Let me be quiet.
That she had apologized in her incident report to Adelaide and the building for her own behavior. She left that out. Because I asked both the mother and the grandmother, did your daughter or granddaughter, tell you that? And they said no.
That's what somebody...
So we know that plaintiff left that
That's
part
what somebody came in here and said.
Plaintiff's mother and grandmother both said that plaintiff is a peacemaker. Okay? Well, that sure doesn't square with the testimony of Tierra, Malcolm, Dr. Finke, or Cardi, and I'll discuss that later. And maybe what we take from that is she's a peacemaker when she gets her own way. We know what she's like. We've heard testimony what she's like when she doesn't get her own way. But there's another word for that other than peacemaker. It's a bully. Plaintiff's mother and grandmother both said they saw a scar on plaintiff's cheek. But on February 26, 2018, 2 days after the incident, plaintiff emailed her incident report to her supervisor, Jasmine, stating that Cardi scratched plaintiff's nose. So how is it that the mother and grandmother are saying that, well, when this happened around that time...
So you said somebody said Cardi was, but not you. Okay, the exact words was, you're on Cardi's side and you're bashing black folks. So are we talking about the same thing? I don't think we're talking about the same thing, Sugar. Or was that you? Oh, so you're saying that I'm not bashing black folks. You're saying Cardi. You're talking about Cardi and not me. Is that what you're saying? You read it wrong. Okay. Well, I apologize by that, Sugar. I read it wrong. I took it out of context. The way you wrote it, though, it looked like you said you're on Cardi's side. So how could Cardi be on her own side? So how could you be talking about Cardi? You know what I'm saying? That. So that's why I thought you were talking about me. So why would you say Cardi was on her own side? I don't know. But if I took it wrong, my bad. Let's continue.
Our daughter said that Cardi had scratched her cheek. But in plaintiff's own incident report, she said she told her supervisor Cardi scratched her nose. A nose is not a cheek is not a nose, and there is something wrong about what's going on because, again, apply common sense. Plaintiff's mother testified that she saw a scar, but she didn't testify when she saw it. Counsel asked her, did you notice after the incident that Ammani...
Oh, that's a good point. She never said when she saw it. So that means that none of the lawyers asked her, did this cut happen? What day did you see this cut? Or either they asked her, she didn't remember?
Ellis had a scar from her face. Answer, I did. When did she notice that? 2018, 2019, 2020? We don't know. And in response to one of your questions, because the judge was kind enough to allow jurors to ask questions, which doesn't happen all the time. You were lucky in that regard. One of your questions, the judge read, and in response, plaintiff's grandmother said she spoke with plaintiff right after the incident. Right after the incident, she spoke with plaintiff. But plaintiff testified last Monday, question, you didn't call your grandmother though, did you? Answer, no. Okay? So again, common sense tells you something is very wrong here. Now, plaintiff's mother and grandmother testified that plaintiff became depressed. If so, there could have been many different reasons for it. And for example, it could have been because she got fired. And as we'll see in a few minutes, she felt guilty. That's what plaintiff told Dr. McKenna in April. On April 26, 2018, plaintiff told Dr. McKenna that she feels guilty. Ultimately, the testimony of plaintiff's mother and grandmother just doesn't move the needle for plaintiff. They weren't there, and they're relying on what plaintiff told them. Now, plaintiff's third group of witnesses, is Dr. Mulligan. And that's what she offered to support her claim. Of course, Dr. Mulligan also wasn't there on February 24th, 2018. He didn't witness what happened. Dr. Mulligan testified that plaintiff came to him in November 2022, or more than 4 years after the alleged incident. Dr. Mulligan is a plastic surgeon, not a psychiatrist. So counsel pointed out that Dr. Mulligan testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulligan said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me. Now, Dr. Mulligan, and I hope he's not insulted, but his testimony was confusing and inconsistent.
I know, she's sleeping.
He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulligan thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars. Also, though, Dr. Mulligan...
So the 1 scar in the beginning was her initial report to her job in the incident report after it happened, right? And then it turned into 3 scars because that plastic surgeon that did the micro-needling in her face said it looked like, 3 stars, like it's like claws of a werewolf going down. So it turned into 3 scars, and it was on her cheek. Okay?
Own photograph, Exhibit 228, which he testified was taken with a digital camera before any treatment, sure doesn't appear to show the scar.
Everybody keep typifying.
That is you'll have the actual,
Thank you for the
the actual photo. It's admitted as exhibit. You can look at it, and you can decide. Counsel actually challenged you, look at the photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated. Importantly, Dr. Mulligan testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claim scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay, that's what he testified to. That's what was in his deposition, and that's what he testified to here. But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape.
Where's any of my mods at? I'm letting them rock because I don't give a F what y'all coming here saying. Nobody's paying you no mind. We're listening to the report and getting down to business in here. Nobody really cares about what you're talking about if it's negative. If you having problems watching it here, go watch it on television. We're here enjoying the community. All right? So my mods are working. It's the fall. So we're gonna get some more mods. I'm going to recruit some more mods to come in. So when my mods are busy, I can have mods. But I don't give a F about what you're talking about. We busy in here.
Your Honor, I don't think I need to ask for permission, but we'd like to show then we'll show, this was played for the jury before. It's Cardi's testimony, plaintiff's testimony, as to how she was supposedly cut by Cardi.
When you see it like this, she put her finger...
Pointing, yes, go like this. Pointing her finger in my face, yes.
That is directly...
So homeboy got crafty with it. Let's run it back. Let's run it back a little bit because I was talking to the people that you don't even matter. All right. So he went, and the Cardi B's lawyers, he got videotape he's rolling back. They got, now see that? They came prepared. They came with videotape he rolling.
2018, he didn't witness what happened. Dr. Mulliken testified that plaintiff came to him in November 2022, or more than 4 years after the alleged incident. Dr. Mulliken is a plastic surgeon, not a psychiatrist. So counsel pointed out that Dr. Mulliken testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulliken said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me.
Hey, Samantha.
Now, Dr. Mulliken, and I hope he's not insulted, but his testimony was confusing and inconsistent. He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulliken thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars. Also, though, Dr. Mulliken's own photograph, Exhibit 228, which he testified was taken with a digital camera before any treatment, sure doesn't appear to show the scar.
So anybody that's talking crazy, I don't mind you giving your opinion, but if you in here talking crazy, you know what I'm saying? Because we're going to have trolls regardless, y'all. But if you in here talking real crazy, you're going to earn yourself a muzzle. And we'll see. Okay? Let's continue.
That is you'll have a copy of the actual photo. It's admitted as exhibit. You can look at it and you can decide. Counsel actually challenged you. Look at the photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated.
Say something else. Say something else.
Importantly, Dr. Mulliken testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claim scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay, that's what he testified to. That's what was in his deposition, and that's what he testified to here.
Yeah, I'm just having fun with them, Lachey. I'm a special kind of girl. I don't give a flipping flying flick about a troll. I have fun with them, though. So Miss Knockout's not angry. She just, like y'all said, packing them up.
But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape.
I have fun with the trolls.
Your Honor, I don't think I need to ask for permission, but we'd like to show the. Okay, then we'll show. This was played for the
right,
before.
Donna, right.
It's Cardi's testimony. Excuse me, plaintiff's testimony as to how
the trolls is helping me out. They contributed to my engagement, like Donna said. That's right, Donna.
She was supposedly cut
right away. You want to keep talking from New York.
When you say it like this, she put her finger.
Yes, go like this, pointing her finger in my face. Yes.
That is directly and irreconcilably in conflict with Dr. Mulliken's testimony that it was a right-handed person who scraped with an index finger and 2 other fingers downward. Those are completely different things. They don't correlate. The testimony is clear that plaintiff and her plastic surgeon have completely different explanations for the same claimed scar. And once again, common sense. Something's wrong here. Something is very, very wrong. Now, maybe the scar that Dr. Mulliken says he saw and his explanation, maybe it was a car accident. I don't know. But it is irreconcilable with plaintiff's own testimony that she was jabbed with a straightened finger. And to add to that, Cardi is not right-handed. I want to say that again. It's very important. Dr. Mulliken says that in his professional opinion, and counsel talked about how well-respected he is, that it was a right-handed person who scrapes 3 fingers downward across plaintiff's face. But Cardi is left-handed. She is not a right-handed person, could not have done that.
Good point. Good point. Good point.
Plaintiff's counsel tried to get Dr. Mulliken to testify that a left-handed person might have made the claim scar, but that's not his opinion. He admitted that it would be hard, in fact testified it would be hard for a left-handed person to reach across and strike a person on the opposite them on the left side of the face. Now, here's another important thing. Dr. Mulliken testified that he can't say when plaintiff got the claimed scar. He testified there's no way of knowing the age of the scar. That's important because plaintiff admits that she hit her head in a car accident in 2021, almost 2 years before the November 2022 appointment with Dr. Mulliken. And Dr. Mulliken also testified that he can't say whether the claimed scar was caused by an intervening accident or some other cause.
Objection, that was his testimony.
Thank you. When you heard the evidence, please rely on your recollection of the evidence and rely on your own recollection to the extent that it differs from counsel's representation.
And Your Honor, we also have a cite to the reporter's transcript. There are other odd things about Dr. Mulliken's testimony. For example, he calls a 3-minute long session of outpatient microneedling a small part of plaintiff's cheek, which serves, well, as reconstructive surgery and plastic surgery. A 3-minute microneedling session, in his mind, is reconstructive surgery and...
A 3-minute micro-needing is equivalent to surgery now.
Plastic surgery. Now let's talk about why he would say that. He has a broad version of surgery that enables him to charge an additional $11,000 for an operating room. He testified surgery is anything that includes a doctor, a nurse, a scrub technician, and an operating room. No matter what you're doing, even if it's microneedling, if it's pulling a splinter out, you go into that room and he charges $11,000. Dr. Mulliken testified he is the sole owner of the surgery center with that operating room. So he has a strong financial incentive to use and charge for that operating room, whether he's doing real reconstructive.
Now see, I didn't catch that part. So he's the owner. That people are leaving. We're in here enjoying it with my community. People are leaving because somebody put where it's actually playing. You could go watch it there if you want to. Cut out the middleman. You know what I'm saying? But we're a community. We're supporting the Miss Knockout community, and people are enjoying watching it with me. They know that they could go watch it on YouTube, but people are spending time into me. So somebody put it in the comments. I see a couple of hundred people. People do all kinds of stuff. You know what I'm saying? But we know we still gonna rock. Let's go. We here.
Surgery or microneedling.
Still people gonna be here.
Now, perhaps because his photograph doesn't seem to show the claimed 1-inch scar, Dr. Mulliken also provided confusing testimony about hidden scars under the skin. I don't know if you remember that. It had my head spinning. But he never testified. There's no testimony from Cardi, from Dr. Mulliken, or anyone else that plaintiff has a hidden scar. In fact, it's supposed to be this, really big embarrassment that she has this, terrible scar on her face that, you can decide whether you've seen it. You've walked by her. If you see a scar, well, no one else. A lot of us don't, I should say. Dr. Mulliken also testified that he charged $17,500 on a lien basis, which means he gets paid only if plaintiff wins or if plaintiff pays him. But plaintiff...
Everybody already knows that it's playing other places. We just vibing out.
Testified under counsel's own examination on Monday that she couldn't afford a $15,000 or $20,000 plastic surgery bill. So we know she's not going to pay Dr. Mulliken. And Dr. Mulliken knows that he is going to get paid, if at all, his $17,500, only if his testimony helps plaintiff recover money in this case. That is a big incentive, and because of that risk, he testified he added a 20% premium to his bill. That's plaintiff's side of the scale. which keeps disappearing. And it pales in comparison to Cardi's side.
So we rocking today. I don't think is any of the mods still in here. I think I see Rev earlier. Is Rev still here? You know, Rev is working. Leah's working. Ginger had a couple events going on, but that's okay. We rocking out with no mods. Let's rock out. I don't give a F about a troll.
So, of course, Cardi's evidence starts with Cardi's testimony, which will appear shortly. Thank you. Cardi is one of the 3 eyewitnesses who directly contradict plaintiff's story about what happened that day. Cardi testified that in February 2018 she was pregnant. You may remember in this trial that plaintiff's counsel asked Cardi, "Why does that matter? You're pregnant." No one knows, but why does that matter? Well, it did matter, and Cardi testified, and you should consider, and I hope you remember Cardi's response. She felt her privacy was completely being violated, and that her medical issues are not anyone's business. Quote, especially something that is so sacred as your pregnancy. It's yours. No one knew she was pregnant. Her parents didn't know. And she shows up for an appointment, and this woman is photographing, filming her, and then getting belligerent. Now, I mentioned that Cardi testified her parents didn't know she was pregnant at the time, and it's common sense that no daughter would want their parent to find out that she's pregnant by social media. This was a secret. There were special arrangements made so that she could see an obstetrician while in LA on a Saturday. Now, Cardi testified that she came to Los Angeles for the NBA All-Stars weekend, and concerned she made an appointment with the obstetrician for Saturday afternoon. I'll get to the photograph in a minute. Cardi testified that she got off the elevator to go to the doctor's office at about 1:30 on the 5th floor of that building, and plaintiff started filming and photographing her. Cardi objected, and plaintiff apologized at first, saying, "Oh, my bad," which is effectively an admission that she was doing what Cardi thought she was doing. Cardi testified that plaintiff wouldn't stop and just kept following her with her camera, with her phone out. Cardi testified that she was very concerned and nervous and confused by plaintiff's conduct. That is understandable. Cardi testified that she was concerned about her unborn child. Cardi referred to plaintiff as security heavy. She's a large woman. She's almost twice the size of Cardi. Cardi's pregnant, early in her pregnancy, and this person comes up to her in black boots and starts yelling at her. Cardi was concerned about her, and scared, frankly, about what she might do to her unborn baby. Cardi also testified she was confused. Why is this going on? Why is a security guard doing this? Why is she filming me? Why is she following me? Cardi also told plaintiff specifically that plaintiff was invading her privacy. But when Cardi told plaintiff to leave her alone, plaintiff went berserk. She yelled, it was plaintiff's phone. Plaintiff said, "That's my phone. This is my building. You can't tell me what to do." That's what Cardi testified, and it's consistent with what Tierra Malcolm and Dr. Finke testified. But plaintiff advanced on Cardi, screaming and yelling and forcing Cardi backwards down to the hall to a corner, coming chest to chest with Cardi, yelling at Cardi about how, this is her building. She can do whatever she wants. Now, hearing the yelling, the doctor's receptionist, Tierra Malcolm, and then the doctor intervened and tried to get plaintiffs to stop and leave. We'll talk about that in a few minutes. In the meantime, Cardi testified that she and plaintiff yelled and used curse words, but neither struck the other. Cardi did not strike plaintiff. Plaintiff tried but did not strike Cardi. Cardi testified.
I don't want to interrupt. We're coming up on a break. If there's a logical place to stop, please.
I can stop there if you want.
Okay. All right. Why don't we stop there, folks? We're going to resume back at 1:30. In the meantime, please not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 1:30.
That's California time, y'all. All right, so let's skip. So this is why I stayed up behind a little bit. You know what I'm saying? So that we don't, have to wait. Oh, they still on the break. They still on the break. Okay, so 1:30, 2:30, 3:30, 4:30. They on break till 4:30. All right, so they on break till 4:30. All right, so what do y'all think? Do y'all want to come up let's jump in there. Let's do this. Let's do this. Jump in the box. All right, get out the box if you're in the box by accident. Okay, get out the box. But if you want to chime in, okay, because we got about a half an hour now. So if you want to chime in, I'm interested in hearing your thoughts. Thank you, Sheila. Thank you for keep the blessifications going so Miss Knockout could stay here and bring you the news and she don't have to go and work for the man. Okay? Thank you for your blessifications. I appreciate it. Let's get the likeifications up to 3. We almost at 300K and everybody in here, let's share a fight with 10 people. All right? They're coming back. The people leaving, they're coming back at 4:30. So everybody want to come up and get your 2 cents in, all right? If you're in the box by accident, get yourself out of the box. Because God forbid you come up in the box and the camera goes on by accident and you don't have your wig on. Like what happened to me on the beach. Okay. Yeah, Misty, I was on the B app one time and I went up and God Zeus was commentating and I guess I was tapping. I hit the button by accident and he brought me up. And then see on the B side, the camera don't automatically come on. But on the B side, the camera just brings you up and the camera's automatically on. And I had my wig off. I had to set it off, braids going back. I had potato chip crumbs on my mouth. I was just a messification, baby. God Zeus looked at me. He said, "Oh, wow, oh, whoa, oh, whoa." All right, so let's bring Yvonne up. If you didn't mean to come up, okay, just take yourself out of the box if you didn't mean to be in there. How you doing?
Don't worry. I'm good. I mean to be here. Don't worry.
Okay.
So, I'm sitting here, and I'm kind of feeling sorry for the plaintiff here, because, I don't know how she plans on recovering from all this. There is no way she's going to win this case. And, with everything Cardi's attorney is saying is exactly true. I sat here and watched that just like I watched the Johnny Depp and Amber Heard court case. I'm sitting here watching this, and everything that he pointed out is everything that I said too. I'm like, wait a minute. This story, this is so inconsistent. How the surgeon testified versus what she said, and versus even what the doctor that was on duty and that front desk clerk said. This girl's ruining her life for what? For 5 minutes of fame. And I don't see her coming back from that.
No resuscitation. Yeah, but if I was an employer, I wouldn't trust her with my business. You know what I'm saying? She got, allegedly, everything's all alleged in Miss Knockout's life. She got fired for HIPAA. They tried to say it wasn't for Cardi. I'm going to look into it deeper to see if it actually was. Well, then who was the other person that she got in trouble for HIPAA then? So that means that she's consistently violating people.
I don't know, too. Even that part's confusing, because the doctor that testified on Cardi's behalf said that he reported her after the incident, and then she was let go. He said that. So I'm like, okay, they're saying she didn't get fired for the Cardi incident, but the doctor himself sat on that stand and said that she did. So what really, something's missing there.
Right.
But I'm nosy as hell.
She's probably embarrassed to say that she got it for HIPAA, and then that's going to really damage her case if she says that she got, because that means that she's in the wrong for something.
Right. And the other thing I'll input too, like my mom, she works in the hospital, too, a hospital as well, right?
Mm-hmm.
They know when people are coming, especially important people, down to the food and beverage people in that hospital will even catch wind, like, oh, you know, Cardi's coming. I think that girl knew that information and wanted to go get her shot of Cardi going in to collect, you know, to get her up, get her.
She planted herself in that area. She was doing her security.
She planted herself.
Mm-hmm.
She was trying to get some money and trying
allegedly
to get a photo to get some money.
Mm-hmm.
Allegedly. Because how the heck is there 5 floors there and you just happen to be on the one that Cardi B is on? Not where you're stationed even. Anyways, I'm just preaching to the choir. I think everybody who has common sense knows everything I'm saying is factual at this point.
Right.
Like based on their testimony. But anyways, thank you. I'm not leaving. I love your comments.
Thank you.
Throughout the video. So let all those other people go.
Yeah, they just coming in here. You know, this is what happens when you're a streamer. And then I was at the Diddy trial. You know, I don't like to talk about what goes on behind the scenes. Not saying that everybody comes in there is like jealous of you or whatever, but anytime you stream, you're going to have trolls. And then it's added on that I went down there and a lot of people got, you know, down there got jealous of each other. This one's getting more interviews, this one. So they grow a vengeance, and then people that watch their broadcast come in and they try to say stuff to take your viewership away. But you can't and you won't. So carry on.
No, they won't.
You can't.
It's all about energy. So
right.
If I'm on a live and right, I don't care if you're telling me about that you saw Jesus coming from the heavens.
Yeah.
I'm gone.
Keep it going. Keep talking. I gotta check something. Keep talking.
You have the right energy, so you just have to keep that all up and not worry about these trolls and let them go. Just got pause. I have no clue what I'm supposed to say here.
Yeah, I had to check something with my agent messaged me about something. You know what I'm saying? So I still don't wait, hold on for a minute.
Oh my goodness. Somebody said Cardi can't keep her eyes open. I'm bored too because this is a waste of time. And Cardi should be bored.
All right, y'all. Sorry about that. So yeah, I agree with you in everything you said. You know what I'm saying? It's just like, and then, but here's the thing though. With these court cases, when people are suing people, they always boost it up really, really high. She was never going to get $24 million. I don't care if Cardi B stabified her with a butter knife. She wasn't, right? But they always put it high, and then they shoot for the stars, and then they get what they get. But in this case, right, it might also be that the jurors award her something, right? Or we might see the jurors say, no, 0. We about to see. We don't know, but she might get something. Maybe 50 to like 200,000.
I mean, I don't think she should get anything.
Oh, we don't, right? People, that right, but sometimes in cases, even though they shouldn't get it, it's a lot of people that start cases and sue people that's not even injured, and they work it on up, and then they get something. But the reason why I think she's not going to get a whole lot of money is because that microneedling is not microneedling or whatever, that 3-minute surgery, what they call it surgery, that's not major surgery. It's not going to be to the jurors in their mind. They're going to be thinking the opposite. They're going to be like, this is a joke. What?
Yeah.
It's not no
That's
surgery.
Not major surgery. That's not $24 million worth of surgery.
Yeah, they tried to create something.
And how is she going to prove what she can't? I'm waiting to hear the plaintiff side here. How is she going to prove that the surgery that she did in 22 didn't have anything to do with her car accident?
Well, her lawyers already went. Her lawyers already went because this is the closing argument. So her lawyers already went. But I am going to replay the testimonies like after this is over. I don't know if I'm going to get to it tonight, y'all, because we've been on here a whole workday shift of 5 hours going on 5-6 hours, right? So I don't know if I'm going to get to it today, but tomorrow we're going to have time because it's going to take them a little bit of time to deliberate. It's going to take them a little bit of time. So we're going to have some time to go through it. Yeah, but thank you for your opinion. Yeah, thank you.
Sure, thanks for
Good
having
insight.
me.
Yes. All right, so let's take somebody else. Let's see if somebody else. They're not back yet, y'all. They're not back. So we're taking a few people up. You know what I'm saying? Everybody left. They'll be back. They're going to get a sandwich or something. You know what I'm saying? So they'll be back. Look, 500 people left to get a sandwich. Hey.
How you doing?
I'm good.
I'm kind of, I'm very upset, and I hate to say this. I hate to even feel like this, because where you were just stating that maybe they're trying to get this lady something. For what? You know what I mean?
Well, I'm saying that's how court cases are. Even there's a lot of people that just sue and say they slipped on a banana peel or something and not actually hurt and still get something.
But this is my thing. You came up to her. You followed her. You was the aggressor. Whether I turned around to defend myself or anything, that's because you being aggressive toward me. So how in the hell, why in the hell do you feel that I need to pay you? You know what I mean? Like, what am I paying you for? You're an actual security guard that works here. You're an employee. I'm a patient. I'm visiting. You are in the wrong. I'm not in the wrong. Whether I cuss you back out or not, I'm not in the wrong. You come to me with a phone pointing toward me. You say, oh, I think this is Cardi B. I turn around, I say something, you say my bad, and then you continue to follow me. I understand in cases you could say you flipped and they didn't see it and all of that stuff, or fell and they didn't see it and they still want your money. The state will want your money, whoever wants your money. But with this case, there's too much evidence that states that she was in the wrong, period. So I don't know, I'm just kind of like...
And you can't ignore the heightened level of inconsistency. What, you say that last part?
I said, I'm going to be upset that woman has to give her some unnecessary money when it's proven that she did
Wait, keep talking. What's going on outside? Hold on, y'all. Y'all hear that? Hold on, y'all. What is that?
Yeah, somebody, I don't know, probably train or something. But yeah, why does she have to give her anything for coming to court? Why do I have to be responsible for any of your bills? You did this to yourself. Like I said, she need to be walking with her head hanging low.
I don't know what that is, y'all. That sounds like a fire truck.
Yeah.
And all kinds of stuff going on. So yeah, I agree with you though. It's so many inconsistencies that you can't ignore.
You can't. And then
I'm like, what's...
I heard a boom. Be careful.
Oh, that's firecrackers.
Oh. This early?
Right? Hold on. We getting ready to go outside. Hold on. We getting ready to see what's going on. Right. See? See? You got some insight. We got some insight, yo. Straight from a nurse. Oh, we can't hear you no more. What happened? Can you hear? Okay, now I can hear you. Yeah, but yeah, thank you for that info. I can hear you now.
Is taking videos because you know you're in a hospital, and even if you're a security guard or you delivered the mail or if you delivered the laundry, if you work for the hospital, you are violating HIPAA.
See? There we go. There we have it. There we have it,
I
y'all.
don't have to lie, but okay. I just wanted to give that little insight.
Who said you lying? So how does security that has been saying that she...
I don't know. If they talking to me said I'm not a nurse, but I'm telling the truth. I don't have to lie about being a nurse, but whatever. These people crazy.
Yeah, how do they know that it's just
that's
trolls?
All I wanted to explain because it was too much to write in the chat.
Yeah.
Explain that.
Yeah.
HIPAA doesn't only
Thanks for making that clear.
and medical records.
Yeah. Thanks for making that clear. You know what I'm saying? Because
no problem.
She got rid of all her phone is missing, gone, or no pictures. You know, so and part of that is because she was holding the phone here. Cardi said, so that means that it might be footage on that phone. She wanted to get rid of it.
Oh, yeah, because if they get the phone, they can get the information even if she deleted it.
Yeah, she wiped everything. But see, Cardi could have took it a step further, like the crime people do. I don't know if she would have to pay. Does anybody know she had to pay extra to get one of those specialists to extract it from cloud or send a summons to, different phone carriers to summons her phone records? It's some kind of records. Google has a cloud. Apple has a cloud. They
can just get it from the phone company. The phone company can give them the records.
Yeah, I don't know why she didn't go that far with it. Being with 24 million on the line, I'm going far as I could get. I'm pulling up records. I think
it's my personal opinion, I think it's an open and shut case. This lady is just trying to get a quick buck. She was wrong. She had no business.
But watch what I'm telling you. I'm not sure, but I think they just going to give her something. Because I seen a lot of court cases where the person wasn't even hurt. And they got something. But see, Cardi usually they settle out of court.
She was wrong.
It's not a matter of fact that she was wrong.
I heard something about she said her nails were long and she scratched her, and then they took pictures and they said her nails weren't long. So it's like she's already getting caught up.
And then it was on her nose, and then it wasn't on her nose, and it turned to a werewolf scratch down her cheek. Right? I don't know.
Right. I don't know. I think she's not gonna get anything, and they just gonna throw her butt out of the. They just gonna throw it out.
She gonna get a trip back home and a transfer. I don't know. We about to see. Well,
That's about it.
They're not gonna probably finish deliberating today.
They'll give her transportation back home.
Remember, the lawyers get a third of the settlement. Yeah, but Cardi's lawyers don't get nothing. They just get to win a case. You know what I'm saying? But that's why her lawyer is so vicious, and he's giving me scammer vibes. When her lawyer talks, Ammani, he gives me scammer vibes. Like he is just, twisting and turning. Like the way he said, you came in the courtroom and disrespect, cursing and stuff. Sir, you asked her to say exactly what she said to Ammani. And then you asked her to say it to her. And Cardi was like, say it to her. And Cardi didn't do it because she didn't take the bait. So, all right, y'all, let's bring a few more people up. We're waiting for them to come back on break. Okay, so let's bring a few people up.
Okay, Mr. Knockout, you can drop me down. That's
Okay.
all I wanted to add. I thank you for letting me
Thank you.
come up to your panel.
Thank you. I don't know why this is... Okay, so everybody, we're going to bring a few more people up until they come off of the break. I don't know how my phone is like... was on such a large percent. Oh, it's on 4%. Oops. All right, so let's bring a couple more people up. They didn't come from break yet, y'all. They didn't come from break yet, so we're going to bring a couple more people up until they come from break. Let's hear your opinion. All right. Hello.
How are you?
I'm good.
I'm listening to the lady, the former nurse, talk about the HIPAA law.
Mm-hmm.
I did work, I'm not a nurse, but I've worked for the Department of Health. I've worked at a hospital. And everybody that works in the hospital have to sign the HIPAA law. It doesn't matter who you are, as long as you're in there, because sometimes people come in the hospital, you do not know what they are coming there for, so they don't even want you to take a picture, because that picture could go and people are going to make an assumption to say, oh, this person, like for example, I work for the Department of Health, and I used to work for the STD area. So somebody could walk in there, you don't know what they're walking in there for, so they don't want no picture, because that picture could go out there, and it's going to say a lot of things. People are going to assume, why is that person in there? Oh, they have this. Do you understand?
Right.
So they always sure that nobody...
Because even if somebody says that shows a picture and you going in the STD place and then they say, oh, she got the apartment in Delaware. You know what that is. We abbreviate it. And now, even if they don't have that, people out here believe anything. It's always going to be somebody that's still saying it. No, she got that. She got that. And that's terrible.
And they even tell us, like, before I left where I'm at now, they even tell us, like, when you start working now, when you stop working, like, say you call for somebody's information, I think it's about 10 years before that information could be released. So that HIPAA is going to be covering that person for a long, even when the person dies, you understand? And if you were working there and you happen to release that information, that could get you in trouble.
Right.
So the security was wrong. She didn't have to go take a picture of the person. She could have talked to her, oh, can I take your picture? Maybe has she, because Hattie seemed to be somebody who is just like the regular people. You hear her mouth, how she talk, right?
Right.
So she could have been able to say, okay, yeah, let's take a picture. You understand? But don't show my stomach.
Right.
You understand me? She could have done that, but she didn't do that. And I didn't see everything that is going on. I just recently heard about this incident.
Yeah.
And I saw this morning on the news, they were talking about it. And I'm like, she was wrong. And she's lucky it's only her face that she got scratched. Honestly.
But where's the scratch at, though?
I know, right?
Where's the scratch? Because I looked at that I was looking at that picture. I was like this. I couldn't even, like...
Could be makeup for all we know. Because nowadays, anything goes. You see? That's the problem with the system now, the social media.
Money grab. Money grab.
Money, yeah. 24 million for what? 24 million for what?
These celebrities better watch out. They better move differently. Because now you already a target. But now it seems like the targetness is at an all-time high. Because people are thirsty. You know what I'm saying? They don't want to go make their own money.
She could also sue the doctor's office. Patty could sue the doctor's office.
But I don't think she's going to sue the doctor's office because the doctor came in on her side. So I wouldn't turn around and sue them.
She could have still come in her side, but for that money coming out of her pocket, you understand? For that money that if she's not, which I don't think she will win. I wish I was a juror on that case. I don't think she's going to win. But for the mere fact that they invaded her space, her privacy, the security company, even though she got fired from that company now, they could still sue the security company. Say, because you're the one that hired this person. You understand me? So they have I don't know.
Oh, that's a good point. Look what Jen Dog says. So Jen Dog says she could sue the security place where the girl worked at. So now that is a question. Now that right there, Jen Dog. Yeah, I could see it. If I was her, I wouldn't sue the doctor because the doctor stuck his neck out and told what really happened, and it actually helped her case. So, you don't turn around and, you don't turn around and sue the hand that fed you. That'll be a little vicious. But the security, yes. Yes, I would. If she wins any money, I would get my money back from the security place. Yes. Yes, I would get a refund.
Supposed to be held liable.
Yeah. Thank you, Constant. Thank you, Mama.
These are all training that they get. These are all training that they have to put them through. You send somebody to work in a certain area. This is what you have to do. This is what you follow.
Right.
The greed nowadays is what we are doing. It's sad what we are dealing with now. It's too much.
Yeah. Even parts of the Diddy trial was money grabs. Some of it, he was at fault, but a lot of it is money grabs. Just like this. It's just mixed in. With the truth and the lies. It's all mixed in together like a doggone stew. They're about to come on. Okay, they're about to come on. Okay, we right here. We ready, y'all.
Okay.
We ready.
Thank you very much.
Yes. Thank you. Yeah, because I want to hear what y'all think. Thank you so much. Thank you. So, they're about to come back on at 4:30. They probably might be a little late. Everybody got to shuffle in. They probably went to get something to eat. Cardi B was already sleepy. I hope she didn't eat too heavy. Thank you, Mama. Thank you. Everybody tap a 5. We're almost at 300K. All right. Let's get to a cool 500K today. All right. Thank you, Mama Chef. Everybody tap a 5. Everybody share a 5. And everybody bless a 5 so she's not broke a 5. All right. And everybody, I keep forgetting to say this, but the candy to the apple. Thank you, Sleeping Butt. Is in my profile. Okay, it's the first linkification at the top. All right, the candy apple. Read between the lines, y'all. I'm just saying it because somebody messaged me and asked me what it was just now. So the candy apple is in my profile, right? Just like my name. Thank you, Mama. So we getting ready to go back in. Let's see if we could take one more, and then when they come back up, we'll let's see. Okay, so they're not, the court is on lunch break. It's just 4:31. They should be coming back. Okay, let's see if we could bring one more person up while they're coming back. Let's bring one more person up because they're still coming back. Hello? Hello? Oh, I think, did you mean to come up? Okay, I don't think she meant to come up. Okay, or he. I don't know. I'm saying she, or I'm assuming. Thank you, Mama. Thank you. Okay, let's bring a few more people before we go back in. All right. There's no violation of HIPAA. You have never even read it. Huh? What you talking about, Keto? Keto said there's no violation of HIPAA. You've never even read it. You got one follower, and you following 2 people, which tells me that you just made the page. You just made that page, and you come in here and you say there's no violation of HIPAA, right? You have never read it. And you know what I'm going to say to that? Ammani, is that you, Ammani? Is that you? Ammani,
is so wrong.
Is that you? What's up? What's up? What's up, Nicole? How you doing? Hello? Nicole, do you know you're up here?
Hello?
Yeah, you know you up here? Or you meant to come up?
Oh, okay. No, it had froze.
Oh, okay. What's up?
Yeah, your screen had froze.
Oh, it did?
So, I am an armed security guard. I am an armed security guard in Louisiana.
Okay.
I am a field manager. I had to take classes and sign documents for HIPAA. She did violate a HIPAA law. Work in hospitals and dialysis clinics. Any medical center that you work in, you have to sign a HIPAA form
noting that you would not tell anything you see, hear, witness. You might peek at, you might run across. You can't tell nothing that happened in that medical center. Nothing. If you see a patient that had been failed or whatever, you cannot tell none of these people business. You can't tell if these people came in there for a pap smear, a toenail removal. You can't tell none of it. If you do, these people can sue you and you will be fired. I know this because I work in a dialysis clinic. I can't tell none of these people business. I can't even say what these people talk about to each other.
And you, it might be somebody you know that's there, your neighbor, coming to the STD clinic. You know what I'm saying? You sitting there watching them getting diagnosed. You can't come tell nobody. And also, it could go beyond just getting fired. They could press charges against you for that. You could get in a lot of trouble for it.
Pretty hard.
Oh, you froze up a little bit.
Very, very big trouble for it because you are telling these people medical history.
Can you ask?
This is a medical center. You can't tell nothing about these people at all.
So they're saying, can I ask if you can continue to work in that field after you lose your job? I don't know. I don't know the answer to that. I work in the healthcare field and we lost employees because of HIPAA. Okay, so Nicole, I think that's you that's freezing, Nicole. Am I frozen, y'all? Am I frozen? I think that's Nicole that's freezing. Or is it me? Am I freezing or her? Oh, Nicole, I think that's you freezing.
You can't say nothing at all.
No, Nicole, she can hear me.
Huh?
So, I think that's you that's freezing because,
hold on.
Yeah,
Can you hear me now?
Because I can hear you, but I don't think you can hear me at times because you freeze up. Because they said that I'm not frozen, but it's all good. You can hear me now, so continue. Hello? It's probably the area she's standing in. It's the area she's standing in. All right, let's see if they're back, y'all. Let's see if they're back. Hold on, let's see if they're back. Hold on. And another thing, right? But she worked real hard for them to not get that footage of whether she filmed or not. That's why she got rid of that phone. Because if they would have got hold of her phone or her phone records or her phone, and found out that she was filming, then Cardi B can actually press charges on her, counter sue her for HIPAA, in the HIPAA realm also. I learned my lesson big time. How'd you learn your lesson, Crystal? All right, they didn't come back up yet, so we could bring somebody else up. Let's bring somebody else up. They didn't come back yet, so let's bring somebody else up. All right. So the person had one follower. They're following two. That means you just made a page and you came straight to Miss Knockout out of everybody on TikTok. How you doing, user?
Hi, good afternoon. I have a little accent, okay, because I'm Puerto Rican and Dominican. And I work in Jersey City Medical Center. And it's true what they said. So I work as a supervisor with the people that they clean their rooms, and we signed, and we're not allowed to give any information to anybody.
See?
Okay?
Everybody
so
signed.
She did wrong. I don't think she deserved anything. That's my opinion. Everybody's different, but in my opinion, they give us, the form when you filled out the application, and they told you exactly what we don't supposed to do.
Now, even Cardi B said, and which I think the girl was trying to deny it, Cardi B said when she was on the phone, she told somebody, Cardi B is here, Cardi B is here. And then the phone went from here to here. So even by her telling people, Cardi B is here, that's a violation of HIPAA too. By her telling Cardi B is here, Cardi B is here. That's a violation. That's why she denied it adamantly. And that's why she got rid of that phone. But if I wish I could
to hide evidence. That's
right.
what I think she did.
But if I was Cardi B, I would have hired she got the money. I would have hired a analyzer of phones to subpoena the phone company and get her phone, because even if you throw the records away, the phone company could subpoena your records and still get everything off the phone. And if they can't get the pictures, they could get, if you text somebody, if you text your mama. You know what I'm saying?
Yeah, but the guy, I'm sorry to interrupt you, the guy and the girl, it seems like money hunger. They're so desperate to get money. And
you mean the lawyer, her lawyer.
Nobody wants to her lawyer. Now after the pandemic, nobody wants to work. They wanted easy money. They wanted to sue everybody, and I think it's not fair. It's just my opinion. Thank you so much.
Yes. They're not back yet. Thank you so much for your input. See? So she said that she cleaned the room. They even make them sign it. Everybody, that's why she worked hard to get rid of that evidence. She worked hard to get rid of that evidence because she already knew. She knew what she signed in that hospital. She knew it. They're not back yet, y'all. So we're going to keep taking people till they come back.
Hi.
They're not back yet. How you doing?
Hi, I'm here. I'm actually calling from the UK. And I've been watching you for the longest time. I love your stuff, girl.
Thank you.
You're doing great.
Thank you.
I just wanted to say, she needs to get countersued.
Thank you, Mama.
I feel like she's been literally out here to get a piece of money. She saw an opportunity. Everything that she said has been proven to be a lie so far. And on top of it, I mean, literally, I feel at this point she needs to be made, an example out of.
Exactly. That's what I feel like. If she's here.
If people keep doing this, especially to Cardi, knowing that Cardi's a fiery lady, but she's not going to.
Thank you for the follow.
Unnecessarily.
Thank you, Miss Barry.
I think this would help stop people trying it with her. Do you know what I mean?
Yeah. And also, I feel like if she does win a good lump sum of money, it's going to encourage copycat stuff, and people are going to go out and antagonize stars. You know what I'm saying? And then you get a hothead, allegedly, like Chris Brown, who's known to be a firecracker. And they could be easily baited into an argument. Now, it's Cardi B. Cardi B gave this girl, the girl got money out of Cardi B, so now I could do it too. It's sending a signal out.
But so my other question is, so if you lose your job for violating HIPAA, are you allowed to have another job in that field straight afterwards, or is there a clause that stops you from working in that field for maybe 6 months to a year or something? Just wondering.
That's a good question. Well, maybe one of the nurses can answer that, because I got to do something to my browser won't update, and I didn't want to mess with it till I got out the broadcast. So I can't really chat GTP because the browser didn't update. So until I figured it out, but that's a good one of the nurses can answer that. So we still got one of the nurses, or even the person who worked with the cleaning people in there. Does HIPAA, when you get fired from there, can you work immediately after? Or are you just violated and forever? Like, how does that work? No, it don't affect her unless she was a nurse. Oh, so if she was a nurse, you get blacklisted because you broke federal law. Okay, but they just said, and the nurses came in here and said, Stormy, right, that everybody signs the HIPAA law. The security guards, the cleaner lady, the person who washes the windows, everybody.
Exactly.
So she does get penalized for that.
Because she's now got a new job, I'm just wondering if the result of this case is going to end up having her lose her new job.
Okay, so can you work after HIPAA violation in the medical field? Because maybe, like, if you want to work with clothes, okay, but, you still got to get a review and everything. Exactly. Right? Oh, okay, so this is working. So, yes, you can still work after a HIPAA violation in the medical field, but it depends on Okay? If it's minor, accidental disclosure to a family member of wrong facts. So you wrongfully did it. You made a mistake. Usually results in training and a written warning, and you can likely stay employed. Moderate, repeatedly checking patient records without cause may lead to suspension or termination. Future employment possibly will be harder to obtain. Right? Severe, leaking celebrity info. Whoa, there we go.
Shazam!
Okay? Leaking of celebrity info is considered severe. Leaking celebrity info, selling data, intentionally snooping. Snooping. Like this. It's Cardi B, y'all. Cardi B is here.
Exactly.
That's why she adamantly denied that. So if you wasn't doing that, so what was the argument over, miss? I wish somebody would have asked her. If you weren't doing all that, so what do you say that the argument was over?
So here's my last thing is, you kind of notice with everything that we've just pulled out, the fact that the CCTV went missing. Now I know.
Wait, the CCTV on where? On the court? On the building?
In the building, because technically she was a security guard, so she would have had the ability to delete it, couldn't she?
She could go to somebody and they could work with her to delete it. Like she might not work. See, they have everybody stationed in different places. So you got the people that's monitoring the security cameras, or maybe they just have the security cameras that's running, and she probably ran in there and got rid of it real quick.
Exactly.
Or she told other people, like, look, I might be in trouble. Can you get rid of this? Do me a solid.
Exactly. See, this is why I love you, Miss Knockout. Thank you so much.
Yeah, because how would we have this whole incident like this in a complex that's in California? I know it's swanky if Cardi B went there. How did they not have cameras?
Exactly.
They got stars roaming around, going here and there all over Cali. Why wouldn't they have cameras?
Exactly.
So if you're thinking that, and I'm thinking that, the jury's going to be thinking that too.
Exactly. Well, I'm hoping so.
Well, we're going to see. We're going to see.
She doesn't deserve a red pen, and I do.
Hey, Miss Shelley. Thank you.
Cardi wipes the floor with her.
Okay, they're not back yet. They're not back yet, y'all.
So thank you so much.
Thank you so much. Thank you for your opinion. All right, so we got a couple of... Yeah, thank you. I appreciate you. Thank you so much. So now we still got a couple of minutes. They're a little late coming back. They were supposed to be back at 4:30 out time. Oh, we ain't got nobody else in the queue. You know what I'm saying? She won't be back in court till after 2, how California court works. Okay. All right, so 2, 3, 4, 5. Okay, so that's in 10 minutes. So we got quick time to do a battle, y'all. Let's do a battle. We got 10 minutes to battle.
Oh, man, how are you?
How are you doing? So, yeah, my time, Eastern time, that's 5 o'clock, y'all. So let's do this quick battle, and then we're going to get back into the casification, because she should be coming back in about a little over 10 minutes. So, how you doing there?
Good. Where are you from? Thank you for following me.
I'm from New York City. We are friends already, so I'm already following you.
Nice to meet you. Thank you for following me. I'm from Syria.
You're from Syria. All right. Thank you, Key. Everybody running fired up. Let's do this quick whippification before we go back to the trial.
Just a minute. I show you photo. Yes, okay or no?
You show my photo? You want to
show you one photo for me what?
Yeah, okay. You want to show me a photo of what?
Photo one for me wife. Look.
Okay.
Hint. This hint for me wife.
What is that? Her foot?
Listen, wait. Just.
Okay, I seen a foot. Everybody running fired up, y'all. Running fired up. Okay, so my wife is disabled from I need help to treat. Okay, well, we're doing a battle now. You know what I'm saying? I don't solicit through, over here we don't solicitate our people. You know what I'm saying? So, you show the picture, people see it, they can help if they like. It's all good. Thank you so much, Michelle. Everybody run a fire up, run a fire up. Run a fire up. So, yeah, so it's stuff going on over there in Syria, huh?
Yes, Syria happened war, everything's no good.
So now let me ask you a question. In Syria, right? Like in the USA, right? I pay $50 a month for my phone bill, right? How much do you pay for your phone bill in Syria?
I am work TikTok for my food, children 3, and my wife hand medicine because my city war and I lose everything.
Oh, but how much does it cost to keep your phone running every month?
I recharge coins for money. I don't have work, only TikTok.
No, we're not asking about work. I'm asking you, you have a cell phone because you're on the phone. I see you, right? So you either have Wi-Fi or cell phone. So how much does it cost for Wi-Fi every month?
Yes, every person have telephone and have Wi-Fi.
Yeah. How much does it cost?
My telephone, $15.
$15? That's US dollars? 15?
Yes, my
okay.
telephone.
And then you got Wi-Fi. How much is the Wi-Fi?
Wi-Fi every month.
Hey, caller.
$10.
$10. Oh, okay. So that's $25. You got a good deal. 10 minutes to go. Yeah, we're going to be back in the case. Everybody run a fire up. Run a fire up. That's really cheap. I wish my phone bill was $15. Shoot, we be paying that with a breeze. I mean, $50 is cheap. I seen one phone company say $25. Robin said, not true. How much is it? How much is it do you pay? Robin said, not true. Do you live over there, Robin? All right, everybody. The case is getting ready to start back. We're just doing a little quickified battleification. Everybody run a fire up, run a fire up. I'm supposed to be doing battles more because I'm almost out of my league, but I don't battle too much. I haven't been, so I got to make it a point, It's included in the hip-hop grind, to battle. All right? So I only pay $10 a month here for phone in UK. $10 a month. $10. How much is that in US dollars, Donna? Donna only pays. Okay, so I pay $70 for internet and $60 for phone. I would love his bill. Wasn't we talking about Cardi? We are talking about Cardi, but we was doing a little battle because we're waiting for them to come back to the court. So while we waiting for Cardi to come back to court, we took people to come up to still talk about Cardi, and that has depleted because there's nobody else in the queue. So while we're waiting on Cardi, I figure I'd do a battle because that's part of my journey on TikTok, and I can't just admit it. It's affecting how I'm leveling up on TikTok. So I got to take a battle here or there. I'm in England. I wish I had that deal. Yeah, I wish I had that deal too. I paid $50 for that. Thank you. Everybody come on in. Thank you so much. Thank you so much. I appreciate it. Everybody give him a little blessification. Okay? Give him a little blessification over there, y'all. You could run over there and run back. Look out for him. He's in a country in Syria. You want to go again? Okay, we'll go one more, only because Cardi didn't come back yet. So once Cardi comes back, then we're going to have to go. All right? So, yeah. Everybody come on in. We're waiting for Cardi B to come back, and then we're going to dive back in. So far, their lawyers gave their account. To me, Cardi's lawyers was speaking on facts, but the lawyer for Ammani, to me, he kept on turning stuff around and doing a lot of trickery with words, like saying she was disrespectful to the court, Right? Everybody come on in. Everybody runify it up. Everybody tapify, tapify, tapify. She was disrespectful to the court for cussing and all that. Well, sir, you asked her to say what she said to the girl. She had looked to the judge and said, look, can I cuss? She asked that. She said something about it. Sure, go right ahead. Only for you to try to set her up for cursing. That left her like little, he lost brownie points in my mouth for that. He lost brownie points for that. Trickery at its finest. Trickery. Everybody runify it up, runify it up. Runify it up. Tapify, runify. Alright, best viewers on stream. Oh yeah? Oh, okay. I don't know what that is. Alright, so we're waiting for Cardi B to come back. We're just doing a little battleification. I thought you were supposed to say the truth, so it's bad words. Oh well. I thought you were supposed to say the truth. What? I don't understand that, Stephanie. What do you mean? What do you mean you're supposed to? I thought I was supposed to say the truth, or you talking about Cardi B? Right, he was. Yes. So Cardi B only said, you saying Cardi, yeah. Cardi B only repeated what she said to the girl. But come only to find out that he baited and tricked her into saying it, only to say that she was disrecording the court to make her look bad. Now, one thing about this jury, I'm willing to bet they ain't stupefied. They not stupefied. They gonna read in between that. Oh, we need 60, y'all. We need 60 points, y'all. Come on, y'all. We need one person could do it. Even one person to do it. One person do it. You are supposed to say the truth in court. Everybody, come on, y'all. We need 60 points. We need 60. Come on, y'all. Let's get it. We got 10 seconds to get 60. 10 seconds. Yes, we reached the target. All right, 2-time gifting is starting soon. All right, 2-time gifting is starting soon, y'all. Let's wait for the 2-time gifting. Y'all, let's wait for, save the gift for the 2-time gifting. Okay, 2-time gifting started. Go ahead, y'all. 2 times gifting started. Everybody blessify, runify it up. Runify it up. We're waiting for Cardi B to come back, y'all. We're waiting for Cardi B to come back. All right, so Cardi B hasn't come back yet. Thank you so much for the blessification. Thank you so much. Everybody runify it up. Runify it up. Runify it up, everybody. Hey. Hello?
Miss?
Yes.
Miss?
Yes?
Support me. Two ballon no support, no coins finish.
Okay. Followfy him, y'all. Followfy Ahmed 90. All right. Yeah, she had threw a pen on a reporter outside the court.
Me, please help.
She threw a pen. Who threw a pen at the reporter outside? Who threw a pen at the reporter outside? Thank you so much, y'all. Everybody, come on in. Okay, we got a minute left. We got a minute. Who threw a pen at Cardi? Is that true, y'all? Did Cardi throw a pen outside the courtroom? Is that true? It's on TMZ? It's on TMZ? Oh.
Welcome, guys. Welcome.
Oh, wow.
Yes. Welcome.
I didn't see that. Let's go look. Oh no, she needs to keep her cool. Yeah, now Cardi. Come on, Cardi. Come on, Cardi. So the reporter now remember, she's also preggo, so that's like mood swings and stuff like that. Okay, so let's see what they're saying, y'all.
Come on, guys, let's go.
Let's see what they're saying, y'all. Let's see. My browser's acting up, so let's see if we could get it. Okay, let's see. Okay, let's see. All right, everybody. Okay, listen. Thank you, but I got to continue my show, okay? I got to continue my show. I would love to battle you again, but I got to continue my show. All right? It's nice seeing you. All right. So, yeah, he wants to battle all day, that guy. But I got to do a couple of battles because I got to increase my league right? It's part of the TikTok journey to increase the league. All right, so let's look for Cardi. Okay, so Cardi was Cardi went from glowing to growling after leaving court on Tuesday after somebody dared to ask if she was pregnant. Okay, so they asked if she was pregnant, and that's what set her off. But she still shouldn't. And Cardi, you shouldn't have threw that pen. You shouldn't threw that pen at them, because now it's like, now you're throwing a pen. Now we're trying to prove, Cardi, they ain't there trying to prove that you're not violent and you're not, you know. So TMZ caught the wild exchange earlier. Somebody off camera asked if she would predict any paternity drama with Stephon Diggs. So they're already putting her in, jinxing her relationship with Stephon Diggs in light of Offset apparently bragging that he banged her up with baby number 4, allegedly. So allegedly, Offset is saying that he's the one who got the baby, allegedly. Maybe Offset didn't say nothing. Who knows? You know how they turn stuff around, right? So Cardi didn't take kindly to the question coming from the guy outside the courtroom, right? And Alhambra, California courthouse, and threw a pen in a fit of rage, causing her bodyguard to call her back. Wow. See, now, technically, the jury can't use that against her. It's only due to their case. So they can't. But because they're human, the jurors, human nature, you know what I'm saying? Let me see if I could pull it up. Let's see if I could pull up the audio. Okay, goes ballpoint ballistic over pregnancy question. Now, this was what the whole trial is about. Protecting her pregnancy. Right? Now, look what she come out the courtroom and what do they ask her? About the very thing that she's trying to protect again. Did it hit anyone? I don't know. We're going to find out. Oh, so the polka dot thing is not a dress. It's a pantsuit. It's cute.
Hey, Cardi, you're beautiful.
Thank you.
Cardi, insiders are claiming that Offset is publicly bragging about getting you pregnant for the 4th time.
That sounds like Danette. That sounds like Danette. Y'all, don't that sound like Danette? Yeah, you can't see because TikTok will penalize me if I show something that's considered copyright, Liberty. So that's why I'm only doing audio. All right? That sounds like Danette. Ooh, Danette got a pen thrown at him. Now, I bet you're going to try to suicide him. How much you want to bet? How much you want to bet he's going to try to suicide?
Do you foresee any paternity issues with Stephon Diggs?
Stop disrespecting me. Don't disrespect me.
I got another marker card.
So the pen didn't hit him. The pen hit the mic. Okay? The pen hit the button. So she threw the pen not at him. She threw the pen at the mic.
Stephon Diggs.
So she threw the pen at the mics. So she knew not to throw the pen at him. She threw the pen at the mic, Sean. The pen hit the mic. Let's see. Let's go back. And no, it don't even look like a pen. It looked like a piece of paper. So who won? We don't know who won yet. We're waiting for them to come back. They didn't even finish arguments yet. So Danette. That means Danette is at Danette is out there at the trial. That sound like, I don't know if it's Danette, but it sure sound like him, right? Don't it sound like Danette? Do it sound like Danette? Let's go to Danette's page. Let's see if Danette got anything on Cardi B case. Let's see. So Danette was at the Diddy trial. That's the one who was having all of the thing. He was going back and forth with Gene Deal. Okay? Now, he's not the one who came at the Tisa Tells. That's another guy called Ratchet TV. So people get confused and they thought it was him, but it's not him. So let's see if Danette got anything on, let's see if Danette got anything on Cardi B trial, because I'm telling you, I know that voice. Okay, breaking news, Danette arrested for what? Is this it? Well, oh, okay.
A breaking story that.
Okay, so this don't look like, no, this look like it's something different. Okay, so this is from 2 weeks ago, so that's different. All right, so I don't want to play that on here anyway. Gene Deal, okay. No, that's from Gene Deal. Okay, Denot. Okay, so where's his channel at? I want to see if Denot is at the Cardi B trial. I think he lost. Denot said, okay, so this is old. This is old. Danny Rush, that's old. So I really don't see anything on it. I really don't see it. Denot is back 10 days ago. Okay, so the last I heard, Denot got arrested for something. The last I heard. But I don't talk about other content creators on here. It's on. Okay, let's go back to it, y'all. Okay, let's go back to it. That surely sounds like Denot, though. But we will soon find out. I bet you we're going to find out if that's Denot or not. Okay, we will find out. Okay, so let's get back to the case. Let's get back to the case, y'all. Let's see. Oh, they're not back yet. I don't know where you say they're back at, but they're not back on the channel that I'm at. Where do you see that they're back at? Deshaun. So Court TV, they're not back yet. Is this 505? They're probably coming back any second. Maybe this channel is just delayed. Court TV. Okay. Let's mosey on over to Court TV then. Because the crime channel is lacking. Alright, so let's mosey over on Court TV. Wait. No, Court TV is what I had on. Let's see if they're back. Court TV is not back yet. They're still showing the screen. Which one y'all say is back? Court TV is not back. I'm looking at it right now. No, they're not back. Yeah, they're not back. Okay. All right. So, yeah. So Cardi B, like, okay, let's finish watching it.
Stop disrespecting me. Don't disrespect me.
I got another marker.
Cardi, your courtroom is amazing.
You are amazing. I still love you, even though you just threw some stuff at me.
I don't care. You just.
He said, I still love you, even though you threw some stuff at me, right? So now you throwing stuff at another person, and especially if let's see.
Respectful. Don't do that. Do you see women asking those type of questions to me? You see women asking those questions?
That is Denot. That is Denot. Look at here, y'all. There you go, right here. Y'all want me to show you? That's Denot, y'all. Let me show y'all. Hold on. Let me turn it around. Hold up. Ain't that Denot? Look at him. Denot always has that around his camera. That's Denot, y'all. That is Denot. Allegedly. Right? So she threw something at you, Denot, but it didn't hit you. So if you go to court, you got at least 50 cameras out there that's going to say that the pen hit the mics. I watched
the matter. Counsel, the parties are present. As are the members of our jury and the members of our jury. And I'll resume the defense closing argument.
Okay, they're back, y'all. They're back.
So picking up where I left off.
So see, he couldn't sue her because Cardi B went out. He asked her a messy question about her pregnancy, saying that Offset is saying that he's the one who smashed her up with baby 4, allegedly, and she got heated and she threw a pen, but she threw the pen at the mic and she said, "Stop disrespecting me."
Cardi testified in this courtroom that the whole encounter was maybe 45 seconds, less than a minute. Counsel has urged, and I'll get back to this as well, that she didn't see what happened before, but if you add her and compare her estimates with those of Tiara and Dr. Finke, who said that it lasted about 45 seconds, it's clear that they came out right at the beginning. Now, Cardi also testified in front of you and under oath that she never spit on plaintiff. She never struck or cut plaintiff. She never touched plaintiff's face. She never used the N-word. She never threatened to get plaintiff fired. Cardi also testified that she is in fact left-handed, and we've talked already about how that undercuts Dr. Monica's theory that a right-handed person caused the claimed scar. Cardi testified that she didn't have any 3-inch nails at the time of this incident in February of 2018. She also testified that she was in Los Angeles. She lives back east, and she was in Los Angeles for the NBA All-Stars weekend in 2018. And we put into evidence a photograph of Cardi to prove that her fingernails were an inch or less. It's a photograph that she testified was taken at the NBA All-Star weekend. And you heard counsel earlier say that Cardi testified that photograph was taken on the same day of the alleged incident on February 24th. That's absolutely untrue. She did not testify to that. If you are unclear, the record can be read back to you, but I expect that you were here and heard Cardi testify that she was here for a week or so and kept the same fingernails this entire time, and that includes February 24th. The assertion by counsel that she testified to something she did not, in fact, testify to is something that Your Honor that the judge had already indicated is something you should disregard. Now, she testified that the nails she was wearing while she was in Los Angeles were coffin square and not pointy. That was a new one on me. Apparently coffin square means the shape and square and it can't cut anything. She also confirmed and testified that the rhinestone images were flat. They were not pointy and they had no sharp.
I kind of disagree with that. I kind of think that you can get cut by a coffin if they really scratching you. Not to say if she got scratched or not, that's still up in the air for debate. But a coffin nail can actually scratch you. So I kind of disagree with that, Mr. Sir. But he's a man, so he don't know.
Edges. Apparently you can get rhinestones either as little decals on fingerprints or as rhinestones themselves. I'm not like Dr. Finke, a fingernail expert, so I won't talk about that. But the point is, rhinestones can appear on a fingernail, a decorated fingernail, either as three-dimensional or as flat, which, of course, flat can't cut anything. And she testified, as did Dr. Finke, I misspoke. She testified that they were flat. Dr. Finke, counsel had said, testified that they were sharp. He actually testified he didn't know whether they were sharp or flat. It is very important, actually, also that while plaintiff's testimony about what happened is uncorroborated, she called no witnesses who were actually there. Cardi actually did have 2 witnesses. And we'll get back to that. I do want to mention something that plaintiff's counsel raised, which is there's testimony from Cardi that as plaintiff advanced towards her swearing and pushing her back, that their chests touched. And counsel told you that that's an assault right there, that his client wins. Well, there's a couple of problems with that. Just touching chests like that is not an assault, and if it is an assault, it's an assault by plaintiff on Cardi. Cardi was being pushed back. That's the testimony from all of both of the witnesses and Cardi herself. But I should mention, just in case you want to know, there is an instruction in the jury instructions that deals with the defense of self-defense. Counsel said that is inapplicable here because Cardi denies that she touched anyone or had to act in self-defense, or that she cut plaintiff. The point he's overlooking is that is up to you. You've heard the evidence. We think it's overwhelming that Cardi did not touch plaintiff at any point in time and did not touch this magic appearing, disappearing scar. But we have to be careful as lawyers. So we've included a defense of self-defense instruction, which means that if you were to find that Cardi did touch plaintiff, or that somehow a chest-to-chest caused by plaintiff is an assault by Cardi, which we dispute strongly, there is an instruction that the judge has given you that self-defense applies if a person reasonably believes that another person was going to harm her or him, and the person uses only the amount of force reasonably necessary for protection. I think there can be no doubt that Cardi was faced with someone bigger than her who was trying to hurt her. We know that.
Now, just a question. How will we know if Cardi B paid somebody? Were we there? Did somebody tell you that Cardi B paid him? Did you see it with your own eyes? I didn't see anything in the media saying that Cardi B paid her witnesses. So how would we know that? How would we know that? So we're going to do it after the arguments. Okay, we're doing it after the arguments. Okay, we're listening to the arguments now because that's what people want to hear. But I was just curious, how would you know that Cardi paid off her people? Were you there watching her give the money to her? How would you know that? I'm just asking you a question real quick. How would you know that Cardi B paid off her witnesses? I'm just curious.
From both Cardi's testimony, Tiara's testimony, Tiara Malcolm, and I believe also Dr. Finkel. But let's talk about Ms. Malcolm, Tiara Malcolm.
Okay, so the witnesses, right, was one, the receptionist, and two, the doctor who's working on their job. Okay, the doctor has a lot to lose. He could lose his license. Accepting a bribe from a person, you could lose your license from that. And the receptionist works for him. So I don't know about you, but if I'm a doctor, I ain't chancing my license for nobody. Okay?
We called her as a witness, so we'll have her there. And she is one.
That's what my ex says. I should have been a lawyer. That's what my ex. He said, you ain't gonna never get no man. You should have been the FBI.
One of the four people who were in the hallway, and she testified as an eyewitness, and she has no axe to grind. She's not a friend of Plaintiff. She's not a friend of Cardi. She doesn't work for Cardi. They never met before. And so, again,
they've never met before. She doesn't work for Cardi, right? Other than her breaking it up, okay?
She's an independent third-party witness. She testified that she was Dr. Finke's receptionist and
maybe somebody talk. Maybe somebody can talk. But I'm asking Chiquita, I'm asking her. She said that Cardi paid her people off. So I'm asking her, how does she know that? Yes, people can do things and then people talk. But I'm asking the person who said it, how do you know that Cardi B paid her off? Did you see her give the money? Did you see that somewhere on the news? Because I never seen it. So I'm just curious. I'm just asking that. How would you know that?
Expecting Cardi for a secret appointment. As a receptionist, she was...
So Cardi looks like she's clearly agitated for that extent that altercation outside, you could tell it sent her to the highest degree. And now she looks like she is really over it. Okay, thank you, A. Addo. Thank you. And again, she could be get sued for making that statement. Oh yeah. Well, everything in the Miss Knockouts Live is all alleged.
Was near the front door.
Look, I didn't say Cardi pay anybody because I ain't seen that with my own eyes. I want to see it with my own eyes before I say that something is so. You know what I'm saying?
That's why she got out first before Dr. Finke, whose office was in the back. She testified it was a Saturday and all the other offices in the building were closed. And they closed early because, quote, they didn't want anyone there when Cardi arrived.
I agree with you. She shouldn't have thrown that thing at the thing and showing A, but they cannot use what Cardi did outside the courtroom. They can't use it in this case, y'all. Now, the jurors are human. I don't know if the jurors might not know about it yet because I don't know if they got their phones or they could watch anything. They're not allowed. When you're in cases like this, you're not allowed to watch, talk about the case, watch stuff. You're not allowed. So they probably didn't see that Cardi B threw the pen. They probably didn't see it. Now, the other lawyer looked like he's so grimy that he would probably come back and mention it. And then the judge is going to immediately interject and object because you cannot use that in the case. This has nothing to do with the case. We're dealing with Ammani and Cardi B. Hopefully they can't because they don't know. Yeah, they can't use that in the case today. It has nothing to do with it.
When Ms. Malcolm, she testified that when she heard yelling, she immediately ran out. She's near the door. There's nothing she really could have missed once the yelling started. Defense counsel has argued that, again, that she wasn't there in the beginning.
At the time,
the testimony she was near the door, immediately ran out when she heard yelling. Now we have a visual rendering based on plaintiff's own photograph of the hallway outside the doctor's office and based on the testimony and Cardi of Ms. Malcolm. This shows how far, you see the elevator bank and you see the doors that are depicted in the photograph that the plaintiff showed you, plaintiff's counsel showed you. And where did they end up? They ended up in that corner. That's how far this demonstrates, based on the testimony and evidence in this case, how far plaintiff forced Cardi B backwards and into the corner that Tiara Malcolm saw her when Tiara opened the door into the hallway. Ms. Malcolm specifically testified that when she opened the door, she saw that plaintiff had Cardi against the corner. Ms. Malcolm testified that she said, "What are you doing? You're at work. Go back to your post." And that the plaintiff just refused. She was going after Cardi. She was yelling, screaming. Ms. Malcolm testified that she got between them, with Cardi behind her and with Ms. Malcolm facing plaintiff.
Hello. Hey, Esther.
The evidence is that at that point, Ms. Malcolm testified that plaintiff was swinging at Cardi, who was behind Ms. Malcolm. That's what she testified to. Now, Ms. Malcolm didn't realize at first that she was hit. She went after Dr. Finke came out and tried to deal with plaintiff. Ms. Malcolm took Cardi into the office, and someone else at the office, this is what she testified, what Ms. Malcolm testified to, someone else at the office said, "What happened to your head?" That's when she found out. In all the brouhaha, she did not realize, with Cardi behind her and plaintiff in front of her swinging away, Ms. Malcolm did not realize that she had been hit. Now, counsel told you in his opening statement that Ms. Malcolm didn't know she was hit. She knew she was hit. She went back to the office and she saw the scratch on her own head.
Right, April?
Counsel has argued
Your Honor, I would object to him referring to counsel. We can talk about facts on counsel.
Overall, plaintiff's counsel has argued to you that Ms. Malcolm didn't know who hit her. Okay, and he dwelled on that a lot in his cross-examination of Ms. Malcolm, and with all the things flying, with all of plaintiff's hands flying in the air, what Ms. Malcolm explained is her back was to Cardi. Ms. Malcolm specifically testified she did not see.
Give me 2 seconds, Joe. Give me 2 seconds. Hold on.
Cardi's hands go in front of her, go by Ms. Malcolm's head. But she did see plaintiff flailing away trying to get to Cardi. That's why she concludes that it was plaintiff who hit her. And it only makes sense. Cardi was behind Ms. Malcolm, and Ms. Malcolm was hit in the forehead, face to face with plaintiff. Again, I apologize for the language, but it's important that you hear this. Ms. Malcolm also heard plaintiff, who was almost double the size of Cardi, expressly threaten in no uncertain terms to harm Cardi. Quote, "I will F your shit up." That's what Tiara Malcolm testified to. She heard plaintiff threaten Cardi. That's an express threat. If anyone was being assaulted by threats of immediate offensive contact, it was Cardi who was being assaulted by plaintiff. Ms. Malcolm testified that while Cardi was behind her and Ms. Malcolm was face-to-face with plaintiff, Ms. Malcolm did not see any scratches or cuts on plaintiff's face, any blood on plaintiff's face, any injury at all on plaintiff.
Okay, so Malcolm is Tiara, who is the receptionist, right? So the receptionist is the one who broke them up. So she was right there. Okay? She was right there. So she said that she didn't see any scratches on him. Nothing. Remember that part of the testimony? Remember?
Plaintiff's face, or any spit or spittle on plaintiff's face. Ms. Malcolm also testified that Dr. Finke came out of the office into the hallway and tried to get plaintiff to stop and leave. Ms. Malcolm then got Cardi into the doctor's office. She testified that throughout this, plaintiff had her phone in her hand. I want to repeat that. So she testified here that she was using earphones. We've got another witness who says plaintiff was standing there, flailing away with her phone in her hand. Now, Ms. Malcolm also testified, and I know this gets a little bit repetitive, but it's important you remember this testimony and you take it into account when you deliberate. Ms. Malcolm also testified that Cardi did not hit plaintiff, that Cardi did not cut plaintiff with her fingernails, that Cardi did not use the N-word. Cardi Ms. Malcolm testified with Cardi behind her, almost touching her back. She did not see or feel Cardi swing at plaintiff. They didn't touch each other, although counsel asked what about chest to chest, and Ms. Malcolm testified, which seems truthfully, when plaintiff had Cardi in a corner, Malcolm could not tell if their chests were touching. That's because she's behind them. She's coming out of the office door. Ms. Malcolm also testified that a few months later, plaintiff asked Ms. Malcolm to help her go after Cardi. Now, if you remember, counsel for plaintiff elicited testimony from plaintiff that she never really intended to sue Cardi. She never intended to go after Cardi. But that's not what Ms. Malcolm says. Ms. Plaintiff was trying to elicit witnesses to support a claim against Cardi. And Ms. Malcolm said, thank you, but no thank you. And she did that because she felt the plaintiff was at fault and, quote, she handled everything unprofessionally, close quote. Now, we also called Dr. Finke. He, too, was there the day of the incident, and he, too, has no axe to grind. He is not her regular doctor and never has been. He saw her that one occasion on February 24, 2018, when Cardi was here for work for the NBA All-Star Weekend and was concerned. She was pregnant, she wanted to see an obstetrician, and an appointment was made. He is a completely disinterested third-party witness with no axe to grind. Now, Dr. Finke, like Cardi and like Tiara Malcolm, testified that plaintiff, well, first of all, he testified his office was at the back of the suite. He heard yelling, and he immediately ran to the front. Okay, so he gets there very quickly, too. And he just has a little more distance to cover. And he testified, like Cardi and like Ms. Malcolm, that plaintiff had her cell phone in her hand. He saw plaintiff trying to hit Cardi. He saw poor Ms. Malcolm in the middle. And by the way, do you remember in the opening counsel for plaintiff said, well, Ms. Malcolm threw herself into the fight. If she gets hit, she gets hit. That's what happens when you try to help. I mean, really? I mean, she's a doctor's receptionist. She sees a patient coming there for a secret appointment, a pregnant patient. She tries to stop a security guard who's got the patient cornered in the hallway, and that's like, she asked for it? Is that really the answer? Dr. Finke also testified that Ms. Ellis had scratched Ms. Ellis, plaintiff had scratched Malcolm's head. If you remember, the evidence is that Tiara Malcolm did not realize she was scratched until someone else in the office, the doctor's office, pointed it out, and also that Dr. Finke, once he got plaintiff to leave, which she refused to do, that he went back into the office. So he had a chance to see her at that point. That supports his testimony that he saw the scratch on Malcolm, not on plaintiff. Dr. Finke also testified that he told plaintiff, do your job, you're a security guard. But plaintiff kept yelling and she refused to leave. Kept yelling.
So there was two people that said that they didn't see any mark on Ammani, right? There's two people. I don't know.
Yelling at them, kept yelling at Cardi. Now, while Dr. Finke tried to get plaintiff to leave, he was face to face with her. He testified they were within a foot of each other. And he testified he saw no cuts or scratches to plaintiff's face. He saw no blood on her face.
We're going to bring Sugar Plum up after we finish listening to closing arguments. I hope you're still here.
Despite the fact that he testified that a cut on one's face bleeds more than a cut on any part of the body. This woman claims that she was cut in that encounter, but no one has testified that she had blood in her face. In fact, she testified she doesn't know if she had blood on her face from a scratch that has supposedly ruined her life. He also testified that he saw no spit or spittle on her. He also heard, he was there.
Well, everybody's allowed to, like I said from the beginning, right? Even through the Diddy trial, everybody's allowed for their opinion. Everybody's allowed to have their opinion, but we're going to bring Sugar Plum up. Sugar Plum says she want to come up. Very vocal, so we're going to see what she got to say. But we're going to listen to this first, because this is what the people in here...
When plaintiff expressly threatened harm to Cardi by saying, I will F your S up. Now, Tinky testified that Cardi did not spit on plaintiff or anyone else, did not take a swing at plaintiff, did not hit plaintiff, did not cut or scratch plaintiff, did not threaten to get plaintiff fired, did not use the N-word, and did not call plaintiff fat or poor. Dr. Finke also testified that once Cardi was safe in his office, he examined her in an examining room, and she did not have 3-inch fingernails. Now, in an interesting turn, that was a surprise to me as well. He said he actually noticed it.
So 3-inch fingernails will be like this. The 3-inch fingernails is long. That's like the girl from SWV had.
This patient's fingernails, because it's a way of calming them down. It's a way of lightening the mood in the examination. So he's seen a lot of fingernails. And he looked at hers, and hers were not 3 inches. There were allegations, and you've heard little bits of it, that Cardi supposedly got plaintiff fired. Actually, Dr. Finke said it was him. He told his administrator, his practice administrator, that this was outrageous, and based on the conduct he saw, plaintiff had to go. Cardi did not make a complaint. Cardi is not the reason that plaintiff got fired. Plaintiff is the reason that plaintiff got fired. Our evidence also included plaintiff's February 24, 2018 incident report. Plaintiff was asked in discovery, and we read some of that to you, which are formal written requests for documents or information, sworn under oath by plaintiff in this case. We asked for documents relating to the incident, emails relating to the incident. She never produced her incident report. We had to subpoena it from Ally. That's how.
So she was supposed to, like, when you do a deposition or you have a lawyer, they ask you for certain things, right? So if I am so in the right, I'm going to be running to give you my incident report. I'm going to be running to give you my incident report. She refused to give them the incident report. They had to subpoena her incident report.
How we got it. We didn't get it from her. She claimed it didn't exist.
Oh!
Once again, common sense. There's something wrong there. We had to serve a subpoena on Allied, who produced a copy of the incident report, and we relied on that incident report because of plaintiff's inconsistencies and admissions. Now, it contains a lot of her accusations, and we believe the evidence is clear that they are false, but it also includes some interesting statements by plaintiff. And this is 2 days after the February 24, 2018 incident. Plaintiff, who testified, if you remember, that incident reports are very important. And she testified, in the incident report, she told her supervisor that plaintiff, that Cardi had scratched plaintiff's nose. Not cheek, nose. 2 days after the incident, when she's blaming all of this on Cardi, which I think it's safe to assume that she was improperly doing so, given all the evidence we've heard. Plaintiff told her supervisor 2 days later, Cardi's, with 3-inch nails, the evidence is against that as well, scratched plaintiff's nose. Nothing about a cheek. And again, a nose is not a cheek. They're different.
A nose is not a cheek.
This raises 2 points, really. Plaintiff's first statement that Cardi scratched her nose is directly contrary to plaintiff's sworn testimony here that Cardi scratched her cheek. Okay. So if we accept that, then the statement that she put in her report is clearly false. Because she's now saying, and she's been saying for a couple of years, no, it wasn't my nose, it was my cheek. Second, plaintiff admits that her nose was not scratched.
Oh boy. Okay, so Ammani's lawyer, okay, I'm just pointing out facts here, just pointing stuff out, all right? It's not about siding, I'm just talking facts. Ammani's lawyer put nothing up on the screen. He has no receipts. He has no pictures. He has no emails, no reports. Cardi B's lawyer is pulling up a report every 5 seconds. He got a report right now. And what he talking about, he got a report up. He got it in black and white. Let's listen to it.
This was outrageous, and based on the conduct he saw, plaintiff had to go. Cardi did not make a complaint. Cardi is not the reason that plaintiff got fired. Plaintiff is the reason that plaintiff got fired. Our evidence also included plaintiff's February 24, 2018 incident report. Plaintiff was asked in discovery, and we read some of that to you, which are formal written requests for documents or information, sworn under oath by plaintiff in this case. We asked for documents relating to the incident, emails relating to the incident. She never produced her incident report. We had to subpoena it from Ally. That's how we got it. We didn't get it from her. She claimed it didn't exist. Once again, common sense. There's something wrong there. We had to serve a subpoena on Ally, who produced a copy of the incident report, and we relied on that incident report because of plaintiff's inconsistencies and admissions. Now, it contains a lot of her accusations, and we believe the evidence is clear.
Easily provoked, as we could see today, with the pen and deny. As a matter of fact, they're talking about it is denied. Okay, it is denied. And you can see today that she got a little bit of spiciness to her, right? But the thing is, you got to prove stuff. You got to prove stuff. And yes, Cardi B does got a little spicy to her, but we talk about this case. Okay, they can't just be saying stuff. You got to prove stuff.
That they are false, but it also includes some interesting statements by plaintiff. This is 2 days after the February 24, 2018 incident. Plaintiff who testified, if you remember, that incident reports are very important. And she testified, and in the incident report, she told her supervisor that plaintiff, that Cardi had scratched plaintiff's nose. Not cheek, nose. 2 days after the incident, when she's blaming all of this on Cardi, which I think it's safe to assume that she was improperly doing so, given all the evidence we've heard. Plaintiff told her supervisor 2 days later, Cardi's, with 3-inch nails, the evidence is against that as well, scratched plaintiff's nose. Nothing about a cheek. And again, a nose is not a cheek. They're different. This raises 2 points, really. Plaintiff's first statement that Cardi scratched her nose is directly contrary to plaintiff's sworn testimony here that Cardi scratched her cheek. Okay. So if we accept that, then the statement that she put in her report is clearly false. Because she's now saying, and she's been saying for a couple of years, no, it wasn't my nose, it was my cheek.
So everybody that's just coming in, we're going over Cardi's case. This is the live courtroom closing arguments. Cardi got into an altercation with the security guard, right? Blessings to you. Thank you. Keep it to just me. Hey, thank you. Beauty is here. Hey, Beauty. Yeah, we met Beauty when we went to Coney Island, remember? Yes. So we're listening to closing arguments with Cardi B's case. Cardi B is being allegedly sued for $24 million for getting into an altercation with the security guard. She's a girl, right? The girl claims that Cardi B scratched her with her nail and she had to get plastic surgery for it. And she showed pictures of the nail. We all struggled to find the scratch, right? I mean, I struggled to find a scratch, you know. And she wants $24 million for it. So this is a closing arguments for it. That's it in a nutshell. We'll be going through it extensively. We might not get it to it today, but tomorrow, because they're not going to deliberate today, y'all. Tomorrow's going to be deliberation. So while they're deliberating it, we're going to be going through the trial again. We're going to be playing all the testimonies. We're going to be looking at all the players. We're going to look at Cardi B's testimony first, and then we're going to look at Ammani's testimony, right? And then we'll look at all the others, right? And then we're going to wait for them to deliberate, and then we'll continue on. So now, Cardi B's lawyers is delivering his closing arguments, and then the plaintiff's lawyers, who's the girl suing Cardi B, Ammani, will come back and give any rebuttals, right? And then they'll go on to like end the day or say other stuff that matters or whatever, all right? So now we'll listen to Cardi B's lawyers talk.
Second, plaintiff admits that her nose
He got a PowerPoint presentation, darling.
was not scratched. So this is a very important document because it confirms that she made false statements about the incident. At a minimum, she made the false statement that Cardi had scratched her nose. This statement, this incident report that she said is very important, also apologized to Ally and the building owner, quote, for behaving the way I did.
So that incident report that they have in black and white is very important and is credible because it's from the company, right? She apologized for what she did. Now, if you are suing somebody and you're not at fault, you ain't supposed to apologize for nothing. Am I right or wrong? Am I right or wrong? Yeah, look, Breed. You know what I'm saying? How you pronounce your name? Arabi. Breed. I'm going to call you Breed. When you apologize for something, you are in admittance that you did something wrong. She early on, this is my theory, allegedly. Early on, her wheels wasn't turning yet. So she filled out the incident report. If her wheels was turning from the jump, she would have had her story together from the incident report. But it seems like she don't got her story together from the incident report. It seems like she put the incident report in and then her wheels started turning and she probably forgot about the incident report. Because the incident report is coming back to haunt her. Let's listen.
Okay. Why would she apologize to them if she was attacked? Why is it something that she would apologize for? Again, common sense. She was apologizing because of the way she was behaving. She's apologizing to them for her professional misconduct. She's apologizing to them for attacking a medical patient who's trying to go in for a medical exam.
Wrap up about 10 minutes.
Can I have a little bit of extra time since counsel got extra time?
I don't know that you did, but please try to wrap it up.
Okay. I'm going to do this a little bit faster, and I apologize. We also called Nicole McKenzie.
He didn't seem like he was up there as long as the other guy, right? The other guy was up there mad long. Do they give the plaintiff more time? Does the plaintiff have more time? Because he seems like he was up there for a long time. Cardi was nodding. We was nodding.
McKenzie is an interesting person because she's a psychologist, a workers' comp psychologist, and plaintiff called her too. It's baffling why he did, because all of her testimony only helped Cardi. First of all, no one called Dr. McKenzie as a psych witness. There were no...
Now look at this comparison. Look what this lawyer did. Wait, hold on. I'm going to show him a turn.
Close quote, touched her. Almost is not touching. Plaintiff has offered no explanation as to why she told Dr. McKenzie Cardi almost touched her. Ms. McKenzie also testified that in doing her evaluation, she would note any physical symptoms. And she confirmed that plaintiff identified no physical symptoms 2 months after she supposedly got cut in this incident. in response to one or more of the jurors' questions, the judge elicited the response from Dr. McKenzie that it was her standard practice that even if someone came to her just for a psychological examination, that she would also note any physical symptoms that would be reported, and also that if she saw the patient and saw, if they've got a cut or a scrape or a bruise or whatever, she'd note that as well in the report. And none of that was noted because none of it existed. We also asked Plaintiff about her Kaiser medical records. At this point, I'll just mention that she testified and admitted that out of 161 pages of medical records over 2 years, there was no mention of any cuts, scratches, anxiety, PTSD, or anything else. Counsel noted that we called Dr. Rosenberg, who is a lifetime board-certified medical doctor who specializes in psychiatry. He has impeccable credentials and decades of experience.
So her Kaiser medical records, which was probably early on, didn't mention any cuts. See, it seems like her wheels didn't start turning on this to do this like little thing that she, the lawsuit, until later on. So she wasn't able to cover her tracks good. If she would have thought, if the bell would have went off when she wrote that incident report, right? She ain't getting not a thing. If her bell would have went off like, oh, I'm suing her, when she wrote that incident report, she would have had her story straight. Oh, she scratched me like a werewolf on my cheek. She would have went straight to the punch and stuck to it. But she don't remember what she got on the, do you get a copy of the, don't you get a copy of the incident report? She probably took that incident report and threw it in the garbage. Because you get not only do you put in the incident report, you get a copy of it. You get a copy of it and you're writing it. So if I'm writing an incident report, I'm going to make a copy of it too. Anybody that's thinking with common sense, if a company asks me to write an incident report, I'm going to have my own copy of that incident report. Not only you giving me the copy, I'm going to make sure I got a copy. Because look at what had happened. Okay, let's listen.
He, by the way, does not work on a lien basis. He does not work, we paid him. He does not work on a lien basis, so he doesn't have the same incentive.
Oh, she was asked to come in and fill it out? Okay, but then when you fill it out, they rip off that little, they make you a copy of it. Any job, I worked in human resources in the Gap and Old Navy. This is protocol. Anytime somebody writes a statement, you get a copy of it automatically. If you get a write-up, they write that write-up, and you get a copy of it also. For your records, you have a copy of that. So what happened to her copy? She probably took that thing and threw it in the garbage. Because her wheels wasn't turning yet.
That Dr. Mulligan has to spin his story. Dr. Rosenberg wasn't asked to diagnose any psychiatric conditions that plaintiff has. So in his report, he specifically said no diagnosis. But he did come to conclusions, okay, which is different than a diagnosis. And what he did was he had a 6-hour recorded interview of her, and he had her take a gold standard test of 335 questions. And what he learned from the test was that she claimed symptoms, different symptoms, and so many symptoms that only 2 out of 1 billion people in the world have those symptoms. He also testified that there were inconsistencies.
So that's the doctor that worked for Law and Order, that got all these Harvard degrees, that got all these credentials. You know what I'm saying? So I guess Cardi B paid him off too at $500 an hour. So he said that only two people out of 2 billion got all the symptoms that she claimed. She probably said, I'm delusional, I see this, I see that, I'm this, I'm that, I'm this, I'm that. And he's sitting there like, okay, So, wow.
With her story, we talked about the McKenzie analysis, and the fact that the plaintiff didn't mention any problems or physical injuries to Dr. McKenzie. We've talked about the initial incident report, which says a scratch on the nose, not a scratch on the... So with all these different inconsistencies, that went into his analysis as well. Now, he also considered that in the Kaiser medical records, there's no indication of any of those injuries. And counsel, for some reason, focuses on vaginal discharge to say, well, if you're going for that, you're not going to mention a cut or scrape. But that's not what Dr. Rosenberg testified to. He testified that in April 2022, plaintiff...
One doggone minute. Let me run that back. Who did he say had what vaginal discharge? Wait a minute. Wait, what did he say?
After she supposedly got cut by in this incident. And in response to one or more of the jurors' questions, the judge elicited the response from Dr. McKenzie that it was her standard practice that even if someone came to her just for a psychological examination, that she would also note any physical symptoms that would be reported, and also that if she saw the patient and saw, if they've got a cut or a scrape or a bruise or whatever, she'd note that as well in her report. And none of that was noted because none of it existed. We also asked plaintiff about her Kaiser medical records. At this point, I'll just mention that she testified and admitted that out of 161 pages of medical records over 2 years, there was no mention of any cuts, scratches, anxiety, PTSD, or anything else. Counsel noted that we called Dr. Rosenberg, who is a lifetime board-certified medical doctor who specializes...
Oh, you mean the doctor that was testifying? We didn't play her yet. We're going to get to her, the African-American lady. There's another doctor that testified. She was African-American. But the plaintiff's name is Ammani.
Psychiatry. He has impeccable credentials and decades of experience. He, by the way, does not work on a lien basis. He does not work, we paid him, he does not work on a lien basis, so he doesn't have the same incentive that Dr. Mulligan has to spin his story. Dr. Rosenberg wasn't asked to diagnose any psychiatric conditions that plaintiff has. So in this report, he specifically said no diagnosis. But he did come to conclusions, which is different than a diagnosis. And what he did was he had a 6-hour recorded interview of her, and he had her take a gold standard test of 335 questions. And what he learned from the test was that she claimed symptoms. What difference in so many symptoms that only 2 out of 1 billion people in the world have those symptoms. He also testified that there were inconsistencies with her story. We talked about the McKenzie analysis, in fact, that the plaintiff didn't mention any problems or physical injuries to Dr. McKenzie. We've talked about the initial incident report, which says a scratch on the nose, not a scratch on the... So with all these different inconsistencies, that went into his analysis as well. Now, he also considered that in the Kaiser medical records, there's no indication of any of those injuries. And counsel, for some reason, focuses on vaginal discharge to say, well, if you're going for that, you're not going to mention a cut or scrape. But that's not what Dr. Rosenberg testified to. He testified that in April 2022, plaintiff went into Kaiser for a complete history and physical, and plaintiff specifically in questioning denied any kind of mental health issues, including anxiety or sleep problems. In April 2023, she went in again, and for hand pain that time, and she was specifically asked, Dr. Rosenberg said that's what Kaiser does. They ask you about everything, just noted in the record. And she was asked, but again, reported no emotional problems and did not request mental health assistance. I should also mention this claim about PTSD. Dr. Rosenberg testified that you can't, quote unquote, an argument or an unpleasant interpersonal interaction isn't a trauma and can't lead to PTSD. The claim of PTSD is frankly an offense to...
Hold up, Deloitte, see, we ain't up to that yet. So, yeah, but they still can't... I knew that he was going to mention it because he been trifling all day. saying that she's cussed. You told her to say the cuss words. You approved it. And then you used it against him. A lot of the stuff, he lost credibility to me with a lot of stuff he was doing through the trial. So I already knew he was going to mention it. But newsflash, they can't use that against her in court. They can't use that against her. Because that's not towards her. That's with her and outside with Deny or whoever. Listen.
Those people who actually have it. She had a 45-second argument. She was fired. That is not what.
Come on, we're almost at 500K.
Stress syndrome, and we know that because we've heard it from a licensed psychiatrist who did all those tests and interviewed her for 6 hours. I should mention that Dr. Mulliken is a plastic surgeon. He's not a psychiatrist. So Dr. Mulliken couldn't and didn't rebut Dr. Rosenberg's conclusion that plaintiff is feigning. Counsel said, well, why didn't the defendants call a plastic surgeon expert? Because we don't see a scar. To call someone to say, can you examine this person? Do they have a scar? You can look at the photograph. Why would we call a plastic surgeon? Conversely, though, they want to prove that
Diddy's status says he's still in jail and his sentencing ain't till October 3rd.
Plaintiff had psychological injuries. Why didn't they call a psychiatrist? Let's talk a little bit about plaintiff's shifting stories.
I bet they will settle for thousands, Gigi, because they know that they was losing.
First of all, plaintiff alleges that Cardi spit on her. It's a disgusting allegation, of course, and I hate to even mention it.
Am I on mute, y'all? Am I on mute? He can't do anything about what happened outside. No, he can't. Am I on mute, y'all? Somebody said I'm on mute. Am I on mute? Can y'all hear me good? Okay, why you say I'm on mute?
And
if you can't hear me, tell him to go out and come back in. Tell him to go out and come back in. Thank you so much.
Everyone else says it didn't happen. But for her part, plaintiff also hasn't gotten her story straight. If you remember, last Monday she testified.
If they y'all tell them in the comments to go out and come back in, because if they can't hear, then they ain't gonna be able to hear me. All right, go out and come back in. Tell them.
In her February 26, 2018 incident report, plaintiff told her supervisor that Cardi spit on her before people came out of the doctor's office. But at her deposition, plaintiff testified that Cardi spit on her after they came out. She can't get her story straight. That's that simple. Counsel has referred to spittle. And so what he's basically backed off of is initially it was terrible spitting at her client. Now it's, well, maybe it was an accidental spittle.
He can make it as big as a mountain. That pen thing outside. They cannot use it in court for this case. They can't use that. Now, if the jurors know and are aware that Cardi B went outside and threw a tantrum, right? Then because they're human, it might settle in their brain a little bit. But they can't use that in this case against her. But as humans, yes, it could be in the back of their mind. Okay?
Say it, don't spray it kind of thing from junior high school. There's no evidence that happened, but it's also not an assault. It's also, when you look at the jury instructions, you'll see that an assault requires intentional conduct, intentional battery. Accidentally, spraying a little bit of spittle when you're arguing, that is not an assault, and there's no evidence that it even happened. Plaintiff also is strikingly inconsistent regarding her claim that Cardi touched her. We'll go through this quickly. We talked about in the February 26, 2018 incident report, supposedly Cardi scratched plaintiff's nose. In April of 2018, plaintiff told Dr. McKenzie that Cardi almost touched her. In sworn responses in discovery in this case, plaintiff stated under...
Now, that's going to mess her up because they got that in black and white that she said at one point that Cardi almost touched her. And they have that in black and white, right? If somebody touches and scratches me, it's going to be always that they touch and scratch me. It ain't, if I got cut anywhere on me, it's going to be from day one this person did this. It's not going to be she almost scratched me and then, oh yeah, she scratched me. Oh, but she scratched me on my nose in the incident report. Oh no, but she scratched me like a werewolf on my teeth. It's going to be one thing. You know when you hit. You know when you
So that Cardi viciously beat plaintiff about the head, face, and body. We haven't heard that, in this trial. No one said that occurred. In her deposition, plaintiff stated under oath that Cardi struck her on her nose and cheek, and plaintiff acted out Cardi jabbing plaintiff's face with an outstretched index finger, which is directly contrary to, and you saw that videotape of that, it's directly contrary to what Dr. Mulligan testified he thought happened.
He got PowerPoint presentation. That girl lawyer ain't effing with him. He got a PowerPoint presentation. That dude, the other lawyer, don't got nothing. Why? Because he ain't got no evidence. Thank you, Gemini. They ain't got no paperwork, no phones, no messages, no evidence, no paperwork. They tried to hide the incident report. They tried to hide that. So that side, they don't got no evidence to show, no PowerPoint. This guy is all PowerPoint presentation with receipts.
Objection, Your Honor.
Thank you, darling.
What's your objection?
That we agreed to 1 hour.
Okay, counsel, what's your record?
Can I have 3 minutes? Okay. I'm sorry, there's more to talk about, but I've got to go. Ultimately, this case comes down.
So he even got more to talk about, but he got to go because they're cutting him short.
To what happened in a minute in a medical building hallway. And to believe plaintiff, you would have to disbelieve Cardi, you would have to disbelieve Ms. Malcolm, you would have to disbelieve Dr. Finke, and you would have to ignore all of plaintiff's contradictory statements, including whether she had a cell phone, whether she had an earpiece, all that stuff. This is not a difficult case. It is not a closed case. Plaintiff has the burden of proof, and the evidence is overwhelming in Cardi's favor. Plaintiff has not met her burden of proof. And plaintiff's demand for whether it's the $24 million that was testified to at trial or the $250,000 plus that you heard today makes no sense. She suffered no injury. Cardi did not do anything wrong except try to protect her baby.
Oh, so did they discuss going back down to $250,000? Did they discuss going with it? We going to catch it?
And get to a doctor. The court will provide you with a verdict form, and we urge you that the evidence and common sense require that you answer questions 1 to 2 is no. That will skip you over to Section B. We ask that you answer question 5 no. That will skip you over to Section C. We ask that you answer question 8 no, which will skip you to Section D. We ask that you answer question 12 no, which is then the end of the verdict, and you can have the foreperson sign it. I also want to note that for each of these questions, as the judge previously told you, 9 people do not have to agree. You can have 9 people agree on one, a different group of 9 people on another. And we ultimately, we thank you for your time, for your consideration, and you know how we wish you roll. So, thank you.
All right, and folks, as we indicated, the plaintiff gets the first and last word, so time for a rebuttal case for plaintiff.
Yes, thank you. Good afternoon. Thank you all for coming back. So this is the end of the road now. I said a lot of things this morning, and I basically don't want to repeat all of it. The main point that I want to highlight, which what counsel has brought up, is the incident report. In the incident report, Ms. Ammani Ellis tells her supervisor that the defendant put her fingernail into her face. You will see that. Into her face and scratched her nose. She caused damage to her face. It was a physical contact. As far as the spitting...
so even he said onto her nose, but the doctor said it was on her cheek. The mother said, what didn't the mother and the grandmother say it's on the cheek? So I think he made a mistake there. He made a mistake. He was supposed to say cheek. He got confused his own doggone self. He was supposed to say cheek, and he said nose.
I never brought up the word spittle. I don't know what that exactly means, but in either event,
He messed up.
Ammani Ellis, who was there, who was a witness to this incident, testified that the defendant spit on her, actually spit on her, which is an assault and a battery.
How come you
Everybody gets an attorney. Everyone gets to have an attorney. Even Cardi B gets to have an attorney. All of these comments and all of these things are smoke and mirrors to hide up the truth. Bottom line is, Miss Ammani Ellis, who was there, testified multiple times. She never did anything wrong in her life. She was a model citizen, good person, and
So she never. Now, what human do you know that never did anything wrong in their life? Does anybody know another person who never did anything wrong in their life? Let me.
And she basically was doing her job as a security guard, and the defendant refused to cooperate, caused a disturbance, physically assaulted and battered her, spit on her, took a swing at her, and ultimately a couple of witnesses came after the fact, and they were not witnesses to the entire incident. The entire incident really took place between Ammani Ellis and Cardi B, and it really is going to come down to who do you believe? Who do you believe? Are you going to believe Ammani Ellis, who was a security guard, who did her job, who was there, who never had any problems of any kind? Or are you going to listen to somebody who's yelling and screaming, has anger management problems?
Objection, Your Honor.
Got angry on that day. There's no question. She admitted it. She said she was angry. She got angry. She attacked the plaintiff. She spit on her. She used the N-word, disrespectful. She took a swing at her. She did everything possible to cause her so much emotional anguish and try to get a reaction out of her. I don't know how it was that Ammani Ellis was able to contain herself, maybe because she is so peaceful. You heard lots and lots of testimony about how she was peaceful. The issue with Dr. Mulliken, at some point I did ask Dr. Mulliken, could this cut have been done by someone who's left-handed or right-handed? At the end, he was very clear. You can ask the testimony to be read back to you. He said it could be done by either a right-handed person or a left-handed person, either one. And when we had Cardi B on the stand, she said she was disabled because she was pregnant, but at the end of the day, she wasn't disabled with her hands, and you can cut someone with either hand, both hands. Go to the bench press, both hands. Anything can happen with both hands. This is not somebody who was taking a swing with a bat, in baseball, you must use the correct, no. This injury could happen with the right hand or left hand, and Dr. Melka clarified that and said it could happen with either hand. Again, the evidence that needs to be brought forth needs to be proven by a preponderance of the evidence. We don't have to prove 100%. We have to prove a featherweight more than 50%. In this case, we have given you so much different evidence from different people, which was Ammani Ellis, her grandmother, her mother, and...
Wait, what evidence? You mean witness? They didn't produce no evidence, did y'all? Yo, do y'all hear this? He said we received so much evidence. That's because the other lawyer had a PowerPoint presentation, and it had them having 5-6 receipts, and they only had 2. So what is he talking about?
All of the medical records, we have a plastic surgeon who came here and explained everything. You now have the case before you where you can now determine what you feel Ammani Ellis should receive to make her whole. And counsel brought up some points to try to maybe muddy the waters in a sense and try to change what really happened here. At the end of the day, we have overwhelming evidence that Ammani Ellis was assaulted and battered, and we thank you for your service.
All right, thank you, counsel. All right, ladies and gentlemen, that concludes the presentation of evidence and argument. You're now going to be shown to the jury room. We do have a hard stop at 4:30, And by no means would I suggest that you should try and rush to be done by then. You do need to deliberate and consider all of the evidence before answering the questions on the jury form. And so if indeed it takes you longer than 4:30 today, then we will need to come back tomorrow. If you want to take a break, you can take a break, but you all need to be back together in the jury room. So please do not deliberate until all of you are back together. To the extent that we do come back tomorrow, if you want to bring snacks or anything like that, that's fine. We can discuss that a little bit later. But for now, can I have Cynthia swear in Vanessa, please?
You worry about snacks.
Yes.
Please raise your right hand. Do you solemnly swear that you will take charge of the jury and keep them together, that you will not communicate with them yourself, nor allow anyone else to communicate with them upon matters connected with the case, except on order of the court, and when they have agreed upon a verdict, you will return.
Let me show you who's going to be one of the decider, and she's the head. She's being appointed as the head, right? So let me show you how, y'all. Let me show you real quick. So this is how, y'all. Hold on. Let me take this. Well, hold on, y'all. Let me take the background off. Let me show you who's deliberating. This is her. That's her, y'all. So this is the one who's going to be the head juror. This is the one that's going to come back and read the verdict. Okay? That is the one. So we're going to see. Woo, boy. Okay, so let's listen.
Turn them into the court, so help you God.
I do.
And do you solemnly swear that you will take charge of the alternate juror and keep her apart from the jury while they deliberate on the cause until otherwise instructed by the court, so help you God?
I do.
May I please have you state your first and last name for the record?
Vanessa Garcia.
Okay, thank you.
Vanessa?
Yes, sir.
I want to talk to the alternate before she does.
Pens, notebooks, and personal items, and we're going to go ahead and hand
No personal items.
Juror number 7, you
see that? So they said no books, no personal items. You can only go in there with yourself, right? So that means that they ain't going to be able to look and study what she did outside.
alternate, if you could just stay in your seat.
All right. So that's the end of the closing arguments, right? Thank you, Gemini. Everybody tap a 5. Let's get to 500K. Let's get to 500K. So now we want to know where Sugar is. Where's Sugar Plum at? Sugar Plum, I want you to come on up and tell us what you was talking about.
The door's closed? There it is. Okay. All right, we're still on the record outside the presence of the jury. We do have the alternate number 1 here. Ma'am, on Wednesday, did you have any conversations with any of the witnesses?
Oh, so they got an alternate. Oh, let's listen, y'all. So they got an alternate. So they asking somebody, did they have a conversation with one of the witnesses?
Were you sitting? Yeah, you.
Me?
Yes. Were you outside? Did you sit next to the plaintiff's grandmother on Wednesday?
The grandmother?
Correct.
I can't remember, but I did sit once, at least once.
Did you have a conversation with her?
I don't remember what I said, if I did.
Okay, so she didn't say anything.
I didn't say anything about this.
Nothing about the trial?
No.
Okay, very good.
Not at all.
Vanessa's going to excuse you to the jury room. All right. Thank you, ma'am.
Why are you even talking to her?
I'll take care of it. Thank you.
Why is she even talking to you? You're not supposed to even sit there, nothing. So where's Sugar Plum at? Sugar Plum was talking all through the broadcast in the comments. Come on up, Sugar Plum.
Let's just for the party's information, they were seen. They had some kind of conversation. May have been innocent.
So Sugar Plum was in the comments saying that people get paid off, and she wanted to come up. So I just want to know where she's at. Where's Sugar Plum at?
I just wanted to rule out an improper contact. If you could please either stay close or give a cell phone number to Cynthia. You just please stay
Your time to shine.
within a couple minutes in case we get any
Where
questions
you at,
from the
Sugar
jury
Plum?
or if we get a verdict.
Come on down.
Yes.
So I do want to
You
put
the
something
next
on the
contestant
record.
or
Not
Miss
about counsel.
Knockout is live.
Okay.
I think it's important. I think this court has a duty to handle the situation, which is what happened. During the lunch hour, Cardi B went outside and threw something at one of the news reporters. I have it on video. She's been staring at my clients, all three of them, trying to intimidate them. I think it's unfair, and it's they feel scared. They feel scared about what she may do to them because of what she did to that court reporter, which I have on video.
To the court reporter?
Sorry, to one of the news reporters. She threw an item at the news reporter.
She didn't throw it at him. It hit the mics.
Physically, in front of this courthouse, on court property, outside this courtroom. So I would ask that she be admonished and be told not to handle herself in this way and not to look at my clients anymore.
All right, so the court can't make any orders for conduct that the court didn't witness.
I can show the court the video.
Well, I still haven't witnessed it.
Yeah.
To the extent.
So if we could show the video, that means we all witness it. Joe, he didn't witness it. Okay. I told you that they was gonna. I knew that they was gonna bring it up. I knew that they wasn't gonna be bringing it against him. But at the same time, Cardi B, you shouldn't have did that though. Cardi B, you shouldn't have did that. You knew that they was gonna look at that.
I think it appropriate that the parties be courteous to each other. I don't think it's appropriate for anyone to.
Cardi B wasn't looking at her.
Either threatening.
I'm watching Cardi B the whole time. Cardi B wasn't looking at that girl. She wasn't looking at that girl.
Even by way of staring at someone, people can take offense to that. So please continue that courteously with each other.
May I just add one thing?
Sure.
I've been sitting here throughout the whole trial. Plaintiff has never looked this way, so I don't know what she's talking about.
Okay.
Second, plaintiff is halfway between Cardi and the jury box and the witness. I have never seen Cardi do anything else other than watch.
Lying.
Sometimes
And he's right. The whole trial, she ain't looking that way. She looking this way at the court or at a lawyer. That dude is lying.
The witness may not
He lost a lot of points.
But I have not seen anything that plaintiff's counsel has claimed.
Okay. All right. And we do have extra security here just in case there's any kind of issue. All right. All right. Stay close.
Yes, sir. Thank you.
Okay, so they went to the jurors going to deliberate. Okay, so Sugar Plum is nowhere to be found. Sugar Plum is nowhere to be found. Oh man, where you at, Sugar Plum? Let's give Sugar Plum one more time to shine. Sugar Plum, come out to play. Sugar Plum was saying a lot of stuff in here. She was saying that, I think it's a girl, that Cardi B paid off the witnesses and pretty much pro Ammani. Pretty much pro Ammani. She said to let her, there goes Sugar Plum. Is that Sugar Plum? Oh no, that's Super Apple. Okay, Sugar Plum. So Sugar Plum was having a lot to say all through the broadcast. So Sugar Plum said to bring me up. So now I didn't want to interrupt the broadcast because everybody's in here listening to the broadcast, right? C Plum, not Super Apple. Not Super Apple? No, I'm almost sure. Who was the person who said Cardi B paid off the I thought I showed it. Come on now. I thought the name was Sugar. Let's go back in the files. Okay, see now what does that have to do? Okay, I see C Plum. C Plum, was it you? Maybe I got the name wrong. I know I screenshotted it. Hold on, let me see something, y'all. I screenshotted it. Yeah, her name is Sugar Plums. Sugar Plums, spelled with 2 G's and 2 M's. Where's Sugar Plum at? Okay, so Sugar Plum, the verdict is in? The verdict is in that court. They didn't come back with the verdict yet. Is the verdict in? Mistaken identity. Yeah. No, it's sugar plum. It's not C. It's not C plum. It's sugar plum. Okay, it's sugar plum. I went back. I screenshotted it. So Sugar Plum had a lot to say, and then she said she wanted to come up. You know what I'm saying? So, you know. So how the verdict, if I go on Court TV, I am on Court TV. Court TV is still on the screen. Where do you see the verdict is in? Where do y'all see the verdict is in? Where's the verdict at? Where's the verdict at, y'all? Where's the verdict at? Where's it at? I'm watching it on TV. It says in the bottom, yes, it's on Court TV. What was the verdict? What was the verdict then? They didn't deliver it yet. Sugar apple bottom. Okay. You want to come up? Come on up. So if the verdict is in, they didn't deliver it yet because they still got the screen up. That means they didn't come back yet. So if the verdict is in, what is the verdict then? How you doing? Hello? You gotta turn your TV down. Oh.
That makes more sense. Yeah, I would have to agree with you. The other thing that's been pointed out by Cardi's attorneys is that it took her 2 years to bring the charges to bring the case.
Okay, so that's not the jury. That's not the jury giving the verdict. That's them discussing the case.
It's over. They about to come right now.
Oh, okay. Okay, because when they said the verdict's in, I figured they announced it, but I'm looking right at it. So the verdict might be in, but they didn't deliver it yet. Now
they deliberated already. They waiting on the jury to come read the guilty or not guilty.
That was quick. What do you think? It was so quick.
They said 50-some minutes. That's all it took.
50 seconds. It must be seconds because
50-something minutes. It was 1 minute. It took.
But listen, they came back on break. They just finished the closing arguments. So how did 50-something minutes go by that quick? Thank you, Kim. How did 50 minutes go quick? I just ended. They just went to the deliberation. So how was it 50 minutes?
Didn't bring criminal charges or attempt to bring criminal charges, I think is a misnomer.
How much is it? How is it 50 minutes?
The authority to bring charges, and if they deem that
okay, she can't hear me.
To meet the burden of beyond a reasonable doubt, they can make that executive decision to not take.
Hello.
So we don't know what counsel she received, and it is possible that counsel.
Sugar apple.
Going to law enforcement because it was unlikely.
Hey, Sugar apple.
Given the facts.
Okay, I don't know if she knows she's still up here. I don't know if she knows she's still up here. Okay, so we're waiting for them to come back. All right. So do you think it's a good thing or a bad thing that they deliberated so quick? Is it a good? Okay, so we're waiting on it. We're waiting on it, Coco. We're waiting on it. Let's go. Let's Google it. My browser's acting up, yo. Let's Google it. Somebody Google it. Somebody Google it. I did nothing yet. You did nothing yet? What do you mean? What do you mean? What do you mean you did nothing yet? All right, so we waiting on the verdict. Okay, let's somebody Google it. Somebody Google it. Because I don't think it's in yet. Okay, everybody Tapify. Let's get to 500K. 500K before we leave, y'all. Let's get to 500K. Let's get to 500K. All right, and everybody blessify is on TV. Yeah, but she just sold the TV. They're not saying guilty or not guilty. They're not saying guilty or not guilty on that TV. So if it's on TV, what's the verdict then? What's the verdict that they said then? Okay, she meant she Googled it and nothing yet. She didn't type a complete. Okay. Oh, okay. See, yeah, that's what I'm saying. It's nothing yet. They're just discussing it. Everybody's giving their commentary. All right. But the fact that they gave it that quick, right? Not guilty. Where you see not guilty, it's not a guilty or not guilty thing. It just said the verdict reached, and it only took 56. It can't be 55 minutes. It can't be 55 minutes because the jury, the judge just let them out to go in the room. The judge just let them out to go in the room. So how could it be 50 minutes, y'all? Tell me. How could it be 50 minutes when we just witnessed? We was there when it came 55 minutes. So how could it be 55 minutes, Jessica, when we just listened to the end of the broadcast? They had to be done by 4:30. Okay, that's on Cali time. 4:30, 5:30. If they wasn't done they're done for the day by 4:30. If they don't reach a verdict, they come back the next day. That's how it works. They don't force them to give an answer by 4:30. So what's the verdict then? They didn't give the verdict yet. So we just ended the broadcast. They told the jury, they swore the girl in. They swore the girl in. They just sent her in the room, and you're telling me it has been 55 minutes since they sent the girl in the room. Come on, y'all. Come on. Come on. What are we in, the Twilight Zone? Are we in the Twilight Zone? All right, y'all. So we're waiting for the verdict to come back. All right. We don't even know if they're going to have a verdict today. They might not have a verdict today. Then they got to come back tomorrow. You know what I'm saying? They call, yeah, Cardi was dozing off. Cardi was dozing off. All right, so we're waiting for them for the verdict, y'all. We're waiting for the verdict. So it looks like the court TV hasn't come back yet. So we wait. I'm watching it right now. Court TV hasn't come back. So if they do got a verdict, they didn't announce it yet. Okay, 4:30. 6:30, 5:30, 4:30, 3:30. Okay, so they got an hour. So they got an hour to deliberate. They got till 4:30. If they don't reach a decision, then they got to come back. No time. Oh, timetable on delivery. Okay. So, but if they don't reach it, look at what happened with the Diddy case. It took them a couple of days to reach it, right? Now, do you see the verdict on the bottom right of the screen? Let's see. Cardi B trial. Okay, rap superstar Cardi B. No, verdict. Let's see. Okay, so they're waiting on the verdict. It looks like they're waiting for them. They got to come and announce it. So, but they got to come in and so they said verdict. The verdict on the bottom of the screen means that they went to deliberate the verdict. It doesn't mean that they announced the verdict yet. They haven't announced anything yet. Thank you, C. Plum. Thank you. C. Plum said it's an identity mishap. Thank you, Michelle. Everybody, Tapify. Let's get to a 500K before I get off, y'all. Let's get to 500K before I get off. 10 minutes. Okay? So the court in Cali closes at 4:30. They got till 4:30 for today. Not to decide the case. They could take their time. If it takes them 3 days to decide, it'll take them 3 days. But the judge said that they only have to, the court stays open till 4:30 today. That's what the judge was saying. Okay? So it says verdict in the bottom of the screen because they went to deliver the verdict. So the channel is telling you that they're on the verdict now. So if the peoples and them, meaning the jury, is not finished delivering the verdict, right? Then they're going to come back. It's only 3:30 here in Cali. That's right. So they got another hour. Because the judge said that they're open to 4:30. they got another hour. Okay? So we'll see if they, they come back today in an hour. In the meantime, let's do this. So we didn't hear this lady's testimony, right? Let's listen to this lady's testimony. Let's see if I can find it again. Let's see. So there's another doctor that did a testimony. We're going to listen to her. Okay. Let's see. So there's another doctor that did a testimony, and we're going to listen to her while we're waiting for them to deliver the verdict, okay? If anybody sees that they came back, let me know so we could pop on in there. So let's find this lady's testimony. She'll tell you what kind of doctor she is. I think it's another psychologist. I'm not sure. So let's see. So Cardi B testified. Cardi B looked like she's kind of having a struggle walking. Okay, let's see. So let's see. I'm trying to find his testimony. Okay, ex-OBYN security. So she was a security guard at the actual OBYN. She wasn't just like for the building. You know what I'm saying? She was like a security for the OBYN. So that's why people are coming in here saying that she's responsible for HIPAA. The HIPAA, she signed something too as a security guard. Okay, I'm trying to find this one testimony. Okay, so, here it is. Okay, so she's a psychologist.
Here today. Are you under subpoena to be here today?
Yes.
Okay, so she's under subpoena to be here today. So let me show you a psychologist. Okay, if the window opens on Court TV, okay, we're going to be watching it. So if the window opens up on Court TV, I don't think it opened up yet, right? But if they come back on Court TV, yeah, I'm watching it. They ain't come back yet. All right, so we waiting for the jury to deliberate. We're going to see if they finish today or not. They might not even finish today, and they got to come back tomorrow. All right? So, they ain't back yet. I just checked. So let's go to the psychologist, and let's look at what she looked like. Okay, so here goes the psychologist, y'all. Here she goes. That's the psychologist. 10-minute delay in bringing back jurors. Okay, cool. All right. So I don't think that they're finished yet, though. All right, so let's listen to the psychologist while we wait. But I'm going to be watching to see if she's coming back. But while we wait, we didn't hear this testimony yet, okay? And tomorrow we'll be going over everybody's testimony. We'll start with Cardi B, and then we'll do Ammani, and we'll work our way down. All right? So let's listen.
And you were served a subpoena from both sides?
Yes.
Do you remember...
We'll do the whole trial on audio.
The person on my right, Ammani Ellis, in your office, medical office?
Yes.
Do you remember why she came in?
Okay.
For a workers' comp injury.
I got you.
And if you just tell us a little bit about your education and background.
So she came to her for her evaluation for workers' comp. So that's what she did.
What exactly is it you would like to know?
Yes. You're a psychologist, correct?
Yes.
You deal with emotional injuries?
Yes.
What else do you deal with as a psychologist?
Primarily emotional injuries.
Okay.
Do you ever deal with physical injuries?
Thank you.
No.
If a patient were to tell you about their physical injuries, is that something that you would want to know for the reason of coming up with a diagnosis? or is that just something general that you may or may not want to know?
Objection. Compound.
You free to answer?
No. So when the judge will say sustained, then you will not answer.
Okay.
Sorry. All right. Approximately how long after? Do you remember the date of when you saw Miss Ellis?
Not the exact date. I believe it was 2018, just because of the year listed either on the subpoena. But it's been a while.
Okay, there's a notebook in front of you, the one on your right.
Yeah, but they didn't read it yet.
Open it to Exhibit 4.
They didn't read
just show
it yet.
you your own medical records to ask you if they are your medical records.
You said 4?
I'm sorry, number 2, I apologize.
Yes.
And if you look at the bottom right corner, in our exhibit book 2-001 through 2-023, all those pages, if you have a moment just to quickly look through and just confirm that those are in fact your medical records, correct? And you can take your time to use it.
Objection. Legal assistance for medical records.
We're waiting on it, y'all. We're waiting on it.
Yes.
He's just asking her to look at this right now.
We're waiting on the verdict, and we're waiting on Sugar Plum. Sugar Plum, where you at, Sugar Plum? Where you at?
Yes.
At the time of the incident, did Miss Ellis advise you she was making $13.50 an hour?
Yes, according to the report.
Okay. Is that something relevant? I mean, why would you put that in the report? Does it have to do with the lost wages, or why would that be in the report?
Objection. Compound. Foundation.
Like I said, it's been a while, and so from what I can remember, that information is usually included in all reports for clients who come in for workers' comp injuries.
And at that time, in 2018, you worked for Management Inc.?
Yes.
And what is Management Inc.?
It is a psychological treatment and evaluations for people.
I gotta get something to eat. I'm hungry. I ain't eat all day.
Have you always maintained a license of PsyD, or was it PhD at one point? Did it change, or it's always been the PsyD?
It has always been PsyD.
So you never went into like family, LA's MFT, or you don't have any of the other licenses? You went straight for this?
Yes.
Okay. And how long does it take to get this stuff licensed after undergraduate degree?
After undergraduate degree?
Yeah.
She looked like she's a little shy. This one, she looked like she's not used to this.
So in order to become a psychologist after high school, you spent approximately 10 years.
It's back, y'all. Get ready. It's back. Hold on, y'all. Hold on. Okay, they're back. Okay, the screen is up. They're not showing nothing yet. The screen is up. Okay, y'all, let's get ready. Oh, snap a doodle now. The verdict is in. They came up with that quick. Okay, shh. So they're not talking yet. They're not talking yet, y'all. They're not talking. Let me refresh it. Make sure I'm at the end. Hey, Mary Casino. Hey. Hello. Hey, Gloria. Okay, so we're waiting. The verdict is in. We're waiting. Okay, they haven't started talking yet. All right, so let's listen to her. Everybody, let's listen to they start talking. They're not talking yet. So the screen is up. They're showing the ceiling of the courtroom.
And what is the distinction between a PsyD and a PhD? Is there a difference?
report is CIDs are more clinically focused on psychological treatment versus PhDs can also provide clinical treatment, but they can also focus more on research.
Okay, and before today, it's probably been several years before you looked at your medical file, correct?
Yes.
And that's because you no longer work at Management Inc. You opened your own practice or work for a different practice, correct?
I work for a different employer.
And when you work for Managed Med, you were an employee for them?
Yes.
Now, if you look at the first page of your report, date of injury, it says 2/24/18. Do you know if that's accurate?
Objection, explanation, it's also there.
I'll represent to you that the date of incident is February 24, 2018. That's the date of the injury. And that's the date it says in your report, correct?
Question for counsel.
Okay, and then it says the date of your examination, April 26th.
Can the clerk only read the call to the question? For example, for number 1, did plaintiff Ammani Ellis prove all the following elements of battery, and yes or no, rather than reading the entirety?
That's fine with us, Your Honor.
Everybody hashtag verdict, hashtag verdict, hashtag verdict, y'all. Hashtag Cardi B,
Any particular
hashtag
reason?
verdict.
It's not going to change the answer.
Well, I feel like she verdict form was not the right type of form.
Yeah, we getting it right now. Okay, everybody, this is the Miss Knockout Show. We are waiting on the verdict live for the Cardi B trial. If you'll come in here tomorrow, we'll be going through the whole trial and going over it after the verdict to analyze the case. All right, but we are listening and waiting for the verdict right now in the Cardi B trial versus Ammani Ellis. Okay, so they went back to the ceiling again. They went back to the ceiling again. We're waiting on it. We're waiting on it. The jury had a question. Oh, okay. But he said it's not going to change the answer. It's not going to change the answer. Right? Thank you. Hey, Missy.
We're now joined by the members of our jury and alternate. And who is the foreperson? Do we have a foreperson? Number 3? And have you reached a verdict?
Yes.
Can you hand the verdict to the clerk, please?
We're about to see now, y'all. Everybody, this is the Miss Knock, because I want to clip this, so let's do a clip. Miss Knockout Show, the Miss Knockout Show is the Miss Knockout Show. Okay, let's listen. Here's the verdict, y'all.
Superior Court of the State of California for the County of Los Angeles, Ammani Ellis, plaintiff, versus Belcalis, Marlenes Almanzar, Cardi B, dose 1 through 50, inclusive defendant. Case number 20 STCV 07031. Verdict. We, the jury, in the above entitled case, answer the questions submitted to us as follows. Section A, assault and battery. Question 1. Did plaintiff Ammani Ellis prove all of the following elements of battery? 1. Defendant Belcalis Marlenes Almanzar, Miss Almanzar, touched Miss Ellis in the intent to harm or offend Miss Ellis. Number 2, Miss Ellis did not consent to being touched. Number 3, Miss Ellis was harmed or offended by Miss Almanzar's conduct. And 4, a reasonable person in Miss Ellis' situation would have been offended by the touching. Answer, no. Question 2, did Miss Ellis prove all of the following elements of assault? Number 1, Ms. Almanzar's acted with the intent to cause harmful or offensive contact with Ms. Ellis. Number 2, Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Number 3, Ms. Ellis did not consent to Ms. Almanzar's conduct. Number 4, Ms. Ellis was harmed. And number 5, Ms. Almanzar's conduct was a substantial factor in causing Ms. Ellis's harm. Answer, no.
Wow!
Section B, intentional infliction of emotional distress. Question 5. Did Ms. Ellis prove all of the following elements of intentional infliction of emotional distress? 1. Ms. Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. 2. Ms. Almanzar intended to cause Ms. Ellis emotional distress. Number 3, Ms. Ellis suffered severe emotional distress. And number 4, Ms. Almanzar's extreme and outrageous conduct was a substantial factor in causing Ms. Ellis to suffer severe emotional distress. Answer, no. Section C, negligence and contributory negligence. Number 8, did Ms. Ellis prove all of the following elements of negligence? Number 1, Ms. Almanzar was negligent. Number 2, Ms. Almanzar's negligence caused Ms. Ellis to suffer physical harm rather than only emotional distress. And 3, Ms. Almanzar's negligence was a substantial factor in causing Ms. Ellis's harm. Answer, no. Section D, punitive damages. Question 12. Did you answer question 4 and 7? Answer, no. Signed this date, September 2nd, 2025, by foreperson George Uloa, number 3.
All right, is it Mr. Chipoldry? All right, let me ask the foreman, was it unanimous as to all the questions?
Yes.
All right, so the question that the clerk is going to be asking is, was it unanimous as to all questions?
Question 1.
Or just all questions?
As to all questions?
Was it
Yes.
unanimous?
Was it unanimous?
Yes.
And you go through each of the jurors. Was it unanimous?
Was it unanimous, juror number 1? Yes. Number 2?
Yes.
Number 3?
Yes.
Number 4?
Yes.
Number 5?
Yes.
Number 6?
Yes.
Number 7?
Yes.
Number 8?
Yes.
Number 9?
Yes.
Number 10?
Yes.
11?
Yes.
And 12.
Yes.
All right, sounds like it was unanimous verdict as to all questions. Can the clerk please record the verdicts?
The verdict has been reported, Your Honor.
All right, thank you. Ladies and gentlemen, thank you for your time and dedication to this case. I know that you've paid a great deal of attention throughout the matter, which was especially evidenced by the questions that you did submit. I want to thank you for that time and attention on behalf of myself, the parties, the court system, as well as the people of California. As I indicated before, this system does not work unless people like you are able and willing to serve, and so I want to thank you once again. Throughout the trial, I have admonished you that you could not discuss the case with anyone, including other jurors, and at this point in time, I am relieving you from the admonition. You can speak with anyone about the case from this time forward. I suspect that there's going to be not only the parties that will want to speak with you, but I suspect also the members of the press are going to want to speak with you. And so I'm going to tell you this. I'm telling the members of the media this, and I'm telling the parties and their assistants that it's up to you whether or not you want to speak with anyone. If you don't want to speak with anyone, then you can just head right out the double doors, out the elevators. If there's press outside that want to speak with you, you can just walk past them. Don't let them stop you. If you do want to speak with them, then go ahead and you can wait outside the double doors. We're not going to be speaking with anyone in the courtroom. And if you do speak with someone, please be respectful of the views of any of your other jurors in terms of the deliberations. You can speak with respect to your point of view and how you...
At 500K, y'all. We almost at 500K. Ms. Knockout didn't even eat today. I didn't eat nothing. I drank coffee and water. That's it. I stayed with you all day. I didn't want to get off of it.
You saw the case. And the other admonition or the other issue with respect to speaking with people is that it's got to be at a reasonable time and place. And so if people start bothering you, or if people reach out to you that's inconvenient for you and they continue to do so, let me know and I'll take care of it, okay? All right. With that, once again, I want to thank you. You are now dismissed.
So what does that mean, y'all? That means that she got this much. This is how much she got. And how do we know that? Because the judge never read a amount. She got nada. So Sugar Plum, where are you at, Sugar Plum? Where are you? Sugar Plum. We want to talk to Sugar Plum. Sugar Plum? I don't know, Sugar Plum. You just skated off and they cut you. Yes, the first time reaching 500K sensitivity. First time reaching 500K again. Well, maybe it's the second time. Thank you so much. Okay, now listen. Everybody listen, okay? Do y'all want to come up? And anybody want to come up and say anything? Anybody got anything to say? Okay, let's see, Lisa. I'm going to make my food while I'm talking to y'all. All right? We're going to end it. We'll be back. Not here. Not here. Hold on, y'all. Hold on, Lisa. We're going to end this. We'll be back tomorrow. I will see y'all tomorrow. The verdict is 0 for Ammani. And Cardi B pays nothing. See you tomorrow.